Hey guys, got some. How you doing? Updates for Daniel Howard. Supposedly, actually, he's gonna the trial starting again today. From what it was disclosed, they apparently met over the weekend. The judge signed an order having him extradited back. I don't know how that works with the whole state issue. Generally, you have to like formally go through a process. But whatever happened, Daniel Howard is now back in Kootenai County, Idaho. So apparently they were going to start it today, but there's no law and crime or anybody covering it. Don't know the outcome yet. Do not know the outcome. So also Judge Gull is hearing the Richard Allen case, but it sounds like it got moved all the way to Allen County, Indiana. So waiting on all that to happen. So we shall see what happens, guys. We shall see what happens. I don't know yet. Other than that, we are going to get started day 9 with Daniel. We're going to get started with Daniel Howard day 9. Yeah, I heard might be a little low, so I fixed that. So, but here we go. So let's get this fired up and started here. If I had Corona, this would be like the 55th time I've had it, so I don't think it's Corona, guys. I'm just saying. All right, we got day 9 ready to go. All right. Turn it up. No captioning, of course, even though it's a couple days old. Oh, wow, 40 minutes of dead air. Worse than me.
This is new information from what I was considering yesterday.
Let's start him over so we can actually hear him.
All right, we're going back on record in the matter of State of Idaho versus Kendy Howard. We're starting a little bit late this morning because I've been in the chambers with counsel discussing some issues. I'm just going to make a brief record and then I'll let counsel put anything else on the record as they see fit. I was informed in chambers by Mr. Johnson that he has in fact spoken with Dr. Howard on more than one occasion. As recently as a couple weeks, sent Dr. Howard coroner's photos and asked if that would change his opinion. This is new information from what I was considering yesterday and what was relayed to the court yesterday. The state was understandably upset at not having been informed about this, and they're concerned about how Dr. Howard's opinion, what it may be, and their ability to cross-examine him based on this new information. I've indicated to counsel that I'm still not inclined to exclude Dr. Howard for largely the reasons I considered yesterday, though I think it is a little bit more concerning today. But nonetheless, I think the prejudice of the state in this circumstance does not outweigh the defendant's due process right to present his defense. In that, even with this new information, Mr. Johnson has indicated Dr. Howard's opinion does not change and is still the same as in his coroner's report, and that is all that Mr. Johnson is intending to elicit from him. And as I explained yesterday, given the state's knowledge of Dr. Howard's opinion throughout the entirety of this case, I don't think that the prejudice is great enough to warrant exclusion of the witness. I did indicate I would allow the state any remedy of needing additional time and so forth. The state took some time and has indicated they are prepared to proceed. I indicated yesterday I was considering a monetary sanction on council. I am going to impose a sanction on council for this lack of compliance. But I'm going to discuss that. I'll discuss that with council at the end of the case. But I am going to sanction conduct because I don't think it's appropriate, and I think it's somewhat strategic. I'm not saying Mr. Johnson's acting. I'll just say I think it warrants sanction, but I think maybe there was some misunderstanding of the application of the rule. I'm not sure. I'll leave it at that. Mr. Johnson, did you want to put anything else on the record regarding that or clarification?
Just on the record, Your Honor, when asked yesterday about experts from the defense standpoint, we were not considering, even though there was a CB, we were not considering Acevedo as an expert. She didn't offer an expert opinion. She was a fact witness, came out as a fact witness at trial. And so when asked about sharing expert opinions, that was my answer. In further complication or contemplation, that's why I brought to the court's and counsel's attention. That's all.
Thank you. Ms. Shostall, did you want to put anything else on the record?
Yes, Your Honor. As the court noted, the state did renew its objection and request that Dr. Howard be excluded. We do believe that there is prejudice to the state based on both the violation of Rule 16 as well as the sort of trickle of information that's been coming from defense as it relates to what Dr. Howard may or may not have been provided. The state likewise takes issue with the condescending approach to Chief Deputy Coroner Lynn Acevedo. She was noticed as an expert. She testified as an expert. Counsel objected to her opinions, which were overruled at times because she was well qualified as an expert. And so even now, counsel's disparaging comments are unnecessary. And I would just note for the record that she was so properly noticed and so testified. Thank you.
Thank you. All right, with that, we'll bring the jury in. Welcome back, members of the jury. I'm sorry to keep you waiting. We had some unforeseen procedural things that came up that I had to work through. The council. It took a while. I know you were all here ready to go at that time, so I do appreciate the patience. Okay.
So, guys, that ultimately looks like there because they discussed things with the defense attorney more. And he said, well, Judge, I spoke with the guy a couple of times, and, you know, I had actually exchanged information with him and stuff, and had him go through some of his documents in preparation. So the judge is like, yeah, now it's really clear you're gaming the system and fucking around. So he is going to give him a monetary contempt. Who knows what it'll be. He's going to wait for that till afterwards. And I think part of the reason why he's waiting till afterwards is to avoid any appealable issue, because technically that's an appealable thing, saying, oh, the judge became biased because he held me in contempt. So that'll happen after the trial is over, but the judge is just putting it on the record. Yeah, and it does sound like he played a little bit of fuck games with the stuff, and that's not how you should do that. If you could avoid it, you really need to avoid that, because it just doesn't help anybody. So, anyway, yeah, here we go. Day 9.
We are back on record. We'll continue. Mr. Johnson, next witness.
Thank you. And, Your Honor, can Madam Clerk let me into the Zoom when she gets a chance? We call Roy Fitting.
Remember, this is the defense's case now. The state is rested.
Morning, sir. Step forward, please. On your face, my clerk, raise your right hand and be sworn in.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. If you have a secret witness stand. And as best you can, I'll ask you to talk to the mic.
Okay.
You may inquire.
Good morning. Can you please state your name and spell your last name for the record?
Roy J. Fitting, Fitting,
And where do you live?
here in Coeur d'Alene.
Did you know someone by the name of Kendy Howard?
Yes,
How long did you know her?
since childhood, not on a personal level, but smaller communities, everybody kind of knows everybody.
Around January 31st of 2021, did you have Facebook communications with her?
Yes,
And did those conversations, did she express, well, let me approach her.
You may.
I handed you what's been marked as Defense Exhibit F.
pardon me.
I've handed you what's been marked as Defense Exhibit F. Do you recognize those messages?
It's been 3 years, so yeah, I haven't had time to go over it. I know you offered this, but
Okay. You had conversations regarding, if you can go through that.
okay.
Does that seem like an accurate conversation?
Sure.
Move to admit Defense F, you know?
Any objection?
Yes, Your Honor, I object on the basis of foundation, and I object to the redactions that have been made by counsel in this exhibit.
Your Honor, every exhibit the state offered with messages has been, they don't submit all the messages, for instance, from Ken Myers, Michelle, or anyone else. That's why, for instance, Ken Myers,
Well, hang on. Let's not get too much. So, the objection, the first one's foundation. So, what was the foundational aspect of it?
Judge, the witness indicated that he has not reviewed this before some time, and just reviewed it now, what counsel handed to him, and judge, based on the state's knowledge as to what's in that conversation, this witness cannot testify this is an accurate conversation because it's in fact not an accurate conversation.
I mean, probably need to see the exhibit and talk to counsel more. I hate to do this. I just got here, but I'm sorry. It's just very briefly. I'll rest very briefly. Yes.
Judge, for the I which was the state's version of this conversation. And I would note that the state's version of this conversation does have a singular redaction made to it in conformance with court rules and prior motions of limiting. That redaction is noted as a blank space in the conversation. It has not been edited to remove that blank space.
All right, and so if I'm understanding correctly, it's not that this is cut and pasted in terms of, it's not redacted throughout, it's not the entire conversation.
Yes, Your Honor, and, correct, Your Honor.
So
And
the state's point out there's more preceding it and more following it, is that right?
No, Judge, there's messages in the middle that have been removed.
no, there's not.
It doesn't look like any, just my quick review of it, it doesn't look like anything's been removed, it's just, this is a portion of the conversation, the state's saying equal to. So,
Do we have just a few minutes to double check that, Your Honor?
sure. You-
Yes, Judge, I would agree that that portion is accurate.
I have no objection to admitting the state's version.
Well, here's what, my ruling is going to be, you're welcome to, I'll allow you to admit Exhibit F, but the state is certainly within their rights on cross to admit the rest of the conversation.
Absolutely.
That's fair,
Sure.
so. Okay. All right, I'll get these back to you, and will you give a shot first back?
Do we really need excuses?
Let's go get your back.
Did the jury really needed to get excused for that?
Sir, just give the jury to obviously.
Sorry.
Can you see this? All right, I've overruled the foundation objection. Defendant's Exhibit F is admitted.
Can we strike that, Your Honor? I'm gonna,
So you're not going to present Exhibit F?
no, Your Honor.
Yeah, Judge Lynn.
You may.
Mr. Fitting, that's the same conversation, but a little more to it and a little different format. Do you see that?
Yep.
Okay. It's defense exhibit G. We would move to omit defense exhibit G.
Any objection?
No objection, Your Honor, just for the record, that exhibit was originally marked with the plaintiff's sticker. Mr. Johnson's not utilizing it, but we would ask it be admitted under defense's notation.
Is that, when I looked at the state's 57?
Yes, sir.
We're calling it defendant Exhibit G?
Yes, sir.
Okay. That is admitted.
I have no further questions, may, retreat to.
You may. Cross-examination.
Move publish defense G.
That exhibit, defense G is published.
acquaintance than a close? Were you and Kendy Howard close?
No,
Was she more of a long-time acquaintance than a close friend?
yes,
That have you not seen her much in the however many years?
I hadn't seen her for 30 years, actually probably 35, 40 years. And I ran into her and her family while I was down steelhead fishing. Said hi to her. She sent me a request on Facebook to friend her, so I did, and we just kind of picked up and started having casual conversation like anybody would.
How far before this conversation was that run-in fishing?
It's like 3 weeks.
Thank you. No other questions.
Can you redirect Mr. Johnson?
Thank you, Your Honor. Thank you.
Thank you, Mr. Kitty. You're welcome to sit. The next witness?
Dr. John Howard.
Morning, sir.
Good morning.
Step forward, please. I'll have you face my clerk and raise your right hand, please.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may sit down. As best you can, please take the microphone. You may inquire, Mr. Johnson.
Good morning, Doctor.
Good morning.
Can you please state your name and spell your last name for the record?
My name is John Dale Howard, Howard.
Any relation to Mr. Daniel Howard?
No.
Where do you live?
Boise, Idaho.
What did you do for work?
I'm currently retired. I was previously a forensic pathologist and medical examiner.
Can you, where did you do that?
Well, after completing my formal medical training, I was the assistant medical examiner for Pierce County in Tacoma, Washington. I then took a position in Tucson, Arizona with the Pima County Medical Examiner's Office. I was also on faculty of the University of Arizona College of Medicine. I was then asked to take a position as the Chief Deputy Coroner, Director of Forensic Pathology, and Director of the Forensic Pathology Fellowship Training Program for Hamilton County in Cincinnati, Ohio. I also served on the faculty of the University of Cincinnati College of Medicine. I was then asked to return to Tacoma as the Chief Medical Examiner, which I served as in Pierce County, Tacoma, Washington for a decade before coming to this side of the mountains to join a medical school classmate in the Spokane County Medical Examiners as a forensic pathologist and medical examiner.
Can you take us through your educational background?
Excuse me?
Can you take us through your educational background?
Certainly. I have a bachelor's degree in chemistry from Central Washington University. I attended the University of Washington School of Medicine in Seattle, graduating in 1982 with the medical doctor MD degree. I stayed on with the University of Washington as affiliated hospitals, clinics, and training programs for a year of general surgery residency training, 3 years of anatomic pathology training, and 2 years of fellowship training in forensic pathology with the University of Washington and the King County Medical Examiner's Office in Seattle.
Have you had any publications?
Yes.
Can you give a little bit of what you've published?
I published in peer-reviewed journals on a variety of subjects related to forensic medicine and forensic pathology.
Have you testified since retiring?
Yes.
Can you briefly explain the circumstances?
I've been asked 7 times to come out of retirement and testify in homicide trials. I was called by the prosecutor. I performed the autopsy and was asked, because I performed the autopsy, to testify, and I agreed to do so and did so.
Is this your 8th time testifying since retiring then?
This will be the 8th time.
Any prior testimony or experience with intraoral gunshot wounds?
Gunshot wounds of the face and mouth, I certainly have encountered those at autopsy numerous times and testified more than once.
Have you ever testified for the state of Idaho for a homicide?
Yes.
Now, is it common in your experience as a medical examiner to be called by defense?
Well, sometimes you're called first by the prosecution when they're put on their case, and once in a long while, usually the defense covers everything in their cross-examination. Once in a long while, they may recall that witness during their presentation of the case, and that's happened a few times, but only a few out of the more than 900 times I've testified.
Okay. Is there a process of involvement between law enforcement and the state and the medical examiner's office?
Well, medical examiners have jurisdiction over sudden, unnatural, unexpected, unexplained deaths. Same as a coroner, medical examiners just have a medical training and medical degree. In this case, this was a coroner case, a Kootenai County coroner case. Spokane County and Kootenai County have long had a inter-county arrangement where the coroner can refer cases into autopsy to Spokane, where those autopsies are performed by a forensic pathologist. Spokane County does that for a number of Panhandle counties and a number of eastern Washington counties.
Did you, well, can you explain the general process of an autopsy?
Certainly. The term autopsy literally means to see for oneself. It's for the pathologist to examine the body of the deceased to help determine who they are, when and where events happened and processes happened that led to their death, to help determine whether they have any natural disease, any developmental abnormalities, any kind of injury, to help formulate cause of death opinions or identify the cause of death, and develop information that helps understand the circumstances in which or the manner in which the death occurred.
What happens after an autopsy is complete?
Well, during the autopsy, there are documentations made. Radiographs or x-rays are taken. Photographs are taken at various stages during the autopsy procedure. Samples are collected to submit for toxicology testing. Then some samples, biopsy tissue samples, are placed into fixative, a formaldehyde water mixture to be held. Portions of tissues are processed into a glass slide that can be examined under a microscope. Once the examination is completed in all those samples, as well as trace evidence like hair samples, swabs, fingernail trimmings, once that's all been processed in the autopsy suite, the body is released to a funeral home.
Now, is the performance of, did you perform an autopsy on Miss Kendy Howard?
I did.
And when was that?
That was February 3rd of the year 2021.
Was law enforcement present for that autopsy?
I believe the autopsy suite has observation rooms where law enforcement can observe through the window, yes.
Are photos taken at the time of the autopsy?
Yes, at various stages from the very start and subsequent multiple stages after the start.
May I approach Madam Clerk, Your Honor? Does law enforcement give you any information prior to conducting an autopsy?
Well, this was a coroner case, so the coroner entered the case information into the computer system at the medical examiner's office, and that would certainly, since they were at the scene and working with law enforcement, include some of that information.
What is an external examination?
External examination means at the start of the autopsy, the body in a sealed body bag is on a cart wheeled into the autopsy suite. The tag is looked at to ensure that it hasn't been broken. It is then broken and the body bag's open, and the external examination, meaning just looking at the outer surface of the body, begins.
Is it important to do an external examination before an autopsy?
Well, it's at the very start before you alter the body in any way by making any surgical type incisions, yes.
Okay. Now, did you... May I approach the witness, John?
Okay.
And Doctor, you said photos were taken, were photos taken at the autopsy?
Yes, either by myself or by the two autopsy assistants working with me under my direction.
Okay, so I'm going to run through a series of photos, and you can just tell me if you recognize them. This is 28.
All right?
This is 20M.
Yes?
This is 20M zoom.
Yes.
This is 20R.
Yes.
This is 20W.
Yes.
And this is 20W zoom.
Yes. Right?
Do you recognize these?
Yes, they were photographs taken at the time of the autopsy.
All right, Doctor, these have been admitted into evidence already. Is one of the things you look for is rigor?
Yes, the postmortem changes. Rigor mortis is a stiffening of the muscles due to chemical changes occurring after death. So that is one of the things that you assess. It relates in general to how long the person's been dead.
And was rigor present in Ms. Howard?
Yes.
Now, What is lividity?
Lividity is the pooling of blood inside intact blood vessels after death under the force of gravity. So whatever position the body is in, when the heart stops, circulation stops, blood, which is a mixture of cells and fluid, behave like a fluid, and like any fluid, under gravity, seek to the lowest spot. Now, it will then show up as vascular congestion, which looks like a purple discoloration of the skin. It will not form where there's pressure, so like the buttocks, if someone's...
Narrative at this point, Judge?
You still explain to her.
Overall, please continue to explain what lividity is. You may continue.
So it doesn't tend to form where there's pressure, but whatever part is dependent, meaning the lowest by gravity, it will start to show up. Now, it's not necessarily fixed in the first hours or even necessarily the first day of death, after death, so it can shift if the body moves. But it's just a post-mortem appearance of discoloration of skin from blood vessels, pooling of blood under gravity.
Was there blood present when you removed Miss Howard from the bag, the sealed bag?
Yes, blood was pooled in the body bag and was on the body surface.
Showing you 20A.
Is this, can you have the lights on? Can you see that photo?
If you need to step out into the well here.
Thank you, Your Honor.
you want to.
I have seen the photo.
And can you see the hair there?
Yes.
And can you describe what you observed and what's shown in that photo?
The hair is wet and blood present throughout the scalp hair.
Now, in the, you do examine the head and neck?
Yes.
Okay. What is petechiae?
Petechiae are pinpoint hemorrhages that can be seen after death or even in a live patient when there's vascular compromise, meaning blood vessels, the veins are collapsed in an area, but there's still arterial pressure going to that area. The circulation of blood stops because of the occlusion of the veins, and small blood vessels rupture, producing a pinpoint hemorrhage. This is most commonly seen in strangulations where compression is put on the neck such that the veins of the neck are compressed and occluded. Blood cannot return back to the heart, but there's still arterial pressure to the head. At every point above where that pressure is applied, occluding the veins, are at risk of having those pinpoint hemorrhages seen. Most easily seen in the whites of the eyes because of the translucent tissue. If you look in your own eye, you can see blood vessels. That's where it's most commonly seen, but can be seen anywhere in the face, the neck, or in the oral mucosa. In other cases of same...
Object to narrative.
Overall.
Similar cases where, say, someone's working in a trench, and the trench collapses, their head and neck are above, and there's pressure on the chest, you may see petechiae all above that level. The other classic case is the backyard mechanic who jacks up his car, gets underneath, the jack fails, it comes down, it doesn't crush your chest.
Objection, non-responsive and narrative.
Overall, non-responsive, but this is getting into narrative. This is quite far afield of your initial question, so I'll ask you to direct the testimony. Sustained.
Did you observe any petechiae in Miss Howard?
No.
Were there any lines or markings going around her body?
Yes.
Can you describe that?
When the body is subjected to being submerged in water, at least partly, you can see where there's relative hydration of the skin, water markings, and there were lines of skin discoloration indicating where the water line was, with above that, no contact with water, below that there was submersion in water of the skin.
And you could see those, where in her body or on her body could you see those lines?
Well, there are a number of them, mostly most readily visible on the trunk.
Okay. Were they also on the legs?
Yes.
Now, did you observe any abrasions?
Yes.
Where was that?
There was an abrasion on the posterior or back of her left thumb.
Showing you what's been admitted as 20W. Is this a picture of the abrasion?
Yes, this is a photograph taken at the time of autopsy of her left thumb, if I may.
Sure.
I can point out the abrasion. So her thumbnail's here, the back of the thumb, the abrasion is here, as I'm indicating with my finger.
Now, is there a difference between an abrasion and a laceration?
Well, abrasion is just the surface of the skin being broken. A laceration is a tear of the skin, but it would be deeper.
Now, did you find any evidence of a gunshot wound?
I did.
What were your observations?
Well, first of all, bullet fragments were visible in the x-rays taken prior, at just the period before the autopsy, and were reviewed. And then direct examination externally of the mouth showed bruising of her lips, blood present inside the oral cavity. And then, as a part of the autopsy, internal dissections are made. The chest, abdomen, head, and neck, and the neck structures are looked at in place, and then are dissected and removed and further examined. There was gunshot wound with damage passing through her tongue. The bullet had gone posteriorly or backward, causing gaping defect in the back of her throat, the pharynx, and then the bullet had broken in pieces, but the main portion had gone through her spinal column, the cervical spine, and transected the spinal cord. The bullet fragments had stayed in the body and then were able to be seen and recovered by the dissection of the neck from the front and dissection of the neck from the back. There was hemorrhage in the tissues surrounding and blood that was pooled in the throat, the mouth, and the nasal passages around the tongue and pharyngeal or throat defects.
Was there any fouling?
Yes.
What is fouling?
Fouling is the soot deposits from a firearm. And when a firearm is discharged, the cartridge contains primer residue. The firing pin hits the cartridge, that residue ignites the gunpowder. The gunpowder burns very rapidly but not completely. The hot expanding gas propels the bullet out of the cartridge, down the barrel, and out of the muzzle.
I'm going to object at this point, lack of foundation for this answer beyond scope of expertise.
Response?
Your Honor, he's testified in thousands of homicide cases, a lot of them dealing with gunshots. I think there's adequate foundation based on strength experience on this.
Why don't you pass it on for the foundation?
Are you familiar with the operation of firearms?
Yes, that was part of my training during my forensic pathology fellowship, including test firing of weapons, and I've worked with firearms examiners in multiple agencies, also test firing weapons.
Permission to continue.
Okay.
Can you continue to explain what fouling?
So fouling is the soot or smoke that comes out of the muzzle of the weapon along with the bullet, and if the muzzle is close enough to the skin or the inside of the mouth in this case, it deposits on the tissue and shows a dark discoloration. You can actually see the gunshot residue with the naked eye and confirm it under the microscope.
You mentioned there was damage to the tongue.
Yes,
Now, it may seem like a simple question, but is the tongue a muscle?
yes.
What happens to muscles when a person passes?
They relax and just stay in whatever position unless external forces or gravity changes it.
Was there anything significant about your examination of the tongue?
Well, I saw the bruising of the lips. There was a fracture of her mandible. When you have a bullet passes through tissue, there's kinetic energy converted to mechanical and hydrostatic.
Responsive.
It's not typically your objection, but I will sustain that. That's not responsive to the question that you asked.
What was significant about anything? What was the damage to the tongue?
The bullet had passed through the tongue, tearing the tissue apart.
Was it from the tip or top, bottom? What part?
It passed from near the front towards the back.
Now, you did a neck dissection in this case,
Yes,
and that was from the rear?
front and rear.
Okay. When you do a neck dissection from the rear, what do you have to do?
First, you turn the body over so it's initially in a supine or resting on its back, place it in a prone position, cleanse the body so that you can do a thorough external examination of the head and neck, and then proceed with surgical incisions in the back of the neck.
While a person is, while a body is on, rolled over, what happens with the blood?
Well, any blood that's in the nose and mouth will purge out, and in terms of blood that's still in the blood vessels, under gravity will start to shift towards the front of the body from the back.
Did you examine the head?
Yes.
What does that entail?
First, you carefully examine and palpate the scalp. Then a scalpel is used to make an incision, as I'm indicating on my head, across the scalp, above the ears. The scalp is then reflected forward and backward so that the deep layers of the scalp can be directly examined. You cut through the tissue to do that. Then the outer surface of the skull can be directly examined.
Showing you what's been admitted as 20M. It's admitted. Do you see this photo?
Yes.
And does that cause pressure, or what are you looking for when you do that? Why do you do that in a case like this?
So the deep layers of the scalp, the muscles that are applied to the head, and the skull surface itself can be directly seen and therefore directly examined.
Okay. You see these two marks at the bottom there?
Objection beyond the scope of the court's prior rulings.
It's explained as autopsy.
Counsel is about to ask for an opinion on something that is not contained in Dr. Howard's original report.
There you are. Maybe approach.
Yeah.
Getting a little feisty. Getting a little feisty, guys. The state is getting a little upset. State's not scared. It's just if he's not qualified as a witness, he shouldn't be allowed to talk about it. That's the thing. If he does this, he's now getting in his witness testimony.
The court.
All right, and Mr. Johnson, well, you can make your objection, Michelle Stone.
Thank you, Your Honor. So the question that the state anticipated, and in conferring with Mr. Johnson at the bench, seems to be an accurate prediction. Mr. Johnson is now going to be showing Dr. Howard things that were not noted by Dr. Howard in his autopsy report and asking for his opinion as to what those are. That is new information. That is new opinions. Those are the types of questions that would have been discovered in an expert report. The entire containment that was articulated by this court was that Dr. Howard was going to testify to the opinions contained within this report. One of those opinions is cause of death. However, he is here testifying as a medical expert and being asked medical expert opinions such as, what is this? Is this part of the autopsy or is this some kind of blunt force trauma? He's going to be asked, is this a contusion or is this lividity? If those are not specifically articulated in the report, then they are new opinions, Judge.
Mr. Johnson?
Thank you, Your Honor. I do not plan on asking him about any contusions, if it's a contusion or not. The lividity, I was not going to ask him specific photos, if they're lividity or not. What I was simply wanting him to do, which he does have in his opinion, that transection, or the examination of the head and neck, and I was asking him what those are. That's, if the court wants, I can move on, but.
What did you anticipate the answer to be?
Anticipate the answer that is not, that is the normal process of peeling back the scalp and part of the incisions that would be made or hemorrhages that would be obtained at that time. I'm not asking of him anything about contusions. Those are in his report. I'm assuming if I did ask him, he would be consistent with his report.
Dr. Howard, just so I understand, what would your answer have been?
What the photograph shows is the undersurface of the scalp where it's been sharply dissected. There's some very small amounts of bleeding from a cut vessel. It's typical of what is seen at every autopsy. It's a postmortem leakage of blood because the blood vessels that were intact previously are cut in order to reflect the scalp.
And this is the only one I was going to ask about.
Judge, the only reason to ask that question is to impeach Dr. Smock, who testified that he would indicate that those are the result of blunt force trauma. That is a new opinion, Judge.
All right.
He's going to have to make a decision on that. Hi to Baker and everybody else joining us this afternoon. He's not really sure. He's trying to make a decision here.
This is part of the difficulty that comes from not disclosing his witness as an expert, the basis of his opinions and so forth. I indicated, exercised my discretion in whether or not to allow the witness that I would, consistent with his report. I'm just noting
No, he's not.
I'm fine with you asking him if he observed injuries to the scalp or head, because that's within his report. What I'm going to limit, which I think is fair, is the attempt to impeach other witnesses' testimony of these photos with his testimony, which goes beyond his report. So I'll let you ask if he observed signs of injury to the scalp or head. That's fine, because that's within his report. And certainly this is all within his expertise. But using it to impeach other witnesses, going into specifics beyond his report, I will limit that given the surprise to the state and your failure to disclose that previously. In exercising my discretion, I do think that those aspects, as we talked about, going beyond his report, I do think is prejudicial to the state, and they're not able necessarily to meet that. But on the whole, I'm certainly kind of allowed you to present Dr. Howard his testimony consistent with his autopsy. So, fine. Let's take about 5 minutes, 10 minutes, maybe 5 to 10 minutes for our morning break.
All rise.
All right, guys, real quick. So what happened there? Well, so this is the case of Daniel Howard. He's accused of murdering his wife. They were in the middle of getting ready to have a very bitter divorce, and he didn't want to give up all his assets. So the allegation is, based on his prior training as a police officer, he was almost a 20-year police officer before he got fired for stealing. He is alleged to have killed her using basically a sleeper hold. And by putting her in the sleeper hold, he knocked her out and then put her in a bathtub and stuck a gun in her mouth and pulled the trigger and staged a suicide. So that's the state's theory, because some of it doesn't add up the way she appeared and the way they found her. What happened here is the first coroner basically was a guy about to retire and didn't really give a shit. Didn't do his job properly, didn't do anything right. So he kind of phoned it in and kind of messed up the autopsy. Didn't do a very good job. So they ended up this is back when it happened initially, 2021. This guy didn't get indicted until 2023, so they had to send it to another coroner. Well, the defense is calling the original coroner. Brittany's saying, the initial issue here is this defense is playing games with how you disclose your witnesses. And they're trying to use the coroner as an expert witness. But they're doing that by calling him as a regular witness. And now he's asking techniques and questions that go into the coroner's competency and experience, which makes him now an expert. Because the defense tried to play games with this and game the issue, the court has already said he's going to sanction him with some sort of monetary fine. So that's why you heard all this going on initially. The judge said, because you played all these games, I am not going to allow this in. You can ask him what he saw, but he can't comment on anything else because that would require an expert opinion. So that's where they are with it. And yes, basically they got caught playing games. So more or less that's what the judge just said there. Let's catch up and keep moving.
You may continue, Mr. Johnson. Commissioner Tree, yeah.
There is also a description down below if you guys need to catch
So, Doctor, you examined the head.
Yes.
Did you observe any or document any injuries to the head?
The gunshot wound to the head and the alterations related to it, such as the fracture of the mandible and the bruising of the lips and the internal injury. I did not find any other head injury.
Okay. What is a histology section?
Histology means the study of tissues. It usually refers to examination of tissues under a microscope.
And what are you looking for when you're looking at a histology section?
Well, like the autopsy in general, the microscopic exam, you're looking for any sign of abnormal development, any indication of natural disease, and any type of injury.
Were those done in this case?
They were done in this case, yes.
Did you, were there any histology findings or things that you noticed?
Yes.
And what were they?
Examination of tissue from the tongue showed tissue disruption, hemorrhage, and gunshot residue present. The examination microscopically of tissue from the spinal cord also showed tissue disruption and hemorrhage.
Now, in autopsies in general, are there times where you'll keep specimens?
Yes, routinely samples are collected, or biopsy specimens that are processed into the glass slides for microscopy. Other representative samples of places of injury and the major organs and structures are also retained in formalin, which is formaldehyde in 1.
In Ms. Howard's case, was there a particular area of injury that was maintained as a specimen?
As I recall, the tongue was handled in that manner.
What happens when you remove, say, the tongue? How does it get from there to formaldehyde?
Well, it's taken out onto the dissecting table part of the autopsy.
Your Honor, this is once again beyond the scope.
Overruled.
You may continue.
Okay.
So it's been removed by dissection from the body, examined on the dissecting table, samples collected for microscopy, and it's rinsed, examined again, and then placed with the other tissues in fixative.
And fixative being the formaldehyde?
Yes.
Did you conduct toxicology in this case?
Well, samples were obtained from autopsy for the purpose of toxicology testing. They were submitted to a laboratory who did the testing.
Did you, on the histology specimens, did you notice any damage to the spinal cord?
Yes.
You said the autopsy was conducted on February 3rd?
Yes.
Do you know what time?
Well, it started at, I recorded the start at 11:39 hours. It took several hours to perform.
Did you do a report that day?
Well, I dictated my findings on the day of the autopsy. That's transcribed in the report, and then additional information such as the toxicology and the microscopic findings are then placed into the report. The report is then proofread and finalized and signed on the day after the autopsy. Several days. In this case, it was I believe, February 16th when I signed the autopsy report.
Any law enforcement involvement prior to finalizing the report?
Not that I recall.
Did you have any findings from your autopsy?
Yes.
And what were they?
As part of the autopsy report, there's a page which has basically the findings or basic conclusions of what was observed. And that was twofold in this case. One is the intraoral gunshot wound of the head and neck with transection of the spinal cord. And that there's a notation about the toxicology finding caffeine, but no drugs or alcohol detected. And then the next section of the autopsy report is an opinion section.
Was there any other than the, well, let me qualify, there was damage to the tongue, correct?
Yes.
And that would cause some bleeding?
Objection, reform the question.
It is bleeding, so I'll ask you to rephrase the question.
Would there be bleeding with a injury to the tongue like that?
Yes, the bullet had perforated the tongue, and so there was autopsy evidence of hemorrhage or bleeding into the tissues and out of the open wound.
Was there bleeding in other areas?
Well, the bleeding extended from where the bullet passed through into the muscle of the tongue all the way down to the upper neck.
I'm showing you again what's marked as 20A. Is that blood, where, is that blood part of that injury that you just mentioned to the tongue and the neck?
The source of the blood that's visible on the exterior of the body, the outside, the only two sources are the perforation of the tongue and the wound in the back of the throat. Those are the open wounds that allow bleeding to occur into the oral cavity and then spill out of the nose and mouth.
Was there any blood found in the stomach?
No.
Is that the amount of blood that you see or saw, is that
Objection to the question is beyond scope.
I'll actually ask you to approach. That's the one first time. You do this.
I think the state's working way too hard here at this. He can comment on that. I don't see why they're stopping him, but yeah, here we go.
All right, the question wasn't quite finished. I sustain objection
I'll rephrase it.
and ask you to rephrase.
Was the amount of blood that you observed consistent with an intraoral gunshot wound?
Yes.
Did you reach a opinion or conclusion in this matter?
I did.
And what was that?
We are asked as a part of this process from the coroner in providing autopsy services as a forensic pathologist to render an opinion as to the cause of death and the specific natures of the wound. And I did so in this case.
Were you subpoenaed in this case?
What's that?
Objection, relevance?
Sustain.
No further question.
Cross-examination.
Your Honor. Good morning.
Good morning.
Can I ask Mr. Johnson to turn off his... Thank you. Dr. Howard, you indicated that you performed this autopsy on February 3rd around 11:30 in the morning. Is that correct?
That's when it started, correct.
And you were made aware at the time of your autopsy that the date of pronouncement was February 2nd, the day before, correct?
Correct.
Were you made aware of the time of pronouncement?
Not that I recall. It may have been in the records entered by the coroner. I don't recall the time.
Were you aware that it had been less than 12 hours since you'd been pronounced dead?
You said I don't recall. It would not surprise me.
And Kendy's body arrived at your facility, which is in Spokane, correct?
Yes.
Were you made aware of where the body had traveled from?
It was probably in the coroner's record. I don't recall.
But you knew that it was a Kootenai County case, so it at least had come from this side of the line?
Yes.
And the body would have been transported by coroners of Kootenai County, is that correct?
Coroner or transport service, correct.
Isn't it common during transport for bodies that may have large injuries to leak blood?
Yes.
Wouldn't it be common for a body that had been submerged in water to have some moisture to it?
That would be expected, yes.
So would it be fair to say that some of that blood that is seen in the body bag has leaked from the large hole in her mouth?
Yes, that would be the source of the blood.
When you performed this autopsy on February 3rd at 11:39, you indicated that there was someone present from the Kootenai County Sheriff's Office. Do you recall that?
There would be a written record of who was in the observation room, correct.
But you don't recall interacting with the Kootenai County Sheriff?
I may have spoken to them before and after, but not actually during the process of performing the autopsy.
And that person wasn't one of the lead detectives, was it?
I don't recall.
And the purpose of that person being there was simply to collect items of evidentiary value that you may locate during the autopsy, such as the bullet.
That's certainly one of their roles, and I believe we have a medical examiner record to indicate the transfer of the items collected at autopsy to the officer.
Now, if you recall, the Spokane County Medical Examiner's Office got a new building right around this time. Do you recall that?
Prior to the autopsy.
Okay, that was going to be my next question. Was this autopsy performed in your new facility?
Yes.
And so in this new facility, isn't it correct that law enforcement would not actually interact with you during the autopsy? They would be in a separate observation room, correct?
Well, they had the option of communicating through intercom, but they would not be at the autopsy table.
You indicated with Mr. Johnson that you performed this autopsy with a couple of assistants, correct?
Yes.
And either you or your assistants had a camera to take photographs, correct?
I'm sorry, could you repeat that?
Sure. Either you or your assistants had a camera to take photographs.
Digital camera, correct.
And typically, since you were the one doing the autopsy, it would be your assistants who would take photographs,
Yes,
but they would take photographs at your direction, correct?
correct. We would have standard protocols, and then I would point out things that I requested in addition, or I would take photographs myself.
So there were, in fact, standard protocols for the photographs that you would take, correct?
Yes, it's posted, at least at the time, it was posted in the autopsy suite.
And so standard procedure would probably include taking photographs of both sides of the body, correct?
Yes,
You began your autopsy with an overall review of the body, correct?
yes,
But before you do that, isn't the body washed in preparation, or at least cleaned to some degree prior to you beginning?
no,
Okay. Do you perform any kind of cleaning or washing during the process?
yes,
Do you photograph the body after washing or cleaning?
yes,
In your report, as you were documenting that external review, you noted that there was lividity present, correct?
yes.
You indicated that lividity was faint, correct?
Was what?
Faint is the word that you used?
If I could,
When looking at your report, refresh your recollection?
may I, Your Honor?
Yes. And may I direct the witness so we can maybe find a little faster? Dr. Howard, I'm directing you to page 3, the last paragraph.
Yes. So on page 3 of the autopsy report, it's the last paragraph under the heading of, main heading of
Dr.
extra.
Howard, I'm going to ask you not to testify from your report. Use it to refresh your recollection.
Objection, I thought that's what counsel just asked me to do.
No, refresh my recollection, because you can look at your report, and if it refreshes your memory, then you can ask the question from your memory, if that makes sense.
All right, if I understand your question is, did I describe it as faint?
Yes.
The answer is yes.
You indicated that it was also primarily located on the posterior regions of the body, correct?
Yes, that's correct.
And that, for those of us lay people, that would be the backside, correct?
Correct.
And again, were you aware at that time that Kendy Howard had been located lying on her back?
Well, she was on her back at autopsy and had been transported on her back from the scene to the medical examiner's office.
You unzipped the body bag as you previously indicated, and when you did so, you noted that Kendy Howard's hands had been bagged to preserve evidence.
I believe so, yes.
At that time, you removed those bags and immediately examined her hands. Do you recall that?
Yes,
You noted that there was no soot on her hands. Do you recall
Correct.
that?
yes,
You then make an external examination of the body, correct?
yes,
You noted 2 specific areas of skin slippage. Do you recall that?
yes,
Those would be on the right forearm and the heel of the left foot, correct?
that's correct.
You then noted a series of contusions to the body. Do you recall that?
I do.
Now, a contusion would also be called a bruise, right?
That's correct.
A bruise is the result of blunt force trauma, correct?
Blunt force injury causing a blood vessel to break and hemorrhage in the surrounding tissue so that there's a discoloration that can be seen, a bruise, more medical term, contusion.
Now, you would agree that a bruise is something that is sustained during life, correct?
Yes,
And as opposed to lividity, which shows up after death.
correct.
And you would also agree that a bruise can be sustained in life but show up after death, correct?
It can, certainly the hemorrhage under gravity or as it spreads even after death may become closer to the surface and there be more visible.
You would agree that it is even at times a tool of pathologists to take a body and cool it and look at it later to see the bruises more clearly.
That's possible, yes.
Have you done that in your own cases?
Occasionally, particularly in suspected child abuse cases.
Now, in your documentation of the contusions to Kendy Howard's body, you noted a 4-centimeter contusion to her right breast, correct?
Yes,
You noted 10 contusions to the right arm and the right elbow area, ranging in size from 1 centimeter to 5 centimeters.
correct.
You noted 12 contusions on the right thigh, ranging from 0.5 centimeter to 11 centimeters.
Yes,
You noted a contusion on the anterior aspect of the left arm that was about 0.5 centimeter in size, correct?
correct.
You noted 2 contusions on her left forearm near the elbow, approximately, again, 0.5 centimeter to 1.5 centimeters, correct?
Yes,
You noted 5 contusions to the left thigh, and again, these were approximately 0.5 centimeter to 4.5 centimeters in size, correct?
yes,
You noted in your description of the damage to the head, contusions to the upper lip extending from 1 centimeter to the right of midline to 2.5 centimeters to the left of midline, correct?
yes,
You noted no fouling on the outer surfaces of the lips or the skin, correct?
correct.
In fact, the only fouling that was present was located on the tongue inside the mouth, correct?
That's correct.
In fact, the only soot that you noted was located on the tongue inside the mouth, correct?
Correct.
You concluded, based on that the gun had been placed inside the mouth, correct?
At the time of discharge, correct.
You noted that there was no damage to the upper or lower teeth in the mouth, correct?
I did not find it, that's correct.
You noted that there was no blood in her lungs, correct?
Correct,
You noted that there was no blood in her stomach, correct?
correct.
And you noted that there were no substances in her system other than caffeine, correct?
That's what the toxicology results were.
Now, Dr. Howard, Mr. Johnson asked you some questions about the tongue and about it being a muscle, right? Do you remember that?
Yes,
Would you agree that the tongue is a pretty important muscle in the mouth?
most certainly,
We use it to talk, right, to eat, to swallow.
correct.
And would you agree that because of the importance of the tongue in the mouth, that there's quite a bit of blood vessels that flow into the tongue?
Yes,
Would you agree that the tongue is a very vascular muscle?
it is.
Would you agree that in your review of the tongue, that the bullet perforated the tongue?
That's correct.
Would you agree that the wound path of the tongue started at the tip and traveled through the tongue itself to the back of the tongue?
Well, the bullet passed from near the front of it, not necessarily the exact tip, but from the front towards the back, correct.
And you would agree that in passing through the tongue, it severed multiple arteries or veins?
Yes,
You would agree that if multiple arteries or veins were severed, that that would result in bleeding?
yes,
You would agree that if there is blood in the mouth, that that blood can only go to a couple of different places?
there are several places to go, yes.
Well, it could go to the stomach, correct?
If the person is able to swallow, meaning they have to be alive in order to do that.
It could go to the lungs, correct?
If a person was still able to breathe after wounding, that can happen, yes.
Or it would go out into the environment,
It could, yes,
travel out through the mouth, travel out through the nose.
correct.
Isn't it true that in your review of that wound pattern, you determined that it was at a downward or horizontal trajectory?
No. You can't have downward and horizontal at the same time. I recorded front to back.
Well, you utilized something called trajectory rods in this case, correct?
Yes,
And did you make a determination as to the trajectory of the bullet, as to whether or not it was downward, horizontal, or upward?
I recorded front to back as the direction of fire.
Dr. Howard, are you aware of which cervical vertebrae the bullet ended up in?
Yes,
And you had the opportunity to review the low-docs or the x-rays that were taken.
yes.
Wish you to approach Madam Clerk.
Okay.
Dr. Howard, I'm going to show you what's already been entered into evidence as states 20L. Give me just a minute to get the technology to cooperate with my schedule. Do you recognize this image?
May I, Your Honor?
Yeah, give me so much.
This appears to be a radiographic image, they're all taken as a part of the overall X-ray scans of the body, as a part of the overall postmortem examination. If I may.
If you would just kind of point out where
So
the,
it's a side view of the head, the face, in front here, you can see she had a nasal post, she had a tooth implant,
And Dr. Howard, I'm going to ask you to just kind of direct you a little bit. So this is a side view of Kendy Howard's head, correct?
Top of the head here, neck here, the body here.
Right.
As I'm indicating on the screen.
And so this is an x-ray of the body that you examined, correct?
Correct.
And you have just testified that the bullet traveled from essentially the front of her tongue, through the tongue, and ended in the C2 vertebrae, correct?
Correct. The mouth is here, upper teeth, lower teeth. The tongue is positioned in the lower portion. So from here to there, the bullet fragmented. So the bullet doesn't go in an exact single line because it's fragmenting going, but the main portion of the bullet is here. These are smaller fragments showing up radiographically. And the damage is, I found, both by radiographic and direct examination spine, the damage to the spinal cord mostly is at C2, meaning the first cervical vertebra, second, and then down from there.
So Dr. Howard, you would agree that that bullet did not travel in an upward trajectory?
Correct.
You would agree that it traveled in either a horizontal or downward trajectory?
Well, you're saying horizontal. It all depends on if you're talking about relative to the head or relative to the three dimensions of the room. The body could be in any position, so if you say horizontal, I said front to back because
Dr. Howard,
bullet would have entered here.
Dr. Howard, my question to you though is, bullets can travel up, they can travel down, and they can travel straight. Do you agree with that?
They can go in a variety of directions, correct.
This bullet did not travel up, correct?
Relative to your head, no.
The bullet path was front to back
Yes.
at the angle that you've just illustrated on this
Yes,
X-ray.
and as you indicated, as a part of the examination, stainless steel probe, once the internal direction was established by my examination, I put the probe in to show the line of the path of the bullet, and you'd have to align the barrel of the weapon with the path of the
Dr.
bullet.
Howard, I'm gonna ask you
And
to sit
that's why
down.
I did what I did.
I'm gonna ask you to sit down. Dr. Howard, Mr. Johnson asked you some questions about petechia. You recall that line of questioning?
Yes,
And you explained that petechial hemorrhage occurs when pressure builds up in the capillaries.
well, or small venules, correct.
And you testified that that was when there is occlusion of major arteries.
No,
You testified it was a partial occlusion, correct?
occlusion of the veins preventing blood returning back. There's still arterial pressure to the head to cause the vessels to engorge and for some of them to rupture.
Would you not agree that if there is total occlusion, the petechia may not form?
Correct.
Would you agree that there are cases of strangulations or suffocations or asphyxiations where there is no petechia hemorrhage present?
Yes,
Would you agree that in cases of strangulation, suffocation, or asphyxiation, breakage of the hyoid bone is not required to show those as the cause of death?
correct.
Dr. Howard, are you familiar with literature, medical literature, regarding trajectory of bullet paths?
Yes,
Are you familiar with medical literature that indicates that a horizontal or downward trajectory is rare in suicides?
suicide, that has been studied. There are people who shoot themselves from in the top of the head downward, so it's not the most common, but they can occur in a wide variety. To say that it's rare, it's certainly not the most common.
Now, Dr. Howard, you cut out Kendy Howard's tongue, correct?
It was using a scalpel, yes, it was removed from the body, dissected.
In your many years of being a forensic pathologist, is the tongue a standard muscle that is removed from the body for dissection?
I would say if it's a properly performed full forensic autopsy, yes,
So in every autopsy you perform, you remove the tongue
except in cases where there wasn't one.
and then you save it?
Not necessarily. If there's no abnormality, maybe a section of it,
Well, you saved it in this case, didn't you?
yes,
Why?
because there's a gunshot wound of the tongue, and it would be common and recommended practice to preserve that evidence.
So you found that the tongue showed potential evidence.
Yes, just as bits of the spinal cord that was transected were saved.
Now, doesn't the lab have a standard list of what is kept in every case, correct?
I don't recall doing that. I mean, we had a routine that each pathologist followed of sampling major organs and structures, not necessarily a specific list.
And those things that were kept, they were representative samples, very small amounts, correct?
It varies depending on the case.
Surely the Spokane Medical Examiner's Office isn't keeping 100 tongues in the back, right?
I bet they are.
They're keeping a tongue from every
A
autopsy.
sample of them,
A sample, not the entire tongue.
not necessarily, no.
Dr. Howard, you indicated that in photographing the body, there would be standard procedures that you would follow for that documentation. Do you recall saying that?
Yes,
And the purpose of that documentation is to make an accurate record of what you're doing, correct?
that's what's attempted to do, correct.
And you indicated that you photograph areas that you document in your report.
Well, we photograph the whole exterior of the body, and then if there's a particular area of concern or an injury or developmental abnormality that we want to document, or say natural disease, additional photographs may be taken in those to depict those specific areas, correct.
But, Dr. Howard, you did not photograph Kendy Howard's back without blood on it.
I don't recall. It would be, I would apologize, it would be remiss if we didn't, but it's often difficult to get the body clean to blood. Can't say, I don't
Counsel
recall.
showed you a very bloody photo for the body being immediately removed from the body bag. Do you recall
Yes.
that picture?
Yes,
Would it surprise you that that is the only photograph of Kendy Howard's back?
that's not true. There are photographs in the back of the neck, and which would depict
Of
the
the
back.
whole body?
I don't recall.
Dr. Howard, you noted in your report, as we previously discussed, 12 purple contusions to the back of the right thigh. You recall that?
That's what I recall, yes.
Would it surprise you that there's no photograph of that?
I don't recall.
Dr. Howard, as we discussed, you noted 2 contusions on the proximal and ulnar aspect of the left forearm near the elbow. Do you recall that?
Yes,
Would it surprise you that you took no photos of that part of the left arm?
I don't recall.
Dr. Howard, you indicated 5 areas of contusions on the medial aspect of the left thigh. Do you recall that?
Yes,
Would it surprise you to know that there are no specific photos of that area, though it can somewhat be seen in other larger photos based on body position?
I don't recall that. Maybe.
Would it not have been standard procedure to take photographs of contusions that you noted in your report?
Yes, it would have been.
And in fact, some of the photos that you did take, you actually utilized a ruler to show the size of the contusions.
Yes.
But you didn't do that in every case, did you?
No, I may have directed it. Obviously, if they aren't there, that wasn't done.
Dr. Howard, you indicated skin slippage in 2 specific places. Do you recall that testimony?
I'm sorry, could you repeat that?
You noted skin slippage in 2 specific areas.
Skin slippage, yes.
One of those areas was on the arm. Do you recall that?
Yes.
I'm going to show you, Dr. Howard, what's already in evidence as States 20R.
Thank you.
Dr. Howard, you took this photograph. Do you recall that?
Well, the photograph was taken during the course of the autopsy, correct?
You utilized a ruler in this portion. Do you recall that?
Yes.
Dr. Howard, is this the area that you were calling skin slippage?
Yes, if I may. So the intact skin, here you see it's very moist, typical of having been in water. And where the areas of discoloration here are where the post-mortem decay of the body, which naturally occurs, has progressed in these particular locations, typical of having perhaps some pressure in that area, in addition to the normal decay and the addition of being immersed in water. The layers of the skin start to separate. So the very surface layers have started to come off, it slips, and the deeper layers are now exposed and visible.
Dr. Howard, you can have a seat. Dr. Howard, were you provided any other opinions about this particular injury prior to your testimony today?
I believe defense counsel mentioned someone referring to them as burns.
Were you informed that a burn doctor from Harborview Medical Center calls this a second-degree burn?
Well, second-degree burn is
My question, Dr. Howard, was, were you informed?
I did not know that such a doctor said that statement.
And were you also informed that Dr. Jennifer Nara, who you used to work with, as well as Dr. Bill Smock, agree with that assessment?
No, I'm not.
And doctor, you indicated that skin slippage is caused by pressure and can be exacerbated by being in the water. Did I understand that correctly?
Well, and it occurs as a post-mortem decay of the body.
That this was the only place on the body that this is observable, correct?
No,
This is the only place on the body that this pattern of what you're calling skin slippage is observable on the body, correct?
no,
Okay, you are referring to what you call skin slippage on the left heel?
yes.
Okay, let's look at the left heel then. Dr. Howard, you're gonna have to give me a second because I don't think you photographed that. What? Dr. Howard, do you recall taking a photograph of this, what you called skin slippage on the left foot?
I don't recall.
Do you recall whether or not what you observed on the left foot looked significantly different from the right foot?
As I recall, I observed the skin slippage on the left heel, not on the right.
Dr. Howard, I'm going to approach you with what I'm going to call Exhibit 26, and then within that picture, there's 26E zoom and 26C zoom.
All right, yes.
Now, certainly this is something that you did not create, correct?
You mean this particular document? I did not.
However, do you, and it may be difficult, but do you recognize that these would have been photographs taken at autopsy?
Yes,
And these would have been taken from Kendy Howard's autopsy, correct?
it's consistent with that, but I can't document that.
Move to admit what I'm going to call States 26.
No objection.
26 is good.
Dr. Howard, as you noted, this was not something that was created by you, correct?
Well, there are two images. They may have been photographs taken under my direction, but I did not create this particular document.
Correct. And these are zooms of photographs that were taken at autopsy, correct?
As I say, they are consistent with that, yes.
And so on the left foot here, you indicate that there's skin slippage on that left foot, correct?
I said left heel.
Left heel, okay, left heel, correct?
Yes,
Okay. And there is, according to your report, not skin slippage on the right heel, correct?
correct.
And you would agree that what you're terming skin slippage on the left foot has a different pattern than what is observed on the forearm.
Yes,
You did not, at the time of autopsy, take any representative samples of that, what you term skin slippage on the arm,
no, I
correct?
did not.
You did not cut into it or biopsy it in any way, correct?
No,
You did not also, in your examination of the feet, note any lacerations to the feet or toes, correct?
correct.
You did not note any blunt force trauma to the head, correct?
Blunt force, no.
You did not note additional contusions to the body other than the ones that we just talked about, correct?
Correct,
You did not note any additional abrasions or lacerations to the thumb or hands, correct?
correct.
You did not note any swelling around the fracture of the mandible, correct?
I don't recall, that was not a specific term I used in the report, correct.
At the time, prior to your testimony here today, were you made aware that Dr. Jennifer Nara also reviewed the TOM?
That's my understanding.
That was shared with you.
What's that?
That information was shared with you by defense counsel?
I believe that someone had examined the tongue. I don't recall her name being used specifically.
And you do know Dr. Jennifer Nara, correct?
Yes, I do.
She worked with you at Spokane County Medical Examiner's Office?
Yes.
A competent pathologist?
I think so, yes.
Are you aware that Dr. Nara found that the bullet, as did you, found that the bullet traveled through the tongue?
I don't recall that being specifically, but I'm assuming that's what if she examined the tongue, she would find out.
Were you made aware that when she examined the tongue under the microscope, she observed significantly less hemorrhage than she would have expected to see?
That specific, I was not made aware of that in terms, I believe just as less than she expected, but I didn't know it was based on her microscopic exam.
At the time of your autopsy at 11:30 on February 3rd, you indicated with Mr. Johnson that the information that you had was based on information the coroner had entered into their system.
The coroner entered some basic identity, yes, and an initial scene investigation information, usually.
And that did not include photographs of the scene, correct?
Not that I observed, no.
And you had not had the opportunity to speak with any of the lead investigators at that time,
Not
correct?
that I recall.
You had not spoken directly to Chief Deputy Lynn Acevedo, Chief Deputy Coroner Lynn Acevedo, correct?
Not that I recall.
Just had those notes, correct?
Whatever was entered into the computer system, correct?
And you were made aware by defense counsel that there was further documentation of the body that was done later by the coroner, correct?
Yes,
The Spokane County Medical Examiner does not rule on manner of death in Kootenai cases, correct?
correct. It's a coroner case, not a medical examiner case.
And it is not a Spokane County Medical Examiner's job to go to the scene, correct?
Not outside the Spokane County,
You,
correct?
you don't go to scenes in Kootenai County, correct?
Correct.
And thus you did not do that in this case,
I
correct?
did not.
You stated in your opinion, the autopsy findings indicated the muzzle of the weapon was inside the mouth when it was discharged, correct?
Yes.
And you based that on the fouling to the tongue, correct?
The nature of the wound, the fact that there's bruising of the lips and the fracture of the mandible, those are typical and common of an intraoral gunshot wound, along with the presence of the gunshot residue, which would be visible as fouling, correct?
On the tongue, correct?
Yes,
And there was soot on the tongue, correct?
yes,
You examined this body and you saw a wound in Kendy Howard's mouth, correct?
yes,
Had Kendy Howard been alive when she sustained that gunshot wound, without medical intervention, that wound would have killed her, correct?
yes,
The wound in Kendy Howard's mouth, if she had been alive at the time that she was shot, would have been a cause of death.
Well, it's not just the mouth. The spinal cord injury was the primary reason she would die. She would,
My
because of the
question
damage
was,
to
Dr.
it.
Howard,
Question he was answering.
the question, Dr. Howard, was if she had been alive when she sustained that shot, that would have been her cause of death.
Yes,
Based on the observations that you made of the body, you did not consider other possibilities, correct?
not true. All types of death, all causes of death are considered in every case. You look for evidence for that.
The evidence that you saw at that time led you to the gunshot wound, correct?
There is absolute positive evidence of a gunshot wound with the same amount of hemorrhage and bleeding that I've seen in hundreds of other gunshot wounds that proved fatal. So yes, I determined that this gun, in the absence of evidence of any other cause of death, was the cause of death in this case.
In the absence of evidence of other causes, is that something that you would consider?
Every time.
And so there have been cases in your thousands of cases in your career where other evidence has led to a change in your determination.
Well, manner of death is commonly challenged and additional information comes up. But in terms of cause of death, certainly for example, we do autopsy drug overdoses. You wait for the toxicology, not just the anatomy.
So there's no amount of information that could have been provided to you that would have changed your opinion as to cause of death?
So I said, this has the same appearance of literally hundreds and hundreds of gunshot wounds that prove fatal in other cases that I've performed the autopsy. There's no reason for me to believe that there is any other cause of death.
Well, did Mr. Johnson provide you with the complete 2-year investigation for your consideration?
The what?
The complete 2-year police investigation?
No,
Did he provide you with Dr. Nara's reports or opinions?
no,
Did he provide you with Dr. Smock's reports or opinions?
no,
Did he provide you with Dr. Stewart's reports or opinions?
no.
Is it your job as a forensic medical examiner to determine whether a crime scene has been staged?
Well, I certainly, I've always been available to assist in that. I mean, the whole point is, if it's a medical examiner case where I'm responsible
In a
for...
coroner case like in Kootenai County, would it be your job to determine whether a crime scene was staged?
No.
Nothing further.
Thank you, Peter.
Thank you, Your Honor. Dr. Counsel just asked you about a staged crime scene. That would relate to the manner of death, is that right?
Correct.
Now, when you and I had a conversation regarding Exhibit 20R, I was asking you, what was I asking you to compare?
That's the area of the forearm showing skin slippage.
And that, you put skin slippage in your report, correct?
Yes.
And I asked you if that was a burn or did I ask you if it was a burn or a skin slippage?
Yes.
Did you explain to me why you thought it was skin slippage?
Yes.
I didn't provide you any opinions as to Dr. Ford's conclusions.
I haven't received anyone else's report, correct?
Now, counsel asked you to begin with that the examination starts after you wash the body, and you said no. Do you remember that?
Yes.
Why doesn't it?
Because you want to see the body in its original condition. How much blood is there? Are there any pieces of trace evidence? You don't want to wash that off before you have a chance to identify it and collect it.
Now, I did provide to you a copy of your autopsy photos, correct?
Yes.
Do you know how many photos you had?
There were dozens. I didn't count.
Was it more or over 100 or more or less than 100?
There were many.
Now, counsel asked you about blunt force trauma. Can a small impact leave blunt force trauma?
Sure, every bruise is some form of, no matter how small, is a blunt force injury.
So blunt force trauma is a kind of a medical terminology?
Yes, as opposed to a needle puncture or a gunshot wound or a sharp instrument stab wound or an abrasion where it's a scrape. It's just impact to that area. You bang your shin on a coffee table, that's blunt force impact.
If you examined a body and noticed a bruise, would you ever put bruise in your report?
Being a medical doctor doing this, I use the term contusion, but they're interchangeable.
So blunt force trauma and contusion are interchangeable?
Well, blunt force trauma can cause other things like lacerations or fractures, but a bruise is a form of blunt force injury.
Now, counsel asked you about asphyxia in relationship to petechiae. You remember that?
Yes.
Okay. And under what circumstances can you have asphyxia without petechiae?
Oh, there are many. Put a soft pillow and smother someone. That's occluding their airway. They can't breathe. It's not impairing the blood flow until the heart stops. If you have an individual who is in a confined space, like a storm sewer that has low oxygen, if there isn't fresh air pumped in, they can asphyxiate from lack of oxygen. There's no compromise to the blood vessels, no petechiae. Just two of many examples.
Can a person be strangled without petechiae?
It's theoretically possible. There are very rare cases that have been reported in the literature, yes.
Let me see if I have it here. Counsel asked you about counsel asked you about the skin slippage on the right arm.
Yes.
May I approach the witness, Ron?
Yeah.
Doctor, I'm showing you what's been admitted as 17A Zoom. Can you just take a moment and look at that?
Yes. All right.
Okay. Now, does the way the I think in one of your answers involving skin slippage, does the length of time a person's submerged in water affect skin slippage?
Objection beyond scope.
Yes.
And pressure
affect, I think did you say pressure?
That's one of the factors that can accelerate the decay process.
In anything, so I did provide you copies of the coroner's photos, correct?
Yes, there were the ones that appeared to me to be taken after the body got to a funeral home. The post-mortem changes in the autopsy had been undone and the body had been dealt with by some member of their staff.
I'm not going to ask you about those photos other than, did anything in those photos,
Objection beyond the scope.
Overruled, it's fair to be correct.
did anything in those photos change your opinion as to cause of death?
No,
The cause of death is gunshot wound?
that's my opinion.
No further question. Permission to clerk.
You ready? Our schedule. Mr. Johnson anticipates wrapping up with factual witnesses somewhat today. He has an expert witness who's traveling here and will be here Monday and cannot be here tomorrow. What that means is rather than bring back for an hour or two of testimony tomorrow, we're just going to call the day off. And I want to let you know so that if you want to make other plans or something, it looks like we'll finish out today, be off Friday, and back Monday. I want to let you know as soon as I do that, and just with the way things are going to be, it looks like that's going to be the case. So I'm just going to go ahead and make the executive call now that we'll end today, take Friday off, and be back on Monday. So I'm sorry for any inconvenience, but it's just the reality of what happens. Okay, I want you to know that before the end of the day, so if you need to make plans for your inconvenience. Okay, we will recess for the lunch hour. I'll see you back at 1:30. Please seated. I did want to just make a quick record. As was pointed out yesterday, we've had frequent bench conferences where Mr. Johnson's asked to approach, and I've always indicated to him at our conferences, if you wish to make a record to preserve it for appeal, I'd be happy to do so at any break. A few times you have, Mr. Johnson. Most of the times you haven't. Today, I think, was one of the few times I'd actually called you all up, and so I wanted to just make a record of what that conference was. Mr. Johnson was asking the witness, he was in the middle of a question that I didn't know the end of it, which is why I called him up here rather than have that in front of the jury. And Mr. Johnson, as I recall, you were wanting to ask Dr. Howard if the amount of blood seen was consistent with other cases of intraoral gunshot wounds. The state objected that was beyond the scope of his report. I indicated at the bench conference that I did think that was beyond the scope to ask him to compare it to other cases, but it was a fair question as to was the amount of blood consistent with the gunshot that we saw, the wound we saw here. And so that was your question to the witness. So to the extent I limited your question of the witness, I want to make that record. However, I'll just note it ultimately didn't matter because that was brought out on cross-examination. So, but I just wanted to make the record clear what the argument was. Okay, we'll be in recess till, yes, sorry.
Mr. Johnson indicated in chambers some witnesses that he had requested be under recall that he is releasing. Can you just put that on the record so those witnesses could be available?
The only one that would be subject to recall will be the next witness, Detective Athol. Everyone else can be released.
Okay, so any other witnesses from the state that had the names are released and not going to be called by defense? Okay. Thank you. All right, we'll be in recess.
All right. Caveat, except for Detective Northbrook, if Mr. Howard were to testify, he's subject to recall if Mr. Howard testifies.
Judge, I don't think that record was made at the time.
He was never asked to be subject to recall, so if you're wanting him, we'll probably need to make arrangements.
Yep, thank you.
So, guys, yeah, there we go. More of the state. I mean, the state's doing a good job protecting the record, making sure he doesn't get it. You guys may not like her, but she's fighting to keep that stuff out that the judge didn't let in. You know, like, yes, there are times where women sound annoying and persnickety, but she was doing an okay job. Oh my God. The defense fucking around with this caused so many problems, like trying to play fuck games. Look what it did for them. This is why you don't play fuck games. You cause so many more problems for yourself.
Motion is granted. What is the motion is granted?
Your Honor, we would renew our motion from yesterday for a directed verdict as to count one. It is clear from the evidence that the blood that's in the body bag could have come from nowhere else than from the injuries sustained by gunshot. There were no other internal injuries to cause the bleeding. The vast amount of blood, coupled with the blood in the tub, coupled with the coagulated blood in the tub, eliminates the state's theory. This only evidence of strangulation is a quote-unquote lack of blood. Not one explanation has been presented to the blood in the body bag other than the internal injury sustained by the gunshot. Certainly this is not related to count two, or count, I'm sorry, I'm referring to count two. This is not related to count one, so we would renew our motion from yesterday.
Any response?
If I may inquire first, Your Honor, Rule 29 specifically states, or at least it begins with, after the prosecution closes its evidence, or after the close of all the evidence. So I'd like to inquire if the defense is resting, because if they're not, this motion is untimely, premature.
Well, the state has closed, so our interpretation is that it's still within that purview. So we're definitely not closing or resting at this point, but I think in light of the evidence that is in front of the court, we renew our motion from yesterday.
Well, I'll put aside the procedural question for the moment and hear any response from the state.
Your Honor, thank you. Your Honor, I don't think Rule 29 is meant to take into consideration the defense's case. I think 29 is meant to take into consideration whether or not the state has put on sufficient evidence to sustain a conviction. Nothing has changed.
Not true at all, because you show, even after the state has introduced it, no reasonable jury. Yeah, so it's an encompassing of the entire thing. You do a Rule 29 at the end of the state's and at the end of yours. It totally encompasses both. Stop with that nonsense.
Between yesterday and today when we're arguing this. So I would rest on yesterday's arguments, Your Honor. Thank you.
I'm going to deny the Rule 29. Setting aside whether it's procedurally proper to raise again at this time. I think viewed as a whole, a reasonable juror can find the defendant guilty beyond reasonable doubt. The only thing that's changed since yesterday's motion is the testimony of Dr. Howard. A juror could disregard his testimony, or a juror could believe his testimony, but even as I listen to his testimony, he doesn't, at least in the court's view, he doesn't necessarily contradict the state's witnesses entirely. As to the presence of the blood indicated during cross-examination, whenever that comes out is from the wounds. His opinion wasn't, I guess I'll say the jurors can draw their own conclusions, but I'm saying he did not definitively refute the state's case. And I viewed as a whole, I think reasonable jurors could certainly find proof of reasonable doubt. So, and again, this is, of course, in the light legal standard, which the state is not in the party. So let me deny the Rule 29. Otherwise, ready to proceed? Yes, sir. Okay. Thank you very much.
Messages from,
What was it?
I would say the messages between defense portion of messages from Ms. Howard and Tanner.
And that exhibit was previously admitted?
Yes, sir.
Okay. Sorry, I didn't even ask the state if you have any objection.
I'm not even sure what we're looking at now.
Will you actually let these counsel?
It's been like several days ago, Your Honor. It's
Exhibit
D,
what?
D, the messages from defense from,
You have a copy for the state?
Is there a number that precedes D, counsel?
no,
It's defendant's.
it's defendant's exhibit.
You have a copy or not?
I don't have a copy on me.
You give me copies of all our exhibits.
I gave you a copy of the exhibit.
Answer your copy from the clerk.
Call Detective Alton.
Detective Walton, please step forward, sir, and have you raise your right hand. Just
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Sir, if you have a seat, please stand. You may start.
Good afternoon, Detective.
Good afternoon.
Can you please state your name for the record?
It's Ken Lallatin, Lallatin.
I know you previously testified before in this matter, but can you remind the jury how long you've been a detective?
I was a detective from approximately 1999 until, I think, 2003 or 2004, and then I went into persons crimes in January of 2006 until I retired September of this last year.
Would you, do you believe it's important to be objective as a detective?
Absolutely.
As a detective, you frequently come across individuals who are experiencing emotional trauma or hardships.
All the time.
Is it important to separate out the emotions from objective investigations?
I would say so.
When did you arrive on scene again on the incident with Ms. Howard?
I arrived the night of her death about, I believe, 15 minutes before midnight, give or take.
Okay. You, during that course of the investigation, did you take possession of Ms. Howard's phone?
I did not personally know.
Did you or someone you were with, while you were with them, go through her phone?
Could you repeat the question?
So there was a period of time where, let me just back up a little bit. Did you arrive with other detectives?
Yes, I was driving. Detective Sergeant Darrell Euler was riding with me. Jerry Northrup was already on scene, parked in front of the residence waiting for our arrival.
And the jury has seen multiple videos in this matter. During the course of those many hours before you cleared the scene, did you and Detective Euler go out to your vehicle to discuss what you were observing?
Yes.
As part of that observation, were either one of you going through her phone?
I don't recall ever going through her phone.
Now, we heard a couple days ago your interactions with Mr. Howard around 6:45 in the morning. Was that on video?
Well, our interaction was from around midnight until at least that time. So yes, there were multiple breaks in between.
Okay. When Brooke called her dad or Dan back, did you form an opinion that Dan did it?
No. Was I suspicious? 100%.
Did that suspicion cloud your investigation in any way?
Not at all.
That day, did you conduct a phone interview with Wendell and Janie Wilkins?
No.
On the 3rd?
No.
Now, did you conduct an interview with Brooke on the 10th?
I don't recall the dates. I spoke with Brooke, I believe, 2 separate times. One was the morning of the incident, and later, I believe we met in person. There were a lot of interviews with this investigation.
Okay. Now, at the beginning of this case, were you the lead detective?
No, I was not.
But you became the lead detective?
Yes.
And when was that?
Would have been July of the same year.
So from July of that year till today, have you or any officers on your direction that you know of interviewed Carrie Maitland?
No, she's not one time ever came into the sheriff's office and contacted us to make a statement. In fact, I didn't even know honestly who she was until yesterday.
Did you or any other officers at your direction between the time you took over and today ever interview Brett Gunderson?
No, same thing. Not one time did he ever make an effort that I'm aware of to come down to the sheriff's office or to call me.
Did you ever interview Mr. Prado?
Yes, I was with Detective Weyler when we contacted and interviewed Daniel Prado at his place of employment in Kamei, Idaho.
During that interview, did you become aware of potential witnesses to an alleged event on July 10th of 2020?
I don't recall.
How'd you become aware? Well, I'll start. You conducted a second search warrant on 17th?
Detectives and officers from the sheriff's office and Idaho State Police forensic unit served one, yes.
And you were present?
I was present for portions of that, but I was not directly involved, no.
As lead detective from very early on in the case, are you familiar with all the reports and of other officers and reports of, for instance, what's in property?
Yes, so when I took over the investigation in July, I reviewed, to my knowledge, most all of the reports. They're fairly substantial.
On that second search warrant, was there a person there who was not law enforcement?
At the time of serving the search warrant?
Yeah, executing the search warrant, yes.
At the residence?
Yes.
I guess I'm not understanding your question. We had personnel from Idaho State Police forensic unit there.
But non-law enforcement, was Mr. Howard there, John Howard?
Oh, yes, he was.
The purpose of the second search warrant was to confirm some of what Dan had said that the jury heard in the audio, correct?
Objection, leading. Sustained.
Was the purpose of the search warrant in part to confirm some of what Dan had said in your interview?
Yes.
Specifically, the search was to check for a bullet hole in the upstairs closet where Dan said a gunshot went off in the house in a prior event, correct?
Again.
Sustained.
Was one of the reasons to search for a spot in the upstairs closet where Dan had said a gunshot went off in a prior event?
Yes.
Did law enforcement find a gunshot, evidence of a gunshot in the spot where Dan had said?
I know that Detective Northrup found a hole in the floor. I know that he tested it for copper and other things related to bullets and was unable to determine what actually caused the hole.
A piece of carpet was a piece of carpet removed and booked into property.
Yes, I believe there was.
At any point, have you reviewed? Let me straight. Have you reviewed what is in property?
Yeah, several times, multiple times.
Are there any black pants anywhere in property?
To the best of my knowledge, no.
Are there any black hoodies anywhere in property?
I don't believe so, no.
Are there any black gloves anywhere in property?
No.
I have no further questions. Ron.
Okay, cross-examination.
Based on your common sense, could black hoodies, gloves, and pants be simply discarded by someone committing a crime?
All the time.
Especially someone who would be cognizant of what a crime was and how to get rid of evidence?
Yes.
And that could happen, especially true with someone who's trained in the collection of evidence, couldn't it?
I would believe so.
And Dan Howard was trained in that, wasn't he?
Objection. Foundation is to get rid of evidence, Your Honor.
Do you lay foundation for females?
Do you know Dan Howard?
Yes, I do.
I think we spoke about this when he first testified, didn't we?
Yes, we did.
And you've known him professionally for over 10 years, right?
Probably closer to 15.
You've been
Yes.
sitting here in the entire trial while people have discussed his law enforcement background, haven't you?
Yes, I have.
And you know as well as everybody else that he has a background in evidence collection, right?
Yes.
He has knowledge of DNA, right?
Yes.
Ballistics.
Correct.
And so it would follow then, because he has that knowledge, he would have the knowledge on how to get rid of all that evidence, wouldn't he?
Yes, he would.
You were asked some questions about being objective in this case. Do you remember that?
Yes, I do.
Do you think you have been objective?
Yes.
Why do you say that?
Well, if we would have just taken Dan's word or one other person's word, that's one thing. But in this particular case, we let the facts and the evidence lead to a truthful conclusion in this investigation.
Objection to
We went
the word truthful.
Overruled.
Please continue, Detective.
I would say this was one of the most intensive investigations I can recall being involved with. It took a team of investigators. Not only was I involved in this case, but we had experienced investigators from multiple agencies, and we elicited the assistance from some of the top experts in their fields that are unbiased.
Objection, foundation for hymnology, expert.
I'll sustain as to his characterizing what other witnesses are as biased.
Can you continue with your answer, leaving aside the fact that these experts are unbiased?
Objection.
That's a very disregard for that statement.
Can you finish your answer, please?
Yes, I forget where I was, honestly. Could you restate the question?
Was your investigation unbiased?
Yes, it was.
Can you describe why?
Because of the reasons I just spoke to, in the fact that we let the facts and the evidence speak for itself.
You were asked a question early on from counsel about whether you took into account emotional hardships someone might be suffering. Do you remember that?
Yes, I do.
And did you do so?
Absolutely.
Can you describe why or how?
Well, anytime you respond to a crime scene or an incident, and in my particular case, in my experience, I've been to a lot, whether it be as a patrol officer or as an investigator responding to a death scene. And at every death scene, whether it be natural, unnatural, suicide, homicide, people are dealing with the most extreme moment in their life, right? So everyone responds a little differently to that stress and the pressure. Unfortunately, most of the time, we don't have the experience or the background to know what that person's normal baseline is. In this particular case, I do know Dan Howard. I have dealt with Dan Howard. And so compared to other people, I feel that I had, and other officers on scene, had a better baseline for how he deals with and handles stress.
We watched you and Detective Euler's interviews over the course of a couple of days. Do you feel like you treated Dan Howard like you would any other person?
I treated Dan Howard with nothing but respect, just as I do everyone I deal with.
You were asked some questions about the moment that Brooke called her stepdad back and essentially accused her of killing Kendy. Do you remember that?
I'll never forget it.
Yeah, I think in the recording, we heard you talk to Dan about that. Is that accurate?
Yes.
And I think you're on direct, you said that caused you to be suspicious. Fair?
Yes.
Why?
Well, in all the years that I've responded to these types of scenes, especially one that originally came out as a suicide call, not one time do I ever recall seeing a family member respond in that manner to another family member.
Did Dan's demeanor change when Brooke said that to him and you followed up with questions about why Brooke thought he killed her mother?
Yes.
Can you tell us about that?
He was very shaken up over it. That was really the first time that I noticed that night that there were some genuine emotions coming from Dan Howard. It was after his phone call with Brooke.
Do you think that despite this suspicion, that the investigation that went on for the next couple of years was unbiased?
100%.
Why do you say that?
Because of the same reasons I spoke to earlier. This was not just one person conducting this investigation. This was a very complicated and a difficult investigation that was, which caused us to have to utilize a lot of experts and uninvolved individuals.
Had Carrie or Brett bothered to reach out to the sheriff's department, had bothered to reach out to you, would you have gladly interviewed them?
Of course I would have. Just like we did the many other people who contacted us.
The search warrant was served on February 17th, 2021. I think counsel asked you about whether or not Mr. Howard's father was there. Remember that?
Yes.
And can you describe what you did as a result of that?
I left the scene with Mr. Howard and met him down at a local restaurant where we sat and had coffee and chatted
How
during
long?
the search warrant, during the majority of that search warrant.
Why did you do that?
To get him off scene so that people could work without him being in the way.
This incident during execution of the second search warrant on the 17th and an attempt to confirm what Dan had said about some incident years ago in firing a bullet through the floor. Was there any evidence from any other person that supported what Dan said had happened other than Dan?
Yes.
And who was that?
Wyatt Howard, Dan and Kendy's son.
But isn't it true that Wyatt heard it from his dad?
That's my understanding, yes.
And so what Wyatt knows about that, he got from his dad?
Yes, portions of it.
And so this entire story is something that Dan could have made up, right?
Sure.
Because there's no one else to say otherwise, right?
Yeah, that'd be correct.
No further questions?
Thank you. Redirect?
Yes, please, Ron. So, in relationship to the incident in July of 2020, when was that charged? Your Honor, directly,
It's also irrelevant and beyond the scope.
Your Honor, directly it deals to whether or not Ms. Maitland or Mr. Gunderson would have the knowledge to go and respond to police officers.
No, it's irrelevant as to charging this offense, sustaining the objection.
To your knowledge, was there anything that witnesses of a July 10th event would know to contact?
Objection.
Lovely.
Speculation.
You know, I'm understanding better the scope of your question. I'm reversing my ruling. You can ask about when it was charged. I understand your question now. I'm allowing it.
Thank you, Your Honor. To your knowledge, was the incident of July 10th, 2020, when was that charged?
I don't
Objection
recall.
relevance. That's a different question than the first two.
It's just worded just a little bit differently than the first one, Your Honor.
I think that's the same question. He answered he doesn't know, but I'm overruling the objection.
What was your answer?
I don't recall. I believe it was last year.
Okay. Last year being 2023?
Correct.
So would Mr. Gunderson or Ms. Maitland have reason to know to contact law enforcement regarding a bruise in July of 2020?
Counselor,
It calls for speculation into two other people's frame of mind.
Understood. It is speculation. Sustained.
Counsel asked you about your former relationship. Were you and Dan friends?
No.
No further questions, Your Honor.
Thank you, sir. You may step down.
Thank you.
Next witness.
Chris McCullough?
Good afternoon, sir. Good afternoon, Your Honor. You could step forward and place my quick raise your right hand.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Could you have a seat there with us?
Yes, sir.
Best you can.
Yes, sir.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please state your name and spell your name for the record?
My name is Christopher McCullough. I have a lot of middle names. Just the first last name, right?
Yes.
CHRISTOPHERMCCULLOUGH.
Where do you live?
I live in Bergen City, Utah.
What do you do for work?
I work for a company called Siemens, and I'm what they call a technical consultant. To make it simple, I'm a factory rep. When people buy expensive industrial measurement equipment, they need somebody to come and teach them how to use it. Or when they want to think about buying it, I want to help the salespeople finish the sale.
Do you know Dan?
Yes.
How do you know?
It's been one of my closest friends for, holy crap, 43 years?
Okay. Do you know Kendy?
Yes.
Prior to her passing, how often would you interact with Dan?
Our friendship is one of those where we talk 4 or 5 times in a couple of years, and then come up and see a brother or a sister or a friend who lives here, or come up and see Dan when I was driving through, and then it would kick back up, and it's like it's like a sentence that kind of finished halfway, and then you pick it up the next day, week, month, year, and not miss a beat. So,
Did you grow up with him?
yes,
Now, how did you learn about Kendy's passing?
Dan called me.
Did you come up at any point after you found out about her passing?
Yes, I did.
Can you explain?
Right when she passed, Dan has posted in the
Objection, relevance.
It's foundational. Your
Hold on.
You can continue.
After I found out, I figured he was well supported, had a lot of friends around him, and he had to keep his job, so he moved back to Alaska. And we stayed in touch, and then when he came back, I was here.
How long did you stay here?
About a week, I believe.
You have opportunity to observe his demeanor?
Absolutely, yes, sir.
Can you describe that?
He's brokenhearted. Brokenhearted. He was in the middle of the process. I've been close with him all my life. He's in the middle of the process, was nervous on the rocks, and all of a sudden his wife was gone. And we'd talk. Anytime we went toward Kendy, we got around her stuff. He'd start to tear up and kind of.
Objection, non-responsive.
Overruled, but that's the narrative. I'll ask you directly. One question.
You were describing his demeanor when you were talking when the subject of his wife.
Yes, so she was.
Objection leading is asked and answered at this point.
He hasn't answered it yet.
Overruled. You can finish your answer.
Pick up my sentence real quick here.
Why don't you ask another question?
Yeah, please.
So, just briefly describe.
Brokenhearted.
Okay.
Distraught.
Where did you stay when you were up here for that week?
In Kendy's home.
Where did he sleep?
In one of the extra bedrooms.
What was the state of his house?
As you might find a house from one day to the next, relatively clean and in good order. And then I was there, I was there to help him get through coming home after being up on the slope, trying to process what was going on. But the house was in relatively good order. Kendy kept a pretty clean house. Dan kept a pretty clean house.
Okay. In the course of you working with him, did you have an opinion on what he should do with any of her belongings?
I actually,
Objection, relevance.
It was brought up in testimony yesterday, Your Honor.
It's not proper opinion, presentation, testimony.
His opinions would be relevant. So, I'll sustain the objection.
Did you, not what they were, but did you express any thoughts about?
yes,
You gotta wait for the question, sorry.
we can have a good question.
Council might have an opportunity to object. And
Yes, sir.
did the topic of some of Kendy's clothing and stuff come up?
Yes,
Did you make any suggestions?
I did.
What were they?
Objection, hearsay.
Overruled. I'll have this not for the truth of the matter, sir, but simply for what he said. Whether it's true or not is not for the jury to work out.
While we were driving back and forth in the course of helping deal with his house, I saw a place that, and I followed up on it, that helped with belongings of people that they would buy things. And I suggested every time we walked past the case of chickens that was full of memorabilia and stuff like that, I would, that's how it affected them. And I realized things needed to change, so I suggested that we call that business and have them come in and tell us what they do.
Did you observe him grieve?
Yes, that's what I suggested. I want to change the state of the house.
No further questions, Ron.
Cross-examination?
Well, it sounds like you've got some opinions about Dan Howard and the fact that he was brokenhearted, right?
He was working hard, sir.
And it sounds like you've got an opinion that he was grieving, right?
He was grieving, sir.
Did you know that his wife, right before she died, had about 30 separate instances of blunt force trauma all over her body?
I don't believe that, sir.
Okay, did you know that?
As I said, I don't believe it.
I'm not asking you whether you believe it or not. I'm asking you if you know that.
No.
Okay, so if that was proved to you beyond any doubt in the course of this trial, you wouldn't believe it?
Objection.
Is that where you're at?
Objections to the question. Form.
Let's sustain the objection.
Why don't you believe it?
Dan and I's characters are known to each other, and he would never strike a woman except in the course of being an officer to protect himself from the people. I've observed him for years. He was never a woman or an innocent person.
So it sounds like you can't neutrally evaluate evidence if it pertains to Dan Howard. Is that correct?
I don't understand.
Well, you wouldn't believe it, is what you said when I told you she had about 30 different areas where blunt force trauma was inflicted on her body. Remember that?
Objection to the characterization, Your Honor. It's not a fact that it was inflicted upon her. There's 30 instances of bruises, aka blunt force trauma. Doesn't mean it was inflicted upon her.
mischaracterization of the evidence.
Your response?
I think the evidence in this case speaks for itself, Judge.
Well, on that basis of objection, I'll have a question to Sandy to answer.
Sorry. The way you're asking the question is asking me to conclude something that I don't think I'm capable of. So you're painting a picture that I can see, but how that picture got painted, I disagree with.
Well, let me try to paint that picture for you.
I understand.
Can I approach and get 19B?
Okay.
Now, prior to this, after he collects the exhibit, maybe briefly approach before the question. Or I think it might even be outside presence. I think it might.
I think it's outside presence of the court. Excuse me. All right. You see it?
Your Honor, I think it's improper to try to impeach a lay witness with exhibits admitted by experts when many of the injuries were after autopsy, or as far as documented after autopsy, by several days. The autopsy was on the 3rd, the coroner took photos on the 8th. The doctor testified that he didn't review them or the chart until later on. I mean, it's purview of expert testimony. And to have a layperson be shown a picture of purple or bluish area and not know the difference between a contusion or blunt force trauma or a bruise or a cause, I think it's the improper impeachment of a lay witness, Your Honor. That's the purview of the experts. That's definitely outside the scope of cross, and I would ask that he not be allowed to try to be impeached by expert opinions of potential, or expert opinions of bruising.
Thank you. Mr. Ricker?
Judge, I think this witness has made an inference that he has a bias and that no matter what, he wouldn't believe something against Dan Howard because of his relationship with Dan Howard. I think that's an inference that one can reasonably draw here in the initial questions that I asked him. 19B has already come into evidence. 19B has been seen by this jury a couple of times. 19B is evidence that would go to refute or explore the bias that this potential witness has. If he would not believe evidence that this jury has seen throughout this case, I'm not sure why the jury would believe anything he would have to say. So it's come into evidence. It's fair game. It's no different than any other instance where a character witness, if you will, has an opinion of somebody, and then the rebuttal question obviously is going to be, if you knew this, would you still have the same opinion? And that's all that I'm doing. And it's completely permissible, Judge.
Mr. Johnson?
Your Honor, again, it's not like showing, well, did you know someone was, X, or do you know that she had a broken arm? The coloration is still in the purview of the jury, whether those are contusions caused by normal occurrences, whether it was a struggle, whether it was after autopsy, which is a violent procedure, as Dr. Howard testified. That's not the proper impeachment of a lay witness, and I think it's a mischaracterization of the lay witness. Certainly, any other area of impeachment that counsel wants to go to may be appropriate, but this is an inappropriate area of impeachment.
Well, I don't believe this is proper cross. The scope of his direct was, he didn't opine as to Mr. Howard being peaceful or not violent with his wife or anything like that. He simply testified to being up here, his observations of Mr. Howard's demeanor and grieving and so forth. And that's all fair. That's fair. Not rebuttal's the wrong word. That's fair evidence to as against the state's evidence of his demeanor and so forth. Whether or not, I don't find it proper to essentially put on the case to this witness and then ask him if he believes it or not. He's been clear that he wouldn't believe, the point has been made for Mr. Heron that he wouldn't believe that Mr. Howard would injure his wife, regardless of what the evidence might be. The state certainly has painted that. His comments about not believing Mr. Howard capable of hurting a woman or hurting a wife or so forth, if that were brought out on direct, then maybe this would be fair, but that was essentially brought up on cross-examination. I don't think it's appropriate to set him up on cross and then further impeach him on something he didn't testify on direct. At this point, I think it's I'll leave it at that. I'm not going to allow it. I think it's I don't think it's proper at this point, and so I'll sustain the objection.
I take it that is just a 19B, Judge?
Well, I'm saying to impeach this witness with a bunch of the exhibits and ask him if he thinks Mr. Howard did it, I think is far beyond direct.
Okay, so I take it your ruling is I can't impeach him with exhibits, but everything else I can?
Well, I'm not sure exactly. I guess I'll see what you do. But what my ruling right now is that it's not proper to show him autopsy photos and ask him if he thinks Dan did that or didn't do that and so forth.
And that's what, isn't what I was doing, Judge.
Okay.
I do find, Your Honor, that the court is right as far as setting up his own impeachment. We didn't go in that direction, Your Honor.
I'll see where you go, I guess, but I'm just saying I don't think it's proper to present him with a bunch of exhibits and unless it's directly impeaching his direct question, his direct testimony, then I suppose you can. But in terms of setting him up to further impeach him on things that he didn't talk about on the graph, I don't think that would be appropriate. This one is redundant.
Would you sustain a second-degree burn to her arm?
Objection.
Going to sustain the objection.
Guys, the speed is at 1.4 speed. If you need me to slow it down, I can. But no, this guy, the way he talks, it's like he's the cleanup man. He took care of all the stuff he was supposed to come up and clean up the body, so. No, I'm not clipping my toenails. I am doing work, but I appreciate you thinking it'd take me that long.
Have you ever had someone not tell you the truth?
Yes, sir.
Have you ever had someone give you a false chain of events?
Yes, sir.
And you believe them nonetheless?
Yes.
And have you done that because you trusted them?
Yes, sir.
In this case, did you know that Courtney Lambert tried to buy Kendy Howard's chicken collection for Kendy's granddaughter?
I knew there was some debate about it, where it would get sold, but I don't know the specifics, who tried to buy what.
What was the debate as you understand it?
I just suggested he sell them as quickly as possible, because there's so many of them. And he said he was trying.
Did you suggest he sell them to Kendy's next of kin?
No, sir.
Why not?
I didn't suggest either way on that, sir. It was just a matter of cleaning the space. It wasn't constantly reminded of his wife's passing and the collections that she lined the walls with.
It sounds like you're the kind of friend that would stick behind Dan Howard no matter what. Is that accurate?
If he told me he did it, I would not stick behind him. I would suggest he do the right thing and turn himself in.
If he told you he didn't do it, you'd stick by him, wouldn't you?
I believe it to be true. That's correct, sir.
Because he said so, right?
40 years of living and being together says so, sir.
I get that. But you're believing him because he said so, right?
That's a kind of a question of vacuum, sir. I believe him because I know him.
Okay. But you don't know the facts of this case, do you?
Some of them, sir. But I wasn't allowed to watch up to this point, so.
But you have been watching online.
I watched a small section. I didn't believe, Your Honor, I didn't believe that they would publish this real time. And so I logged on when it was, I think, the second day. And I saw the comments rolling. And I had a really sick feeling that I shouldn't be doing it. I made a comment that he didn't do it. And then I logged on. I don't know how long it was. I was at my job, so I worked and walked away. And
So when you were at work, you watched this trial.
I work from home.
When you were at work, you watched this trial.
Yes, sir.
And then you commented on this trial?
I think it was around breakfast time, yes, sir. So, yes, I taken a break and I was looking at it.
So I take it that you, among the thousands of other people who watched this trial, you made some comments about the trial.
I think I made 2, maybe 3. You'll have a record, I'm sure, sir.
Did you make these comments to the thousands of people that were watching it?
There's a chat box I just typed in.
Is that a yes?
I don't know how many people were watching.
Does it have like a tally on it?
I didn't look.
You just looked at the testimony of the witnesses that were testifying?
No, may I describe the witnesses that were testifying?
No, I don't think so. Judge, this witness has watched the trial in direct contravention of the order of the court. I move to strike his entire testimony at this point.
I didn't receive a instruction.
Let me, Commissioner Bordier.
Yes.
You said you logged on. Where did you log on?
YouTube, sir.
Did you know that what you logged on to was a live stream?
I thought it was recorded from the day before, but then I saw the comments, I guess I became aware of it.
Somewhere around that, after that first day, did you get a call from either Dan or myself regarding whether or not you should watch the video?
Yes, sir, from you.
Fishing meeting.
You already answered it.
And did you actually observe testimony in this case?
No, sir.
Let me wait, Coach Ron. It might be necessary to be off record. I guess.
Be off.
I'm on. I'm on.
Okay. Sorry, this is very- You seated?
Your Honor, some of this is stuff that I don't think should be in front of the jury.
Well, did you not understand what an order of exclusion of witnesses?
Yes, absolutely, Your Honor, and no one knew that it was going to be live streamed. We had media, no one knew it was going to be live streamed. We knew they were going to be recording, and
So it would be okay for a witness to
No.
watch the recording from the day before?
did not, no, he
That's what you just said he was trying to do.
he logged on to a YouTube clip, Your Honor. I'm not speaking for him. I'm speaking for what occurred is that first day, actually it wasn't until the second day, I think end of the first day we realized it was live streamed.
Did you tell your witnesses they were excluded?
Yes, as soon as we found out it was live streamed, absolutely we did. As soon as we found out it was live streamed, we instructed all our witnesses, do not. I had a phone call, and when my phone call with Mr. Ricola, my understanding is that he had logged on to something, but he hadn't watched any testimony, but he had made a comment. My understanding, he hasn't watched any testimony. And that's his, I believe that's his testimony right there.
Yes, sir. That's correct.
What did you log on to do?
I didn't believe that these types of things would be streamed live. I'm sorry. I didn't think in Idaho. I thought maybe California or something like that. And so
Did you know that you were not supposed to, that you were excluded as a witness and not supposed to view the trial?
I was not instructed at that point yet.
Nobody told you that at the beginning?
I knew I couldn't be in the room, but when it went public like that, it seemed like the court changed the rules. Don't be disrespectful, sir.
So you knew you couldn't be in the room, but you thought you could watch it?
It's confusing, didn't you say? So,
All right, well, it's certainly in contravention to the court's order on exclusion of witnesses.
May I respond to Mr. Johnson's comments?
Well, it's Mr. Herron's witness, so.
All right. I was in the middle of a phone call with a client. What the fuck did I just miss? Wait, he was watching me? What? No. No, like, are you guys shitting me or do you watch Law and Crime? What the fuck? No, I was on the phone with somebody and I guess I need to rewind for a second. Let's go to, I need to catch up with this.
To Kendy's next of kin?
no, sir. I didn't suggest either way on that, sir. It was just a matter of cleaning the space so there was a constant reminder of his wife's passing and the collections that she lined the walls with.
It sounds like you're the kind of friend that would stick behind Dan Howard no matter what. Is that accurate?
If he told me he did it, I would not stick behind him. I would suggest he do the right thing to turn himself in.
If he told you he didn't do it, you'd stick by him, wouldn't you?
I believe it to be true. That's correct, sir.
Because he said so, right?
40 years of living and being together says so, sir.
I get that, but you're believing him because he said so, right?
That's a kind of a question in a vacuum, sir. I believe him because I know him.
Okay. But you don't know the facts of this case, do you?
Some of them, sir, but I wasn't allowed to watch up to this point, so.
But you have been watching online.
I watched a small section. I didn't believe, Your Honor, I didn't believe that they would publish this real time. And so I logged on when it was, I think, the second day. And I saw the comments rolling. And I had a really sick feeling that I shouldn't be doing it. I made a comment that he didn't do it. And I logged on. I don't know how long it was. I was at my job, so I worked and walked away.
Bullshit, I had a sick feeling and I only commented once and walked away. Bullshit. Bullshit.
So when you were at work, you watched this trial.
I work from home.
When you were at work, you watched this trial.
Yes, sir.
And then you commented on this trial?
I think it was around breakfast time, yes, sir. So, yes, I'd taken a break and I was looking at it.
So I take it that you, among the thousands of other people who watched this trial, you made some comments about the trial.
I think I made 2, maybe 3. You'll have a record, I'm sure, sir.
Did you make these comments to the thousands of people that were watching it?
There's a chat box I just typed in.
Is that a yes?
I don't know how many people were watching.
Does it have like a tally on it?
I didn't look.
You just looked at the testimony of the witnesses that were testifying?
No, there were. May I describe the witnesses that were testifying?
No, I don't think so. Judge, this witness has watched the trial in direct contravention of the order of the court. I move to strike his entire testimony at this point.
I didn't receive a instruction.
Let me, Commissioner Bordeaux.
Yes.
You said you logged on. Where did you log on?
YouTube, sir.
Did you know that what you logged on to was a live stream?
I thought it was recorded from the day before, but then I saw the comments, so I guess I became aware of it.
Somewhere around that, after that first day, did you get a call from either Dan or myself regarding whether or not you should watch the video?
Yes, sir, from you.
Kitchen meeting.
You already answered.
Yeah, but that was-
And did you actually
it's leading, but we're trying to get to the heart of the matter if he's got bias or not. That's necessary.
observe testimony in this case?
No, sir.
Maybe we approach on. It might be necessary to be off the record. I'm on.
Okay. Sorry, so this is great. You see it?
Your Honor, some of this is stuff that I don't think should be in front of the jury.
Well, did you not understand what an order of exclusion of witnesses?
Yes, absolutely, Your Honor, and no one knew that it was going to be live streamed. We had media, no one knew it was going to be live streamed. We knew they were going to be recording, and
So it would be okay for a witness to
No.
watch the recording from the day before?
did not, no, he didn't.
That's what you just said he was trying to do.
He logged on to a YouTube clip, Your Honor. I'm not speaking for him. I'm speaking for what occurred is that first day, actually it wasn't until the second day, I think end of the first day we realized it was live streamed.
Did you tell your witnesses they were excluded?
Yes, as soon as we found out it was live streamed, absolutely we did. As soon as we found out it was live streamed, we instructed all our witnesses, do not. I had a phone
Should have told your client, you told your witnesses, don't watch anything about the trial at all.
call, when my phone call with Mr. McCullough, my understanding is that he had logged on to something, but he hadn't watched any testimony, but he had made a comment. My understanding, he hasn't watched any testimony. And that's his, I believe that's his testimony right there.
Yes, sir. That's correct.
So what did you log on to do?
I didn't believe that these types of things would be streamed live. I'm sorry. I didn't think in Idaho. I thought maybe in California or something like that. And so
Did you know that you were not supposed to, that you were excluded as a witness and not supposed to view the trial?
I was not instructed at that point yet.
Nobody told you that at the beginning?
I knew I couldn't be in the room, but when it went public like that, it seemed like the court changed the rules. No disrespect, sir.
So you knew you couldn't be in the room, but you thought you could watch it?
It's confusing, sir. So,
Well, it's certainly in contravention to the court's order on exclusion of witnesses.
Your Honor, may I respond to Mr. Johnson's comments?
Well, it's Mr. Herron's witness, so. I don't know that it's not necessarily going to strike his testimony. I think he's been thoroughly, I think this has been thoroughly shown to the jury, the inappropriateness of the behavior. If the state has any further cross, I'll allow it. And then the witnesses, I'm not going to allow you that.
Well,
You may.
for the record, Judge, I still stick by my motion to strike his testimony. You have initial testimony from this witness that he watched witnesses. Now, that's changed as he was questioned by Mr. Johnson, but nonetheless, it was out there. So you have evidence that he has watched this trial in contravention of the court's order, that he has commented on this trial, that he has talked to counsel about that counsel has kept that from us yet again with yet again another witness, and we're finding out what counsel has done via a witness when that witness is on the stand testifying. So this isn't like the first time Mr. Johnson has spoke about something that we later find out in terms of the witness testifying. Obviously, that's happened in short order here. I think the most appropriate thing to do, based on these circumstances, based upon the blatant disregard of this court's order, and keeping in mind, even if it wasn't live streamed, if it was recording and you want to take him at his word, it doesn't matter. This testimony needs to be stricken.
The purpose of the exclusion order is so that witnesses can't correlate their testimony with what they're seeing and to prevent bias. It's been demonstrated, everything you just said has been demonstrated in front of the jury. Everything you just said has been demonstrated to the jury. I think they're in the best position to evaluate his credibility after having heard all of that. And I think they can make the appropriate determination whether or not he's credible, what weight to give to this testimony. And I don't see a need to order all of this testimony stricken. Rather, the record's been made of what he did. And the jury, I trust, will take that into account when they consider his credibility. So, if you had any further cross on that, I would allow it. Otherwise, I'm not going to allow further questioning of the witness, given the violation of the court's order by defense. But if you have anything else you wanted to cross on, or if you want to leave it at that, we'll leave it at that.
Thank you.
Do you know which?
I'm still thinking, Judge.
Let's see what they're got.
Damn, I thought it was going to be me that the guy said he watched. Oh, well.
And I know that your friendship with Dan Howard is very important to you. But now, we've listened to you say that you'll believe him over the evidence
That's not what I said.
presented in this case, right?
Well, I haven't seen the evidence presented in this case.
But you told us it doesn't matter, right?
I said if he told me that he did it, I would tell him to turn himself in.
And now we've learned that despite the court's order that witnesses shouldn't sit in the courtroom or listen to the trial, you did so anyway.
I had not received that order at that time, sir.
And that you've commented on this case, right?
At that same moment, I did not receive that order. That's correct.
So it
It's
sounds-
an interactive forum.
It sounds like whatever you've done in the case and whatever opinions you have is for the benefit of Dan Howard?
It's for the benefit of the truth, sir.
The truth.
Yes, sir.
And that's what you're saying today, the truth,
The whole truth and nothing but the truth, sir, yes.
based on what?
Based on everything I've experienced. You have other witnesses that have other experiences. They cannot do the same thing. I'm just...
Oh, my God. Don't say... Now you sound just fake as fuck, boy. Come on now, bro. The whole truth and nothing but the truth. Okay. Okay.
Based on my knowledge of my friend, defending my friend because I know him to be a good and decent man.
Would you consider yourself to be a gullible person?
No, sir.
Thank you.
I'm not allowing any redirect given the witnesses' controversial court's order.
Sorry about that,
Thank you,
sir.
sir. You may sit down.
Yes, sir.
Your Honor, the last witness for today is Mr. Dwight Howard. It's 22. Rather than cutting his testimony up, would this be a good time to take him? To have our mid-afternoon break rather than cut the
I'd rather
testimony?
not. I've had the jury out multiple times now.
Okay.
Why don't we continue on? We'll probably break about 3:30.
We possibly may build that in there.
Okay. Next week?
Dwight Howard.
Yeah.
Nobody present, Your Honor.
May I have a moment, Your Honor? Here we go.
Good afternoon, sir. Yeah. You come forward, please face my raise your right hand, please.
Do you solemnly swear that the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Please, sir, could you have a seat, please, stand there? As you can, I ask you to speak in the microphone.
Okay.
You ready for it?
Good afternoon.
Good afternoon.
Can you please state your name and spell your name for the record?
Say that again.
Can you please state your name and spell your name for the record?
Wyatt, W-Y-A-T-T.
And Howard?
Howard, H-O-W-A-R-D.
And where do you live?
Post Falls, Idaho.
Who are your parents?
Daniel Howard, Kendy Howard.
Do you have a sister?
Yes, sir. Stepsister.
And what's her name?
Brooke Wilkins.
How old are you?
27 years old.
Where did you grow up?
I grew up in Athol, Idaho.
Prior to your mom's passing, what was your relationship with your sister?
Relationship was good before.
Okay. What kind of activities would you do as a family growing up?
Sporting events, boating, camping, kind of just the normal activities.
Did you have any particular coaches for some of your sporting events?
Yes, my dad was involved in coaching for some years.
When you graduated, what year did you graduate?
I graduated in 2015.
What did you do after that?
I enlisted in the Marine Corps.
Okay. Well, what do you do now?
I own my own flooring business.
Now, what was your relationship like with your mom?
My relationship was really good with my mom.
Loved her?
What was that?
Loved her?
Yes, sir, very much.
What was your relationship like with your dad?
It was good.
Wyatt, have you ever gone shooting with your parents?
Yes, sir.
Can you describe that to the jury?
Went shooting probably two times with both my dad and my mother at the same time. We'd go to the ISP range on the weekends. And my mom would participate. She participated twice, I believe, and that's about it.
Where's the ISP range from?
It's off Old 95.
Okay. Kind of close to your house? Or to your parents' house?
Probably about 10 minutes away.
Okay. Now, at some point, was there ever an incident involving a gunshot within the house while you were there?
Yes, sir.
Can you explain that? And let me, I'm not asking for any statements or anything, just what you observed.
From what I observed, there's a round that came through the ceiling.
Objection, lack of foundation as to when this happened.
You can lay some foundation.
This isn't you're referring to. When did this happen?
Sometime when I was in middle school, I would say.
Where were you in the house?
I was downstairs in the basement.
Speaking of downstairs, can you describe kind of what the downstairs is like?
You have a bar area in the left corner, left closest corner, wood stove. Then you have a wood box that contains firewood. That's that side. Then the other side, you have a recliner, a couch, and another chair, and then a coffee table in between those.
When the wood stove is burning, is it loud?
Could be.
Okay. Depends on what?
I think it depends on the oxygen the fire's getting.
Okay.
Could be making like a whooshing sound.
Okay. Now, this incident you observed in middle school, you said you were downstairs?
Yes, sir.
What did you observe?
I observed I was sitting in the recliner. I observed a round that came through the ceiling, and it ricocheted and went somewhere, and that was about it.
Without saying anything that was said, did either of your parents address the round that was shot?
I believe my dad.
Objection, hearsay.
Can you say address?
Without, I'll just rephrase the question.
All right, I'll just say the question.
Without saying what they said, did anyone talk to you about that?
I believe my father did.
Now, growing up, did you guys go on trips?
Yes, sir.
Okay. As an adult, would you go on trips with your parents?
Yes, sir. A little different kind of trips, but yeah.
Okay. In 2020, did you go to Rorschach?
Yes, sir.
And who was there?
I believe my mom, dad, Michelle Lampert, Dean Lampert, my girlfriend Tiffany, my friend Caleb Peck. That's all I can remember at this time. There's probably a couple more though.
Okay. When did you get down there?
What was that?
Do you remember when you got down there?
I do not.
Okay. When you were there, did you notice any marks or bruises on your mom?
I did not.
Why? How did you find out about your mom's passing?
From my father.
Was that through a phone call?
Yes, sir.
What did you do?
I got dressed and then headed to Athol, to the residence.
Was there a viewing in this matter for your mom? Was there a viewing for your
Inside
mom?
the house?
No, I'm sorry. After your mom passed, was there a viewing in Coeur d'Alene?
Yes, sir.
What was your? Did you have contact with your mom's side of the family at that time?
Yes, sir.
Okay. Do you remember who all attended the viewing?
I believe it was my sister, grandparents, uncle, and then there was two other people. I think one of them was Sherry. I can't remember her last name. And Kendy, my sister's daughter.
Okay.
And then my father afterward, after they left.
Okay, we'll come back to that. But did you have any concern that there might be conflict if your dad showed up at the same time as other people?
Objection, relevance.
It's been irrelevant, so I'll overrule it.
Let me answer.
Yeah. Ask the question again.
Did you have any concern that there might be conflict if your father showed up at the same time as the rest of the family?
Yes, sir.
Do you know where your dad was while during the viewing, where the rest of the family was viewing?
He was across the road at Capone's.
After the family left, what happened? Can you tell the jury what happened after that?
My father walked over, and then we went into the viewing together with myself, my girlfriend, and him.
Did you stay with him the whole time?
Yes, sir. I believe so.
Did you attend the memorial down in Camia?
Yes, sir.
Did you, and at that point, did you still have contact with your mom's side of the family?
Yes, sir. I believe so.
Did you have any concern on whether there would be conflict if your father had shown up to that?
Yes, sir. I do.
Did you express that to your father?
Objection, hearsay.
Did you express that to your father?
Yes, sir. I did.
Were you coordinating the viewing service?
What do you mean?
Like, were you helping facilitate, put it together?
I can't remember if I helped or not.
Okay. Now, was there a time after your mom's passing where your dad had a yard sale?
Yes, sir.
Can you describe that?
It was his belongings, some of my mother's belongings. It's just typical yard sale. I didn't see it.
Were you present?
Yes.
Who all was present?
I believe it was myself, my father, Carrie Murray, my girlfriend's mother, and then whoever was visiting to buy stuff.
At that time, did your sister show up?
Sometime during the event, yes, she did.
Was there any sort of confrontation between you and your sister?
Yes, sir, there was.
Before your mom's passing, can you describe to the jury what your dad's normal demeanor was?
Hardworking, kind of like normal guy. I would describe him as, I guess.
Had you ever seen him cry prior to your mom's passing?
Not that I remember.
What about after?
Yes, after he did.
Did you see the ashes of your mother?
Yes.
Can you describe who Did you personally receive them?
Like the whole, yes, I believe I did.
The 100% of the ashes?
Yes, I believe I did.
And where did you receive them?
I think I either picked them up from where the viewing was held or my father gave me them, one of the two.
Okay. Did you give any ashes to your sister?
Yes, sir.
Did you keep some for yourself?
Yes, sir.
And did you give some to your dad?
Yes, sir.
Can you tell the jury what happened to the ashes? Well, let me rephrase. Do you know what happened to the ashes that you gave to your dad?
I believe he spread them out on the property, like more in the pasture area where all the animals and stuff that we raised lived.
Were you with them at that time?
I think I was, yes.
Can you describe that? I mean, do you know if you were?
I don't know if I was or not, sir.
Any further questions?
Councilman Allen?
Okay, let me ask you a question about the trip that you took with your parents to Divorce Shack in 2020, okay? You have to talk out loud because
Yeah.
it's all being recorded.
Yes, sir.
All right. On this trip, I think when you were speaking with counsel, you said that you didn't notice any bruising on your mom. Is that accurate?
Yes, that's accurate, sir.
Okay, so today in court, you're telling us you saw no bruising on your mom at Divorce Shack in 2020, in the summer of. Is that accurate?
I believe so, sir, yes.
Okay. Counsel, I'm going to refer to Detective Lyleton and Detective Wheeler's report, page 22. Give you a copy of that. May I approach the witness, Judge?
Okay.
I think you've seen this before, sir. Take a look
Yes,
at
sir.
that and get yourself acquainted with it. You've been asked questions about this particular interview before, haven't you?
Yes, sir, in the grand jury.
And you did so under oath like today, right?
Yes, sir.
Okay. Can you turn to page 22, please? All right, so on line 11, you were asked on, well, let's go to line 13. Sergeant Lyleton said the neck incident question, right?
Yes, sir.
And that followed a discussion about when you were down at Divorce Shack with your parents, right?
Yes, sir.
And there on line 14, you said, quote, "I don't know about that one. I just saw there was like a bruise and I asked her about it."
Yes, sir.
Line 16, Sergeant Lyleton says bruises on your mom. What'd you say there on line 17?
I said, yeah.
All right. So when you spoke with Sergeant Lyleton, that was quite some time before today, right?
Yes, sir.
Okay. I realize that wasn't under oath, but today you were under oath, right?
Yes, sir.
And so when you spoke to Sergeant Lyleton, was that the truth? Or when you spoke today under oath, was that the truth?
I believe today would be the truth, sir.
Okay, so you were not telling the truth to those detectives back when they interviewed you?
I possibly could have. I don't remember really what I said.
Well, you're looking at what you said,
Yes,
right?
sir. Yes, sir.
And so can you tell us why you wouldn't have been truthful with the detectives?
I cannot, sir.
You just weren't.
I guess so, sir.
Okay. On direct examination, you talked with counsel about going shooting with your parents before, right?
Yes, sir.
And you talked about, you said you went twice before, right?
Yes, sir. I believe it was twice.
Okay. Can you take a look on page 29 for us? The same document?
Okay.
On line 11, Sergeant Lyleton asked you, but did she shoot? Did you ever see your mom shoot that gun? What was your response on line 13?
I said I think we went out and shot. I do think we went once, and I know her and my dad went out, and they shot it too.
Okay. So again, same kind of questions. Were you being truthful then, or today when you testified under oath?
It could have been once or twice, I guess.
Okay. You're not sure?
I know she went out with us. Could have been once maybe, but I thought it was twice.
Okay. All right. Going back to the bruise from Dvorak, would it help refresh your memory if you saw that bruise again?
It could, I guess.
So right now you don't remember it, right?
No, sir, I don't really remember.
Okay. Well, maybe we can get to that real quick. Take up your time while. Let me ask you a couple more questions. Your dad didn't go to the viewing. You've told us today because he was scared of conflict?
Scared that there would have been conflict, yes.
Okay. Why?
Obviously because what the other family was thinking.
Why would that be obvious?
What do you mean, sir?
Why would it be obvious that there would be conflict?
Well, you have people saying that he murdered her, and you have other people saying he didn't. And if you all go to a funeral, I would assume that would cause conflict.
Why would people say he murdered her?
I can't tell you, sir.
Usually when someone kills himself, other people don't say that she was murdered, right?
I mean, it could happen, sir, yes.
It could. It usually doesn't it?
No, but it could.
Why on earth, in this particular case, would the issue of your father murdering your mom come up?
I have no idea, sir.
You can't speculate based upon knowing both of them and their history together?
Objection calls for completion.
It's the same.
You have your own personal feelings about that, don't you?
Yes, sir, I guess so.
And those personal feelings, do you think they affect how you're testifying here today?
No, sir.
You don't think that your personal feelings are influencing you to testify for your father?
No, sir.
You're not familiar with the evidence that this jury has heard in this case, are you?
No, sir.
I take it, I hope you haven't been watching this trial online.
No, sir, I haven't.
Okay. And so you don't know what the jury has listened to over the course of 2 weeks, I take it?
I have not, sir.
Would it matter to you what the evidence was in terms of your personal opinion about what happened or not?
Yes, sir, I believe evidence that does dictate opinions.
But yet you have this belief, this personal belief, without knowing that evidence?
Yes, sir, as of now.
Okay. You think you could change your mind if you heard all the evidence that this jury has heard?
Objection calls for speculation.
I'll have a question, which is going to his ability to be objective and reasonable. So I'll allow the question. So we'll-
Say the question again.
Would your mind be open to coming to a different conclusion if you heard the evidence that this jury has heard over the course of a couple of weeks?
Yes, possibly, sir. That's up to experts, not me.
Well, actually, it's up to people that are listening to the experts. They make that decision. This jury makes that decision, not the experts.
Objection, no question asked.
It's the same.
Would you be open to reassessing your beliefs after hearing all the evidence in this case?
Yes, sir, I believe so.
Okay. Can I approach your court, Judge?
Okay.
Your Honor, I'm going to have any objections to the prior witness.
I don't even know what we're after, so. Hold on.
Go ahead and stick 30 up on the elbow. That looked like your mom at Dvorak on July 16th, 2020 in the afternoon hours?
Yes, sir, the date would prove that true.
Help refresh your memory about the bruise on your chest?
You want to listen about looking at this?
I can't really tell in the photograph if there is or not.
Okay. So even though you talked about this before with Detective Wilth and Detective Whaler and you've seen this photograph, you don't remember whether or not she was bruised in Dvorak back in 2020?
I don't recall if she was or not.
Okay. So this yard sale that you had, your dad sold your mother's stuff, is that accurate?
And a lot of his stuff also.
Okay. So he sold her clothes?
I don't think her clothes were sold at the yard sale.
He sold her clothes, what, via consignment?
I believe it was bulk to a buyer. I don't know what buyer, but yeah, it's one person in bulk.
Your dad made some money off your mom's clothes?
I would assume that there was money involved, yes.
Okay. And then your dad sold what else of your mother's belongings?
I guess stuff that she bought from yard sales, glass chickens, maybe some other things I can't remember.
So possessions that she had laying around the house?
Yes, sir.
In addition to the chickens?
Yes, sir. They rented some other items too. Yeah. I can't remember exactly what they are.
Right. Did he sell other things of your mom's via consignment besides her clothes?
I don't recall.
Not sure?
Don't think he did.
Okay. So this yard sale then, was this at the house?
Yes, sir. It was.
Okay, and was it advertised in some fashion?
I believe there's a couple signs like out in front of the road and stuff like that.
Okay. You didn't put it in the paper, your dad didn't put it in the paper or something like that?
I don't remember if he did or not,
Okay.
or I didn't know about it.
Evidently, your sister found out.
Yes, sir.
And your sister came to the house she grew up in, right?
Yes, sir.
And found her mom's stuff being sold by her dad?
Yes, sir.
And did that include the glass chicken collection or not?
That was being sold?
Right.
Yes, there were glass chickens being sold.
Okay, didn't that get sold to somebody else?
Yes, sir.
Okay, so that wouldn't have been part of the yard sale.
Well, they were displayed at the yard sale.
But someone didn't buy them at the yard sale?
Yes, somebody did.
Okay. Her collection was bought at the yard sale?
Yes, sir.
Her collection was not bought by some other buyer?
I believe it was bought, the person that bought them at the yard sale was actually a part of the family. But yes, they were bought by somebody.
Okay, didn't Courtney Lambert attempt to buy that collection?
Actually, cost years ago. Outside school.
It is outside the scope, I'm not sure it's hearsay, but also objection. So the scope of that.
The yard sale's beyond the scope?
The Courtney Lambert buying the chickens and all that stuff.
Who's the buyer of the chickens?
I don't remember her name exactly, sir.
Was it Courtney Lambert?
No, sir, it wasn't.
So at this yard sale, Brooke wanted her mom's possessions, didn't she?
Yes, sir, I believe so.
And instead of giving them to Brooke, your dad called the police?
Yes, sir. He told her she was trespassing, so they didn't want her on the property.
Your dad told his stepdaughter she was trespassing on the property she grew up in at the time her mom's stuff was being sold? Is that what you're telling us?
Yes, sir.
Why?
Probably because she was the one that accused him of murder.
Accused him of what?
Accused him of murder.
So he was so your dad was upset at Brooke because she accused him of killing her mother. Is that what you're saying?
Yes, sir. They're probably both upset
And
at each other. So therefore, say my father was accusing her of trespassing when she showed up because he didn't want her on the property.
Okay, so I take it then, in order to get some payback, your dad sold your mom's stuff despite Brooke wanting it. Is that what you're telling us?
Objective cost speculation.
Sustained.
Why did your dad sell your mom's stuff if Brooke wanted it?
I believe he just wanted to get rid of it and get everything out of the house.
Brooke would have done that, right?
Yes, sir, she could have.
So again, why didn't he give it to Brooke?
I can't tell you, sir.
Let me show you a couple of documents. This one's 41B. Take a look at that, tell me if you recognize the glass chickens.
Yes, sir.
What do you recognize as glass chickens in the cabinet TV?
Glass chickens.
Kenny's, your mom's glass chickens?
Yes, sir.
You know because you saw them for many years, right?
Yes, sir.
Does that appear to you to be an accurate photograph showing her glass chickens in the cabinet inside your house?
Yes, sir, I believe so.
And the next one I have for you is 41E. Take a look at that, tell me if you recognize it.
Yes, sir, I do.
What do you recognize 41E to be?
Appears to be a Facebook advertisement of the yard sale.
And does it show a picture of the yard sale that you've been talking about?
Yes, sir, it does.
Is that an actual picture of the yard sale?
Yes, sir.
Move to admit 41D and E.
Any questions? I see you can. Yeah. Your Honor, read objected admission of the exhibits as they contain hearsay from other individuals not on the stand, not much before. Very good.
Yes, please.
Your response, Mr. Mayor?
Contentious is not the truth.
Well, the objection being hearsay, overruling the objection is these aren't statements that are offered for the truth of the matter asserted. So I'll overrule the objection.
Your Honor, is it possible to redact the wording in there? Just
Well, if the wording were hearsay, then I would agree, but these aren't word statements offered for the truth of the matter asserted, but rather it's like contract words or words of negotiation. So I don't know if it's offered for the truth of the matter asserted. So I'll overrule the hearsay objection.
To publish 41D. Okay, so 41D, sir, what are we looking at?
You're looking at the antique cabinet of glass chickens.
And is this one single antique cabinet of glass chickens?
Say that again.
What's that?
Say that again.
Is that just one cabinet?
Yes, sir.
And that would be the collection that Kendy had amassed over a number of years of glass chickens.
Yes, sir.
Something that was very important to her.
I would say so. She collects that much. Yes.
And this is the glass chickens your dad made sure would not go to Brooke or Ken.
objection.
Is that right?
Objection.
Sustained the objection.
Let's take a look at the next one. And again, if you wouldn't mind, sir, telling us what that's a photograph of?
It's a photograph of the yard sale.
Okay. And the objects that are out there, would that include your mom's clothing and possessions?
I believe it'd be possessions. I don't know if there's clothing or not out there.
That had all been sold previously?
I think it was afterward.
So just her kind of like knickknacks and things like that?
I believe so, yes.
And those were all sold to someone other than family that day?
I believe so, sir, yes.
Now, when Brooke tried to stop that, did you get violent with her?
Yes, she got in my face. I believe we were both emotional at the time. And yes.
What did you
I
do?
don't think it got violent, I would say.
What did you do to her?
I pushed her back with my hand.
The date of this yard sale, same date as your mom's birthday?
I believe it was. At the time, I did not know.
Do you know what your mom's birthday was?
No, sir, I can't remember off the top of my head.
But that yard sale was on her birthday.
Yes, sir, I believe so.
Thank you. No further questions.
Mr. Durham. What manner did Brooke arrive? Or describe the manner in which Brooke arrived to the yard sale?
Angry?
Did she drive or walk?
She drove there, yes.
Can you describe how the vehicle was coming into the driveway? Quick, slow?
Quicker than the average pace.
And how would you describe her demeanor?
Angry, emotional.
Yelling?
Yes, sir.
Is that when your dad made the statement about being trespassed?
Objection, Lee.
Sustained. Do you rephrase your question?
When did your dad make the statement about trespass?
Not too long after she arrived.
Was it after
there was some yelling.
Objection leading.
Sustained.
Can you describe the order of events from when she arrived?
I believe she came in the driveway, got out of the vehicle, started yelling. I believe she was on the phone. Then my dad then said she was trespassing.
Now, going back to counsel's first question, when you did talk to Sergeant Lallerton over there, is that right?
Objection leading.
That's foundational.
Rephrase the question. Steve.
Did you talk to Sergeant Lallerton, Detective Order?
Yes, sir.
When was that?
I can't recall, maybe a few weeks after my mother's death.
Still fresh with emotions at that time?
Yes, sir.
Then, when you remember counsel asking you about why would people think you did it, or he did it?
I'm sorry, repeat that.
Remember counsel asked you about why would people think you did it?
Yes, sir.
Were you aware of any aggressive conflict or opinions on your mom's side of the family?
Yes, sir.
Was that expressed quietly or loudly?
I'd say pretty loudly.
Posted on social media?
Objection leading.
Oh, rephrase. Was it posted on social media?
Yes, sir.
Just once?
Multiple times.
Just one day?
I believe multiple days.
Just by one person?
Multiple people.
At that time, well, you testified earlier. Remember, counsel asked you if you examined evidence and believed your dad did it, would you believe evidence? You remember something along those lines?
Yes, sir.
Okay. At that time, had there been any evidence presented to you?
Not really, no.
Had you testified at a hearing in this matter at that time?
Yes, sir.
You testified at the grand jury?
Yes, sir.
And counsel showed you some documents there?
Oh, yes, sir.
And when was that?
The grand jury?
Yes.
Beginning of last year sometime, I think.
And so in 2023?
Yes, sir.
Okay. Prior to that, had you been presented any evidence?
No, sir, I don't believe so.
Yet you kept an open mind?
Yes, sir.
Leading.
Did you keep an open mind?
Yes, sir.
In your interactions with your mom's side of the family, did you perceive that they were being objective?
Objection relevance and cause of
Sustained.
What was, did you interact, we talked about, counsel asked you about beliefs. Did you believe that there was conflict from your mom's side of the family?
Towards my father?
Yes.
Yes, sir.
Did you believe, based upon your interactions with them, that they had their mind made up?
Objection calls for speculation.
Sustained.
You remain objective today?
Objection leading.
Do you, rephrase.
Rephrase.
Did counsel ask you about the selling of chickens? Did you take that as a derogatory towards your mom?
Objection relevance to this witness's opinion.
Counsel, you objected when the state tried to ask that, I sustained the objection. So it's the same, I'm sustaining the objection here as well.
During the interactions at the art sale, did you have opportunity to observe your dad?
To what?
Observe your dad?
Yes, sir.
You interacted with him before?
Yes, sir.
After?
Yes, sir.
You loved your mom?
Objection leading.
Did you love your mom?
Yes, sir.
Did his demeanor to you express, what kind of feelings to your mom did his demeanor express to you?
Objection calls for speculation and relevance to this witness's opinion.
having trouble following the question.
All right.
I'll just name it.
The yard sale, did you take offense to the yard sale?
Objection, no, that's just a letter you take offense to.
Overly.
You can answer.
Can you repeat it?
Did you take offense to the yard sale?
No, not really.
Why?
I don't know, I just didn't.
Did, at the yard sale, did your dad get physical with anyone?
No, sir, he didn't.
Did you step in between, or like, did you play peacemaker?
I wouldn't say peacemaker.
You
No.
and your sister were in a disagreement?
Yes, sir.
Saying as the meeting and rest to not lead the witness.
Did you, were you and your sister in a disagreement?
Yes, sir.
I have no further questions.
Thank you, sir. Mr. Heron, I think you have a... Is that your last witness for today?
Yes, sir.
Well, members of the jury, as I told you before, I think that we are done for today, and we will take tomorrow off and be back Monday. So, thank you again for your patience. I know it's been a long day with a lot of in and out and we waiting while we discuss the things. So I appreciate your patience with that. I almost feel like I'm insulting you by saying it, but I really have to, especially as we go into the weekend. And I just remind you to stay away from any news, media. If somebody wants to talk to you about this case, tell them we can't, walk away. Don't have any discussions with anyone about this case. We're forming an opinion as concerns at this time. So, with a sincere thanks to the court, I'll release you for the weekend. Wish you well, and look forward to seeing you back Monday. Okay, we're in recess. Time to start back up Monday. Thank you all. briefs. We're starting up again, the state of Idaho versus Daniel Howard. I spoke with counsel from Chambers about a number of issues. Mr. Johnson, you did want to make a record regarding go ahead.
Thank you, Your Honor. It's a defense for us request to poll the jury after a 3-day weekend. Obviously, the media has covered extensively this alleged flight of Mr. Howard, who was following an individual who was there at the time of the arrest, returning a rental car. He was allowed to go to Spokane. He was not allowed to go within 2 miles of the airport. He had no bags in the car. He had his ankle monitor on. He had no tickets. He was not even in the airport itself. He was at the rental car exchange. Because of the media coverage and because of the assumption that it was flight, and because of the extensive amount of coverage, and particularly locally here, the defense is concerned that it could have tainted the jury's view on the case, even though they're instructed not to. So it's a defense request to pull the jury on.
Thank you. Response, Mr. Morgan?
Thank you, Your Honor. I don't think the jury should be polled, at least not yet. As the court knows, at least once a day, commonly more than once a day, that the court admonishes and directs the jury not to begin deliberations, not to discuss the case, and to basically not follow or seek information from the news or media outlets. And there, up until this point, including up until now, that there has been no proof or indication or any reason for anybody to suspect that the jury has disregarded the court's orders. I think the court should be trusting of its orders. We live in a small world. The internet, social media, we're all connected, and there's been nothing from this jury to give anybody here any reason to suspect that they can't be fair and unbiased, even if they have seen something in the news. And so I don't see a reason to break from what's been the normal flow of the trial. Thank you.
Thank you. Well, I did speak with counsel in Chambers about this, and as I indicated in Chambers, I'm not inclined to poll the jury at this time. I have instructed this jury daily not to discuss this case with anyone else. I've instructed them specifically, particularly before the start of the weekend, to avoid news coverage, to not view any news coverage. And I trust that my instructions and orders to the jury are being followed. I believe just from my experience of the last couple of weeks, I think nearly every day there has been a news story or coverage of this case online, in newspapers, YouTube, on TV. So coverage, news media coverage has been extensive, which is why I advise this jury to avoid any news sources, and I trust they're following the court's instructions.
Okay, guys. So, yes, I understand the defense counsel. I was reading the captioning. Sorry. I was on the phone with a client. I couldn't stop. Yes, there's obviously the defense attorney brought up. Well, there's all kinds of media coverage right now. Self-induced, I would argue, from the state. But I do think, that there's nothing they can do at this point. Just they told the jury don't listen, and hopefully the jury doesn't listen. That's all you can really do at this point. All you can really do. So, he was arrested at the Spokane. And guys, if you didn't understand, he was arrested at the Spokane International Airport. We already did the math on that. It's an hour drive from Athol, Idaho. It's an hour drive. It's 59. It's like 59 miles. So why was he at the airport? Even within 2 miles of it. He was told to stay away from there, and he didn't go there. There's no reason for him to be there. The judge is watching my streams. What? That's you? What did he say is me? Well, yeah, he knows that it's been getting coverage. Yeah, it's all quasi. Yeah, him and Fat Trick are causing the problems here. But, yeah, so we're getting into day 10. We're going to finish this up. So let's go. Let's go, chat. Let's go.
This jury is a particularly attentive and conscientious jury. It was, I believe, the first day of trial or the second day of trial that we lost a juror and excluded a juror after having had some contact with one of the attorneys. And I think that impressed upon this jury the significance of following the court's rules. In fact, on a couple minor occasions, witnesses have heard. Once when a juror had some recognition of a witness, another when a juror had some business affiliation with a company that was referenced, brought that to bailiff's attention, addressed those issues with the jury. There was no concern. There was no inappropriate connection. But even in these minute, unrelated areas, the jurors brought it to the bailiff's attention, to bring it to the court's attention. I say that because I just know this is a jury that has been very conscientious about following the court's orders and remaining impartial. And so I spoke with my bailiff this morning, indicated nobody has made any references to him or made any comments about anything. And I don't see a need to now hold the jury because there was coverage this weekend. Again, there's been coverage last weekend as well of this trial. There's been extensive coverage of this trial, and I am confident that the jury is following the court's instructions and is fulfilling their duties as they ought. So I'm not going to go into the old ones. But we did want to make a record. So Mr. Johnson, your record has been made and preserved. So thank you. Anything else before we bring in the jury?
Not for official.
Moving on. Okay, let's bring in the jury. Hope you had a good weekend. And we're back on record now for trial.
So 2.0 told me that there might have been an issue of, oh, he was returning a rental car, and like, bruh, shouldn't have been within 2 miles of that place. You knew better. Shouldn't have done it. Shouldn't have done it. Well, it's going to cost me money. It's like, I don't want to go to jail. So, yeah, this is just stupid. That was stupid. Stupid work by Howard. So, oh well, let's keep going.
Mr. Johnson, you may call your next witness.
Chet Gilmore.
Chet Gilmore. Good morning, sir. Good morning. Please step forward and face my clerk and raise your right hand to be sworn.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You're welcome to have a seat there in the witness stand. And as best you can, if you would speak into the phone.
Yes, sir.
I'll let you get going.
Do they not have water in this county? Is there an issue with like they don't have a lot of wells, or like it's like sub-Saharan Africa? Like, oh, we can't drink. Like, it's like, oh, I just walked like 2 miles through the courthouse. I need refreshment. I am parched. What is the deal with everybody grabbing a drink of water here? Is it the altitude that makes you dry, or what?
You may inquire, Mr. Johnson.
Thank you, John. Good morning.
Good morning.
Can you please state your name and spell your name for the record?
My name is Chet Gilmore, Gilmore, Chet, Chet.
And where do you live?
I live in Spokane, Washington.
What do you do for work?
I'm a private investigator,
And how long have you been a private investigator?
about 10 years.
Can you briefly explain to the jury your training and background?
Well, I had a 25-year law enforcement career. That was in Spokane. So I did all of the normal learning to be a policeman training, and spent about 14 years as a major crimes investigator. So myriad of various trainings to do with homicide, evidence collection, everything you can think of probably to do with a major crime investigation. And then, so after 25 years, then I retired from Spokane and became a private investigator. And during the course of that, I've done civil investigations, family investigations, but the majority of my work has been involved in criminal defense investigations. And really, the whole gamut of types of criminal allegations.
Did you have an opportunity to participate in the investigation of Mr. Gilmore?
Of Mr. Howard, yes.
Oh, sorry, yes. Did you review discovery in this matter?
Yes, I did.
In general, what did that include?
Oh, it included much documentation, paperwork, officers' reports, evidence reports, a lot of photography, a lot of videography, both from officers, body-worn cameras, and purposeful cameras at the scene to document the scene.
Okay. Now, when dealing with photos, is there a way that you can look at properties of a photo and determine when those photos were taken?
Sure.
Can you explain?
Well, a photo has not just a visual photo of what you can see, but there's data or metadata that is embedded within the digital data of the file that you can open up and look at when it was last modified, but also when it was taken, when the photograph was taken, as long as that hasn't been stripped from the photo in some type of a transfer process or something.
Okay. Did you have an opportunity to look at photos taken by Deputy Wheeler?
Deputy Wheeler, yes.
Commissioner Potron?
Yeah.
In looking at,
For the record, chat, I only say this now for the record. If I have to testify in a trial ever, where it's not me on the line, but I come in as like a bit part, I will intentionally not drink the water. I will not drink water all noisily on screen. It's my promise to you. Yes, he's signaling the crypto Nazis.
did you have an opportunity to look at the data or metadata for the photos for Deputy Wheeler?
Yes.
Were you able to determine a range of when he took those photos?
Yes. I made some notes. Can I bring that out so I have the right time?
Would that assist you in your answering this question?
Yes.
Your Honor, permission for Mr. Gilmore to review his notes?
If he needs to refer to his notes for your questions, then bring them.
Okay. And your specific question is?
What is the time frame that Deputy Wheeler took his photos while he was on scene?
What I made note of was the time that he took photos that included the bathtub area of the scene.
Okay.
And that time frame is February 2nd, 2021 at 11:24 p.m. until February.
I'm an objection to reading from the document that hasn't been admitted into evidence.
Were those your notes you were looking at to refresh your memory?
These are the notes that I wrote down when I was looking through the photos and checking the metadata on the various photographs.
Oh, so I'll ask you not to testify from your notes. So it's from
Okay.
your memory.
Sure.
Have you had a chance to refresh your memory on Deputy Wheeler's photos?
Yes.
And what was the range, time frame?
The beginning range was 11:24 p.m. past midnight to 12:29 a.m.
May I approach witness, Your Honor?
You may.
The question was admitted as State's Exhibit 16G. Do you recognize that photo?
I do.
Is this one of the photos that was taken by Deputy Wheeler?
Yes.
And that would fall within that time frame?
Pardon me?
That would fall within that time frame?
Yes, it would.
Did you also have an opportunity to review photos taken by Detective Northrop?
Yes, I did.
Were you able to identify a time frame of when those photos were taken?
Yes, I was.
Do you remember what they are?
Yes.
And what were they?
It's spread out over a longer period of time. At the very beginning of those photographs that actually showed the bathroom tub area was at like 6:03 a.m. on the 3rd, February 3rd of 2021. Those were a little bit distant because they looked like they were from the doorway, so you didn't have much clarity. Once the photographer moved closer and started taking photographs, that was at 6:05 a.m. And then the officers appeared to be there for several hours, and there were a series of different times when the photographer would come back to the bathroom. And it's kind of hard to tell exactly where the break is from what's in the tub and when the decedent may have been removed from the tub. But the ending photographs all the way up until there was a body bag was in the afternoon. Looks like, excuse me, not afternoon, it was in the morning, 2.5 hours later, almost 3 hours later, 8:58 a.m.
Were you provided autopsy photos in this matter?
Yes.
How many autopsy photos were taken?
There were numerous autopsy photos, 200, a little over 200, I believe.
Did you have an opportunity to review photos taken at the morgue or after?
At a later time?
Yes.
Yes, a few days later.
When were those taken?
Those were taken on the 5th of February.
Okay. Were you provided any information as it relates to Mr. Howard's phone?
Yes?
Did you have an opportunity to look at the call record as it relates to the morning of the 3rd?
Yes?
Permission to approach, Your Honor?
Amen.
You handed you what's been marked as Defense Exhibit I. Do you recognize that document?
Yes?
What is it?
This is a section of the CDR, the call data record, of the data extraction from Mr. Howard's phone,
Okay.
cell phone.
And is that an accurate copy?
Yes?
Move to admit Defense Exhibit I.
Any objection? No objection. Defense Exhibit I is omitted.
Who was the first phone call that Dan made on that exhibit?
On the 3rd? The time showing, well, the first phone call was made to Brooke.
Okay. Were there multiple calls made to Brooke on that day?
Yes.
And was there a call made to Wendell Wilkins?
Wilkins? Yes.
Okay. Does it appear that it was answered?
The Wilkins one appears not to be answered by the length of time on the photo, on the
Did you have an opportunity to
We'll talk about this
examine
later.
the physical evidence in this matter?
Yes.
Can you explain how that came about?
Mr. Johnson made arrangements with the Sheriff's Department and Prosecutor's Office to have me and him go to the Sheriff's Department and look at evidence, various evidence that had been collected for the course of this investigation.
Did that evidence contain a vacuum bag?
Oh, yes, it did.
What was the state of the vacuum bag when you observed it?
Well, it was a whole bag, appeared to have contents within it, within another bag, for preservation purposes of the contents.
Had the vacuum bag been opened prior to your observation?
No.
And then, did you have opportunity to look at any physical evidence as it relates to GSR?
Yes.
And can you explain?
One of the pieces of evidence that we observed was a gunshot residue, a GSR kit that had been collected from the decedent at the time of autopsy. The sample had been collected at the time of autopsy, and then the sample was tested for gunshot residue.
Okay. And what was the state of the, did you have another gunshot residue evidence in property?
No, that was the only test kit.
Okay. May I have permission to approach, Your Honor?
You may.
And what's been marked as exhibit, defense exhibit H1 and 2. Do you recognize those photos?
Yes, I do.
And were you there when those photos were taken?
Yes, I was.
Is it a true copy of what you observed?
Yes.
Move to admit defense exhibit H1 and 2.
Any objection?
No objection.
H1 and 2 are written.
What is that the, when you say testing kit, is that the gunshot residue kit that came back from autopsy?
Yes.
Permission to retrieve exhibit, Sean? Thank you, Mr. Gilmore. I have no further questions.
Thank you. Any cross-examination?
Being a former police officer, you would know that the Washington State Crime Lab doesn't test for GSR, right?
I think they do on special requests, is my experience.
Would you be surprised if your answer was contradicted by another witness in this case earlier on?
Well, in my experience, which ended there about 10 years ago, there were times when they would do it if there was special requests for certain reasons. That's my recollection.
From 10 years ago?
Yes.
So you don't know if they still do that or not?
Correct.
And are you aware that most crime labs, state crime labs throughout the United States won't test GSR?
Yes.
And that's because it's not good science, right?
I believe there can be a lot of false positives.
And so it doesn't do much good, does it?
Oftentimes, it has its definite shortcomings.
Okay. Which way, there was no point in this case in doing it, was there?
Objection calls for speculation. Sustained.
You said there were about 200 autopsy photos?
Yes.
Are you sure about that? Did you overestimate that?
I can look at my notes and tell you what I wrote down.
Can you look at your notes and see if there were only 129 autopsy photos?
Yes, that's correct. I was counting a different set of photographs.
So 129 autopsy photographs?
I have
Not 200?
I have 129 photos.
All right. This vacuum bag that you saw in evidence, this didn't have any evidentiary value, did it?
Well, it was certainly collected to see if it had evidentiary value in it. Oftentimes, you collect things to see if there's anything that might support or negate assumptions or possibilities within an investigation. So
I
you
get
don't
that,
know.
but this bag didn't have anything of evidentiary value, did it?
Do you mean after it was looked at?
When you looked at it, it didn't have anything of evidentiary value, right?
By the end of the examination we did, yes. At the beginning, you don't know.
You were free to look at all the evidence in this case, right?
Yes.
You were free to read all the police reports, look at all the photographs, all the videos, right?
Correct.
And assist in the defense of this case in various ways, right?
Correct.
And I assume that you spent many, many hours doing this?
Yes.
How many?
I don't know.
Don't you keep billing records?
I didn't keep billing records in this case because it was billed as a retained case with a certain fee for the entirety of the case.
You mean a flat fee?
Correct.
What was the flat fee?
Objection on all those.
Goes to bias?
No. Witness can answer. Overrule.
$10,000.
Does that include your time here testifying today?
It includes it.
Did you retire from Spokane?
Yes.
No further questions.
Thank you. Any redirect?
Yes, Ron.
So counsel asked you about evidentiary value. Was anything found in the vacuum bag other than hair and dirt?
No.
No glass?
No, that was one of the things we were specifically examining for, to see if there was anything like broken glass that would speak towards one of the, what appeared to be proffered within the police investigations as a possibility of evidence.
So the absence of glass could have evidentiary value. Is that true?
Objection, lady.
Sustained.
Is there any evidentiary value in the absence of glass?
Yes.
And what would that be?
It would show that
I'm going to object. I think this calls for speculation.
Or he was a major crimes detective. I think he's qualified to answer.
All I wanted to answer as to what his perception of the evidentiary value would be.
given that there was some glass fragments that were collected by law enforcement at the scene, and there was a, at least my presumption was a vacuuming is done to see if there is more glass fragments to show that there's been a cleanup attempt by somebody, cleanup of potential evidence, that type of thing. And so in that examination of the vacuum bag, there wasn't any evidence that we could find sifting through it that there was broken glass in there. So I guess that would negate that one, that particular assumption or speculation.
Counsel asked you about your flat fee in this matter. When did you start working on this case?
I started working on the case shortly after the incident occurred in February of 2021.
So for 3 years you've been working on this case?
Objection, lady.
Sustained.
How many years have you been working on this case?
3 years.
Okay. And your was your flat fee $10,000?
And I need to make a correction. When I first started on the case, there was an hourly fee. And I believe for that first section of investigation, I think it was $1,600 maybe, I believe. And then you approached me for a flat fee for just the remainder of everything that might need to be done during the course of investigation, and that was the $10,000.
Okay. No further questions, Ron.
Thank you, sir.
Yeah, $10,000 for 3 years worth of work. That's pretty. This guy probably did that work and then some.
Thank you, sir.
I still think it should be improper for them to ask this, because otherwise, as a defense attorney, how much do you make a year? You know, do you have performance reviews? If you turn in a lot of things saying, "Up, guy's innocent, guy's innocent, guy's innocent, guy's innocent," how long are you gonna have that job? I would immediately get admonished for that. So I think it's bullshit. They can go into how much the expert gets paid.
I still have a couple minutes.
We spoke in chambers earlier, and I'm trying to capture it, but I'm going to let parties make their motions too. Mr. Johnson's next witness is the defense expert witness who created a detailed report that was provided to the state, but provided to the court as part of the motions. In that, he had a number of photos and scenarios that the expert outlined. And then, as I understand, and counsel can correct me if I'm wrong, but the state today, this morning or last night, this morning was provided with new photographs as well as a couple new animations that the expert had just provided to defense and was intending to present. And so the state was objecting to that and asking for exclusion as they weren't aware of these and weren't ready to meet them on cross or in the and the defense was arguing that these were essentially, I think, Mr. Johnson, you're saying that you thought was consistent with the report, but ultimately, I indicated I thought it was too late to spring that on the state this morning. I indicated the witness was still welcome to. These were animations of a person's arm in the position of Ms. Howard, as the defense would put it. Indicated the witness is certainly welcome to show the jury whatever he wants in his own movements, and he can testify from the stand, but as to providing these animations and new photos of this too late, it's prejudicial, and I think it was appropriate to allow that. Mr. Verheer, I don't know if I've accurately stated the state's objection. Mr. Johnson, I don't know if I've accurately stated your response or if there's anything you want to put on the record.
No, Your Honor, I just need a few moments to go. I have maybe corrections I just need to go meet with the state to make sure.
You say no, Your Honor. Have I accurately stated your objection?
Yes, sir.
Okay. But there's nothing further you want to put on the record?
No, Your Honor.
Got it. Okay. Did you need just a minute?
Just a couple minutes just to confer with the state, Your Honor.
Let's see. Does anybody need like a patent break or anything, or just a couple minutes?
Sure, Judge.
Why don't we take 5?
All rise.
This expert thing, let's see what that turns into. Let's do some time traveling, guys.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth,
This should be good, chat. Here we go.
and nothing but the truth, so help you God?
Thank you. Thank you, sir. You guys see that? Best you can, if you would speak to the mic.
Will do, thank you. Is that good?
United Park.
Thank you, Your Honor. Good morning.
Good morning.
Doctor, can you please give us your name?
Jeffrey Thor Damelin, last name spelled Desmoulin.
And how do you spell Jeffrey?
Geoffrey.
Where do you live?
Vancouver, Canada.
Doctor, what do you do for work?
I am a professional engineer, and most of our work involves litigation support through forensic engineering. We also teach. In fact, I was supposed to be at ILETA this week, which is the International Law Enforcement Educators and Trainers Association, teaching a course on biomechanics from video.
Okay. Can you tell the jury a little bit about your educational background?
Sure. I have 4 degrees. The first one being in kinesiology, which is the study of human movement. So you're going to see a lot of that today. I specialized in biomechanics in that degree, but also had several undergraduate courses in anatomy and physiology. I went on to do a master's degree also in kinesiology, specializing in biomechanics, but as part of that degree, took courses in neurophysiology, and then went on to do a second master's degree at Wayne State University in Michigan, specializing in injury biomechanics, so the tolerance of the body and how engineering parameters are used to predict injury. And then finally ended up with a degree in mechanical engineering at the University of Calgary, also specializing in tissue injury and repair.
Have you had any publications?
Yes, I publish regularly, both in scientific forum and non-scientific forum. I think we're above 40 for scientific forum now, and likewise, similarly for non-scientific forum, i.e. magazines, etc.
Okay. Permission to approach, Your Honor?
Right.
Thank you.
Doctor, I've handed you what's been marked as Defense Exhibit J. Do you recognize that?
I do.
And what do you recognize that to be?
I recognize it to be my current CV.
Your Honor, move to admit Defense Exhibit J.
Any objection?
None, Judge.
Defense Exhibit J is admitted.
Permission to approach, Your Honor?
Right.
Welcome.
Doctor, can you briefly explain what biomechanical engineering is and what it entails?
Sure. It's the understanding of mechanical principles applied to a biological system, and in this case, humans.
Okay. Have you had an opportunity to review this case with your biomechanical engineering perspective?
Yes, sir.
Permission to approach, Your Honor?
Okay.
Doctor, I'm going to show you a series of photos. Just let you know, or let me know if you recognize these. This is Defense Exhibit K1. Do you recognize this?
I do.
K2. Do you recognize this?
I do.
K3. Do you recognize this?
I do.
K4.
Yes, sir.
K5.
Yes, sir.
K6.
Yes.
And K6, for the record, has been redacted. You see that?
I understand.
And K7.
I understand, but I also understand that the figure on the left is in the report.
Okay. All right, and so K7 has also been redacted.
Okay.
K8, do you recognize this?
I do.
And for the record, this has also been redacted.
Okay.
K9, you recognize this?
I do.
And this has been redacted.
Okay.
K10, same thing. Do you recognize this?
I do.
With redaction. K11, do you recognize this?
Yes, the results of one of our simulations.
Okay, and this has not been redacted.
Okay.
K12, do you recognize this?
I do.
K13, do you recognize this?
As a summary of our results, yeah, it's biomechanical results.
K14, do you recognize this?
As a separate test of blood pooling, yes.
And then K15, do you recognize this?
I do. That's a video that we provided with the report.
Are these portions of what went on to a PowerPoint?
Yes, sir.
And do you recognize what's marked as K17?
Yes,
And is that your initials on
it is.
it? Would referring to this information with the redactions noted, but would this assist you in your testimony today?
I think it will assist the jury in understanding what we've done, yes.
Okay. Your Honor, move for admission for demonstrative purposes only, K1 through 15 and K17.
Any objection?
Judge, may I confer with counsel for a moment? No objection.
K1 through 15 and K17 will be admitted as demonstrative exhibits. if you'll be able to see from where you're seated. So if you need to step out into what we call the well, you're welcome to do so.
Thank you, sir.
And permission to approach him.
Good?
Dr. Contentious, I don't know how it'll show up on the screen, but here's a pointer.
Thank you.
Now, what is the investigatory process?
Okay, so the purpose of this investigation was to see if biomechanics could rule out suicide. That was the goal, eliminate the possibility of suicide. And so what you're seeing here in this first process flow, or the investigative process, is a published process in which to approach an investigation such as this. It was published by myself and a former professor of mine, Dr. Theodore Milner, in scientific forum. It's also been published several times in non-scientific forum, and it's dictated the process in which I followed to come to our conclusions. And so if we start with defined injuries, you'll see that it says from autopsy report, and that would be Dr. Howard's autopsy report with his cause of death, and relying on that. Moving forward, we're talking about defined dynamics. This wasn't captured by video. We do have witness statements from police officers as to her final resting place. We also have many scene photographs over several time periods, and we relied on that, especially her final resting place, as we'll get into in a minute. The analysis was based primarily on biomechanical modeling, as you'll see, but also a multitude of published literature and a full incident reconstruction of the event. We moved on to discuss how using these results were consistent with independent information, and then made our conclusion.
Okay. In your analysis of defined dynamics, were you able to observe any information from faro scans?
Yes, sir.
And can you explain what a faro scan is and how you relied on that faro scan?
Sure. A faro scan is a distance measurement machine on steroids, if you think of it that way. It's collecting many points per second, and it does that in 3 dimensions, and it gives you a 3-dimensional representation of a scene that is accurate in dimensions. So we were able to understand the dimensions of the tub itself, and then use that together with our biomechanical analysis of the known height and weight of Kendy.
Okay. And did your analysis in this case involve research?
I'd say there was a literature search that would assist, that would be helpful for you to understand. There was research on biomechanical modeling and an incident reconstruction of the event.
Did your research inform you as to any significance of intraoral gunshot wounds?
Yes, there was a paper, Schmidt, or Kendar 2022 actually, that analyzed intraoral gunshot wounds and found that the trend was most of them were suicide.
Okay. Did you have an opportunity to review trajectory in this case?
I relied on Dr. Howard's interpretation of the trajectory. We also found photos from the autopsy useful in interpreting this, and also Dr. Nara's description of the trajectory was also helpful in the sense that it was horizontal to slightly downwards.
Okay. And did you examine the position of the body?
Yes. That was detailed carefully because we're working backwards from this moment in time with our biomechanical analysis. Specifically, we focused on the position of the arm, the orientation of the arm. What I mean by the orientation is hand up or hand down. And also the position and location, or I should say the position and orientation of the gun itself. So right-hand side of the body and the barrel pointing towards her head. That became important in our analysis.
Okay. What is, what did you look at as far as it relates to the firearm?
Well, we started there because that's the initial input to the hand as a system, as a mechanical system. And so we needed to know or understand the overall weight of the gun, where that weight is centered on that gun, the effect of its overall momentum. So we have a bullet that is published as being 90 grain in weight, moving at 1,040 feet per second. That gives us a momentum that occurs over 1 millisecond, and that gets the mechanical system moving, if you will. We also considered the slide movement and what effect that might have, either on the teeth or the hand itself, if it's being held with two hands. And then, of course, the trigger weight became very important. And what I mean by trigger weight is the amount of force you have to apply the trigger to actually discharge that firearm.
How did that become important to you?
Because there's lots of strength studies on index finger strength as well as thumb strength, and it changes depending on wrist angle. So ergonomically, there's a very specific way that you'd have to hold that firearm in order to match that trajectory and pull the trigger at the same time. What these studies are showing is that any wrist angle over 20 degrees is too much to be able to press 5 pounds with your index finger. And most of the positions were greater than that. In fact, they were closer to 60 degrees wrist flexion. And that actually allowed us to rule out the use of the index finger to discharge this weapon.
Now, we'll come to this again, I'm sure, but
sure.
You mentioned most of the positions. Can you describe what you're referring to there?
Sure. There was many considerations. One was the use of the left arm, but if that were the case, the gun would have ended up on the left-hand side of the body, so we were able to quite easily rule that out. Again, the goal being to eliminate the possibility of suicide. Because the gun was found on the right-hand side, we focused on right hand and both hand scenarios. From there, we considered Kendy's stature with respect to the bathtub and what would be a natural position for her to be sitting there in. One is a sitting position and one is a reclining position. And then various positions from there, as you'll see in our results section.
Doctor, what is ergonomics?
It's the study of how humans interact with their environment. Specifically here, we're looking at strength requirements to perform a task. This task being depressing that trigger at least by 5 pounds. We are forced, that position is dictated by the trajectory and the positions and ranges of those joints. As I mentioned earlier, Lee 2002 found that any wrist postures flexion greater than 20 degrees was impossible. It was not possible to depress with your index finger a 5-pound trigger, so we were able to rule that out. However, in IMRUN 1991, looking at various pinch tasks, which is really measuring thumb strength, we were able to see that in various wrist positions, we would have enough force there to depress that trigger above 5 degrees. And so the focus became ruling out index finger positions and starting to focus on thumb trigger pull positions.
Now, what if the index finger is strong enough? Did you look at that?
Then it would actually increase the number of scenarios that would be consistent with suicide.
Okay. Did you examine the effect of recoil?
Yes, sir.
And can you kind of explain that?
Sure. So as I mentioned before, the transfer momentum from the gun to the hand applies a force to that hand. And the line of action of that hand, the line of action of that transfer momentum is along the barrel. That's what the assumption was. And it lies just above the hand itself. And so in that position then, the only thing that can happen with the wrist is supination. That's what this motion is here. And you can even just try it yourself by pushing on your first knuckle there. You'll cause an opening of your hand. And that became important to rule out many scenarios.
Okay. Did you have a chance to look at flexation? And, well, let me back up. What is joint axis and how did you test them?
Right. I think what this slide is getting at is the axes that were tested. So for example, we limited it because the majority of the interaction with Kendy's arm after the discharge of the firearm would be gravity. We limited the axis of the shoulder into flexion extension, so in line with gravity. Did the exact same thing with the forearm, but the wrist we considered pronation, supination in isolation, i.e. it would be controlled by the input from the revolver. And then we also considered wrist flexion extension in our model. So those were the axes that we considered to move from a starting position to her final resting position.
Do you have any, how many scenarios did you examine?
We considered many, but we simulated 10.
Okay. And on that, when you say simulated, can you walk through what you mean by you simulated scenarios?
This is a mathematical model. It's not a graphic artist's rendition of what they believe to have occurred. This is physics driven, and so what you're seeing here, this is one of our scenarios results, and this is a situation where we had Kendy reclined and holding the firearm with two hands. And so what you're seeing here, the green line, is in fact the gun hand complex, okay? And you can see it slightly flexes, slightly extends as it moves throughout the motion. The first blue line represents the forearm, and the second blue line represents the upper arm. And it's important to note that the gun shape there is giving you the consequence of that model. So where does the barrel point when it gets to the bathtub floor? And is that associated with any supination? As I said before, so you can think of supination as holding some soup in your hand. It's open. In this case, that supination torque was actually canceled because we've considered both hands being on the firearm at the same time, and therefore the hand remains in a neutral position as it falls to the bathtub floor. But this would be a very typical simulation result, and we'll get into what those results mean in a table in just a moment, and what we've considered with each of them.
Did you look at or review any marks on Kendy's hands?
Yes. There was a linear laceration to her left hand, and in some cases, when you're not always aware of exactly where your fingers are in three-dimensional space and you discharge a firearm, you get what's called slide bite. And so this linear cut could have been caused by slide bite.
Objection, lack of foundation calls for speculation.
Overruled.
Okay. Did this also serve to rule out other possibilities? Ms. Mark?
Again, the idea was to eliminate suicide as a possibility, and so we used this slide bite mark as a way to do that. So if we did away with the slide bite mark as being a possibility, then we'd actually add to the number of scenarios that would be consistent with suicide.
Okay. Now, did you put your, you said you considered many, but you modeled 10 scenarios?
Yes, sir.
And did you put that in any sort of visual representation?
The results we did.
Does this explain that?
It does.
And feel free to move about and explain to the
I
jury.
was going to say, I think this would be a good time to do that. So just starting on the left-hand side here, what I'd like to explain is we started with overall gross body posture of Kendy's final position, and we considered both a sitting and a reclined version of that. Okay, so that's what the S and R mean.
And doctor, real quick, just so you know, that is a touch screen, so.
Oh, I'm sorry. I'm bad with touchscreens. I'm a Mac guy, but anyways, gun orientation. So this is the gun orientation at time of discharge. Okay, so we considered a vertical position as well as a horizontal position of the firearm. When I went to the hand, as I said earlier, we eliminated the left hand being involved because that would have caused the gun to be located on the left-hand side of the body. And that's pretty clear in the evidence that it didn't happen, so we did not consider it. But we did consider the both hand scenario as I motioned to before. The trigger finger, we considered index finger as well as thumb discharge. And then how did these scenarios align with the evidence? So if we can just go through these one at a time. So here we have sitting, vertical, gun orientation, right hand index finger. We were able to eliminate this primarily based on trigger pull force, but also because it's single-handed, we would not have seen the slide button. And so you can see every condition in which we consider the index finger has been eliminated based on that ergonomic data that I showed you earlier. Just going down one row, we see sitting posture, vertical gun orientation, right hand and thumb. And that is consistent with everything that we see documented at the scene, except for the slide bite. So as I mentioned earlier, if we get rid of the slide bite, we actually add scenarios that are consistent with suicide. So that's the approach here. And so if we look at trigger pull force, you can see we eliminated based on index force strength, based on arm position, for arm, upper arm that is, landed on the right hand side in the same position in all cases. The arm orientation, interestingly, in the sitting condition, there was enough time, even though we had that supination occur at the discharge of the firearm, there was enough time that after her arm interacted with her thigh to settle into a more neutral position as found at the scene. Also interestingly, in the reclined position, there was very little time for the hand that was now supinated to make its way back into a neutral position after the elbow had touched the bottom of the tub. So in the reclining position, the elbow hit the bottom of the tub first, and then there was very little time for the forearm to correct itself, if you will. However, in the condition where both hands, where both hands are held on the gun, that doesn't actually happen because when that firearm is discharged, it cancels the supination torque, keeping the right hand in a neutral position, allowing it to fall into the neutral position found at the scene.
Okay. So, in this also, did you talk to us about what you found as far as evidence on blood on the face?
Sure. So what you're seeing here is photographic evidence from the scene. This is a completely separate question that I was asked. And the question was, if blood had pooled into matted hair, could it cause a skin stain that appeared to, in an upward movement, to quote unquote, move against gravity, if you will. And so these were the two photographs that we were working with. The first one being at the time of Officer Wheeler's photographs, and the second one about 7 to 8 hours later when the coroner arrived. And you can see that there's some water that has been draining over that time period.
When you're looking at that line, did you, would head movement after death impact that?
There's many factors that would affect this. One of them is, I think head movement can't be ruled out as being a possible cause of this.
Okay. And such as if someone were to check for a pulse, head movement there?
Correct.
Objection to leading.
What's an example of something that could cause head movement?
Checking for a pulse.
Now, can you give us, did you do any experimentation with blood?
We did.
Can you explain that a little bit?
Sure. So to test that question, or to answer that question, if hair is matted against the cheek and there's bleeding into that hair, could it cause a skin stain that has an upward curvature to it? What we did is we took sheet blood, ordered from the government, which is the forensic standard, to do that. You warm it to 37 degrees Celsius so it maintains appropriate fluid flow, etc. And we used human hair against pigskin to test this result. And if you go to the video, you'll see a summary of exactly what.
Well, let me ask you about that.
Sure.
In your testing, did you model it with video? Or not model it, did you capture a video of your test?
Yes.
Okay. And is this depicted here?
Right, so we're calling this blood accumulation on skin in a water basin test. Here's the injection shown with time lapse, 12 times the speed it actually occurred. So there's the bleeding from the mouth into matted hair on the skin. It's a little choppy, but you get the idea. I think what's important here is the settling of the blood on the bottom of the basin.
So the blood didn't taint the whole water?
Objection leading.
Sustained.
And what I mean by settling, the blood
Objection,
settling.
there's no witness. No questions. No
Okay.
witness.
That's right.
Can you, let me go back here, can you walk us through, let's just back up this first experiment, or first portion of the video. What are you showing on this first portion of the video?
This is just the like how we simulated bleeding into matted hair on the skin.
What happened to the blood when in your testing?
It settled at the bottom of the basin.
Okay. And when it changes, can you describe what we're looking at?
So here's the ejection of the blood, simulating bleeding from the corner of the mouth into matted hair. Here you're seeing the draining over time, that 7 to 8 hour period between the photographs. And then a reveal once the hair is removed as to what the skin stain actually looks like.
Now, after your analysis, did you reach an opinion?
I did.
And what was that?
The opinion is that there was one scenario that would be consistent with suicide.
Would that scenario increase if you rule out the possible slide bite on the left hand?
It would.
And in that case, how many scenarios?
2.
Thank you, Doctor. No further questions, Your Honor.
Thank you. Cross-examination.
Thank you, Judge. I noticed that you put a lot of emphasis on looking at all the evidence when you're making a decision or a conclusion about a case. Is that accurate?
I'd say we focused on what was biomechanically relevant.
Well, when you were speaking with counsel, you said the goal was to eliminate the possibility of suicide, right?
Correct.
And is that how you viewed this case?
Yes, sir.
All right. And so in order to determine that, it became very important for you to look at all of the evidence, right?
Correct.
Specifically the evidence of autopsy?
Correct.
The evidence at the scene?
Yes, sir.
Those things will be very important when you're deciding whether or not this was really a suicide, right?
Depending if it's subjective or anecdotal, yes.
Okay. May I approach, Judge?
You ready?
Let me publish for you 19E. This came into evidence a little bit earlier in this case. And I'm going to ask you some questions about it in terms of your opinion about suicide, okay?
We're going to object has been outside the scope as it relates to a diagram put together related to bruising that was not the subject of his or direct examination or the biomechanical analysis.
He's testified he relied on the photographs and the autopsy in this case, and that's simply what this is, Judge.
Mr. Jordan, I apologize. I'm going to have you step up for a minute.
Okay.
Counsel, I guess I want to understand. Well, let me seems beyond the scope, but I want to understand I want to give you a chance to give you a little bit more, but this sounds like as I recall, 19B is the various bruising on the body and so forth. And you wanted to ask this witness about that?
I did, Judge. This witness has already said that he's relied on the autopsy photographs. He's already opined about an autopsy photograph that had what he called a slide bite on it. To simply ask him about these other autopsy photographs at this point would be relevant, and it would be especially relevant as it pertains to his idea that he's trying to rule out a suicide. I think it goes directly to the heart of that testimony, Judge. If you have someone who has multiple injuries throughout their body, who has a second-degree burn on their arm, who has a broken jaw, who has signs of suffocation, whether or not there was a suicide in this case is directly on point. And so I think I should be allowed to go there.
Mr. Johnson?
Thank you, Your Honor. He was asked to look at the body position, gun position from a biomechanical engineering standpoint. Whether or not he was to look at or provide an opinion of marks that show up 2 days after the traumatic autopsy where they do so much stuff, there's lividity. That's a separate, he has not testified to that, it's beyond scope. This was solely focused on the biomechanical and the interaction of the blood and the water.
Very good argument.
We know the state's opinion on 19B, but that's not fact. And I think it's beyond scope, but I think it's improper.
Very good argument.
In the court's view, this witness hasn't testified that Ms. Howard committed suicide. This witness has merely testified to biomechanics that would make it possible, the scenario of how to hold a gun or not hold a gun. And a brief comment on the demonstration on blood in the bathtub. This would be very different in the court's view if this witness did opine that Ms. Howard committed suicide, or the evidence, the autopsy and so forth was consistent with her committing suicide and so forth. But this, in the court's view, this expert has limited his testimony solely to the biomechanics and what is possible biomechanically or engineering-wise in terms of how a gun can be held and so forth. So I think this is beyond scope and not proper. I guess the one thing
You made your ruling. Don't come back to it. Just go.
I can see allowing a question simply to the extent that there were multiple other injuries that you didn't consider as part of your biomechanical review. But to show the witness additional autopsy photos and get his opinion on whether or not this was suicide or homicide, I think is significantly beyond the scope of this witness's testimony, and frankly, outside the purview of his expertise. So I'm going to grant the objection in limited, as I just indicated.
Good ruling.
That was pretty mature.
Very good ruling. Very good ruling. His job literally at this point is explaining whether or not it could have happened and the physics and the logistics behind how she could have done this. He's not commenting on, well, was it suicide? He's just saying, could somebody do this? Yeah. And the attorney did a great job bringing up like all these bruises and crap that happened days afterwards. He has no idea. And that's after they were yanking and banking on her to open her up. So, and to put her in the bag. I'm sure she was like frozen in that position.
You can be seated. I sustain an objection. Mr. Heron, you may continue.
Thank you, Judge. Sir, if you eliminated the possibility of Kendy being alive when she was shot, wouldn't you eliminate the possibility of suicide?
If I had evidence to show that, that would be true.
That would pretty much do it, wouldn't it?
If I had evidence to show that, yes.
All right. And so in terms of evidence, I assume your attorney that you work for gave you all the evidence in this case. Is that correct?
Yes, sir.
Because you wouldn't have come to the conclusion that you had otherwise, right?
I'm not sure what you're referring to, but I considered everything I received.
And so you considered the prior testimony and additional report of Dr. Ryan Rambaran, right?
Correct.
And his conclusion was that she was dead when she was shot. Do you remember that?
I do.
And you know that Dr. Rambaran has a medical degree?
Yes, sir.
Many years of experience as a trauma surgeon? Yes?
Objection.
Yes.
Let's go. Sustained.
You considered the report of Dr. Smock?
Yes, sir.
Dr. Smock was very clear that she was dead when she was shot, right?
Objection. Outside scope. Calls for her sake. Sustaining based on my ruling previously.
Why, when you had these other pieces of evidence, this medical evidence, wouldn't you discount the possibility of suicide from the onset?
None of them actually were at the autopsy. I had an autopsy report from an equally qualified individual telling me that the cause of death was gunshot wound intraorally. And that's how I moved forward. A lot of the evidence that I had considered from those individuals I felt was primarily anecdotal.
Even though they had training and experience far in excess of yours?
In the medical area,
Right.
Agreed, except there are many things that don't fit. For example, the amount of blood that was present. There was, I think, 2 individuals that testified in grand jury that there wasn't enough blood for this to have occurred when she's alive. But in fact, there's many factors that would prove that. I didn't say they prove it wrong, but I could prove it wrong in the sense that first of all, nobody's accounted for the amount of blood that was actually present, as far as I know. Number 2, we saw that the blood via test, which you don't need to be a doctor to assess, sunk to the bottom of the bathtub. Number 3, you've got blood that was lost during the draining between the hours when Wheeler took his initial photographs and the coroner took his initial photographs. Further to that, Schmidt, 1994, documented a very similar case where there was a witness suicide, an intraoral gunshot wound that perforated the tongue and ended up in the upper cervical region, very similar to what we see here. And there was no aspiration of blood. There was very little blood found at the scene. And the conclusion of that paper, which was not by me, anyone can read that, was that there's a possible mechanism of reflex arrest when the spinal cord is involved. And so it stops the heart very quickly. And so taking all of that information in consideration, I think it casts doubt on that opinion.
On medical opinions? And
Yes, I can do that.
You're qualified to make that assessment?
Testing doesn't lie, as you saw. Those were my findings.
In your report you wrote on page 32, last paragraph, last part of the first paragraph, last sentence, furthermore, neither Mr. Livingston nor Dr. Rambaran offers an explanation as to where the missing blood might be found or how it disappeared. Do you remember that?
I do.
Okay. And you were provided with the transcript from the grand jury, right?
Portions of it.
And so you had that when you made that statement, right?
That's correct.
Let me show you that grand jury transcript of Dr. Rambaran. Direct your attention to page 559, line 23. And wasn't Dr. Rambaran asked the question, quote, okay, and so again, you know, the question remains, had the heart been pumping when this bullet went through the tongue, what would have been the result? And then what's his answer there on line 2, page 560?
It says again, significant and profound blood loss.
Why don't you take a moment, sir, and go through the rest of that particular page on that transcript and tell me whether or not Dr. Van Buren does explain where the blood would have gone. Had she been alive when she was shot?
He's testifying the fact that there would be in the order of half a liter to a liter blood loss from that type of wound, which is inconsistent with the research that I cited, but I understand that's also a possibility.
So he talked about on line 22, page 560, the blood could only go 3 places, into the lungs, into the stomach, and into the environment, right?
Correct.
And then he talked about, on the next page, 561, about there being no blood in the lungs, in the stomach, right?
Similar to the case study I quoted.
So
Yes,
it
sir.
had to go into the environment, right?
No, sir.
That's what he testified to, right?
That's what he's testifying to. I've shown you.
You told us in your report he gave no explanation. I'm attempting to show you that he did give an explanation, okay?
He says into the environment, but we don't ever see that, is what I meant by that statement.
And because you drew the conclusion, because there is very little in the environment, that she was dead when she was shot, right?
Except we still don't know where the missing blood is.
Do you agree that his conclusion was that she was dead when she was shot?
That was his conclusion, correct?
And so when you wrote that he gave no conclusion in your report, that was incorrect, wasn't it?
I think you're mischaracterizing what he said.
Didn't you say, furthermore, neither Mr. Livingston nor Dr. Van Buren offers an explanation as to where the missing blood might be found or how it disappeared?
Right.
And isn't
But
his
that she was-
explanation that she was dead when she was shot?
Except it still doesn't account for where that blood actually is.
It would be in her body, sir, would it not?
Except there's blood in the water.
Yeah, there's very little blood in the water, isn't there?
Nobody knows that.
Don't you think a medical doctor can make such an assessment?
I think a test is worth 1,000 expert opinions.
Don't you think a medical doctor has extensive training in terms of determining how the heart works?
Of course, I'm not judging that. I'm just going by the literature I cited.
Okay. You wrote on that same paragraph a little bit further up, given that gunshot injury involved transection of the spinal cord at the C2 level, it would have cut off brainstem regulation of the respiratory and cardiovascular systems. Remember that?
I do.
And is that accurate by your account?
It's also, yes, and it's also consistent with the research that I cited. I speak specifically to the regulation of the heart rate. So blood pressure can go up, blood pressure can go down, or the other option that was given by the research I cited was that it can also stop the heart.
Are you familiar with the medical concept that the heart runs on a different nervous system than the lungs?
Yes, it can continue beating.
All right, and so that bullet transection at C2 wouldn't necessarily stop her heart, would it?
Not necessarily, no.
Okay, so her heart could have kept pumping, right?
That's true.
And so your statement's not correct, right?
No, you're mischaracterizing what I'm saying.
You said it would cut off
Very
brainstem
strong
regulation of the
and
respiratory and
pretty
cardiovascular
light.
systems, right?
Regulation, so sympathetic, parasympathetic, things of that nature. But I would defer to the Dr. Howard's autopsy opinion about that. I would also defer to the research that I've cited.
Okay, so her heart would have kept pumping had she sustained that bullet wound. Is that what you're saying?
Not necessarily, no. And I've shown how that is possible.
Because of that study?
Correct.
Do you remember what that study was? What the name of it was?
It was Schmidt, 1994, case study number 3.
Let me approach it. I think I have the right study. All right? Take a look at it. Tell me if you're correct, please.
Sure. I recognize it.
Is that the one?
I'm referring to.
That's the one you're talking about?
Yes, sir.
And in this case, what you're focusing on is the person that shot themselves?
That was witnessed and had no aspiration into the lungs similar to this, and there was a little blood found in the scene. And the authors on page 59 conclude, there was no doubt that contusion of the cervical spinal cord can cause reflex heart arrest. And that's what I'm specifically referring to.
All right. Now, what I wanted to ask you about with that particular study, I can find where I am here.
I will give this guy credit. He is fighting back. He's doing a very good job at fighting back against the prosecutors, so I give him credit there where credit's due.
Parade of the tongue ended up description. It's just a rendition of Dr. Howard's description of the wound path.
Okay, and what's your description of the path?
Perforated the tongue, ended up fracturing C2 and transecting the spinal cord at that same level.
So to transect the C2, is it going down or up?
It was described as being horizontal or slightly down by Dr. Nara.
Well, I'm asking for your opinion as you sit there and look at that line today. Is that going horizontally or is it going down?
Clearly it's going down.
Okay. And so you would describe the trajectory of the bullet that went through Kendy's mouth as downward?
I didn't analyze the trajectory, but we're referring to Dr. Howard's report. That's.
Do you think you could analyze that for us and tell us what your conclusion is in terms of the trajectory?
It's perforating the tongue and transecting near C2.
Is it going down or not, sir?
Of course it's going down. Yes, sir.
All right. Where's the soft palate?
Soft palate is upper region here.
Can you show us?
Right there.
All right. And so the study that you relied on with the person that shot themselves in front of the witness, didn't they shoot themselves through the soft palate?
It was intraorally and it was upper surgical, but upper cervical region is where the bullet ended up. Similar to this, it did transect the tongue, but I agree with you that there was some differences.
So this one study that you've relied on, there was a completely different trajectory, wasn't
It
there?
wasn't completely different. It was intraoral, it transected the tongue, and the bullet ended up in the upper cervical region, similar to this case.
It was different in that that bullet went up, whereas the bullet in our case went down, right?
It wasn't described that way.
Okay. If you read the journal entry, if you read the facts, you know that the bullet went through the tongue and into the soft palate, right?
I believe that's what it said, yes.
One can make a pretty good inference that that shot is going up if it's going into the soft palate, as you've just showed us, correct?
There's different regions of the soft palate, though. I mean, the main one is here, but also back here before it turns into the pharynx.
So you can't agree that this other study, the trajectory was going up?
It's not detailed to that level, so I can't know.
All right. Wouldn't that make a difference if it was going up, in your mind?
It still details that it was upper cervical region, so we're looking at more horizontal, possibly slightly upward trajectory in this particular case file, yes.
In that study, it didn't even go through the C2, did it?
It says upper cervical region.
So you don't even know where the bullet landed in this other study, right?
It's upper cervical region, is what they say.
And I guess what you're doing is you're basing this conclusion that her heart would have stopped based on a study that isn't really applicable to our case, right?
I disagree with that statement.
Okay, even though we have these differences?
There's slight differences.
Okay. In that particular study, I think you still have it in front of you, on page 57, it indicated a very low percentage rate of handgun injuries that involved the neck region. What was it, 2% there under discussion, number 3? Is that right? According to the study that you referenced.
You're referring to the sentence that says only a few suicides shoot themselves in the neck?
Actually, I was going to get to that one next. I was looking at about 2% of handgun injuries involve the neck region. It's a little bit above that.
Right, I do see that.
Do you agree with that?
That's what they state, but I'm assuming that's external.
Okay. Well, what about that next line there? Only a few suicides shoot themselves in the neck. 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction, while the vast majority, as in cases 1 and 2, are homicidal. You agree with that?
I'm not sure what line you're on.
Go down about 5 lines. So we're still under discussion on page 57. It starts off, as you noted earlier, only a few suicides shoot themselves in the neck.
I see. And And then it continues saying 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction. Except I believe in that case, they're talking about external gunshots to the neck, not intraoral.
What's the last part of the sentence?
Well, the vast majority, as in cases 1 and 2, are homicidal.
Do you agree with that?
That's what they state.
Well, you relied on the study for another fact, right?
What's that?
That her heart could have stopped based on that shot.
You mentioned that there's a reflex mechanism for that, yes.
Yeah, so I'm asking you if you are good with this as well.
I would be, yes.
Okay. You relied on another study. I think, I'm sorry about that. Autopsy features relevant for discrimination between suicidal and homicidal gunshot injuries.
Is that Carter 2022? Sure. Yeah, that's Carter.
I think you quoted some parts of that article. Is that accurate?
I didn't cite them exactly. I mean, if they're published, the scientific community has accepted it. What I was drawing some attention to is the trend of intraoral gunshot deaths are primarily suicide.
Okay. What I wanted to ask you about is on the first page under abstract. It's kind of near the end on the left side. And quote, it says, from 61 suicides who fired the gun inside their mouth, only one pointed the gun downwards. Consequently, some bullet path directions cannot be considered indicative of suicide. Downwards and back to front in gunshots to the temple, left to right in gunshots to the left chest, and downwards in mouth shots. You remember reading that?
Yes.
When you cited to this article in your report?
That's also in our report.
Do you agree with it?
I can't deny it, no.
Okay.
I believe the statistic was 95% are homicide and 5% are suicide. So you still can't rule it out is the point.
Okay. And in our point here, when you've got a downward trajectory in terms of the gunshot wound to Kendy, it's indicative of homicide, is it not?
According to that literature, it is.
That you cited to?
Correct.
Take a look at page 276. Under direction of the bullet path, it says, quote, the direction of the internal bullet path may differ between suicides and homicides for a particular entrance wound site. Suicides commonly intend to have a stable and comfortable position of the shooting hand in a fatal effect of the gunshot. Remember reading that?
I don't actually, but you've refreshed my memory.
Do you agree with it?
If that's what they're saying, can we just go to that part one more time and get a chance to read along with you?
You want me to read it again?
I'd like to read it myself.
Oh, take your time.
Okay. And it's 276?
Yeah, it's under direction of the bullet path. You want me to point it out to you?
Oh, there it is. I see it.
Yes, he's unflappable. That's what a good expert is unflappable. He knows his shit front to back. You know, Dan Howard probably spent a lot of money. God, how much of that $2 million has he spent so far on this defense? Because this guy actually is worth every damn dime. This is a phenomenal expert that they found. I will say that much. His attorney did a great job finding this guy.
So you've read the first paragraph? That's what you're referring to?
Not the whole paragraph, just the
Okay.
first couple of sentences.
Yeah, those are the trends, yes.
And so that last part is what I kind of wanted to focus on. For someone to get a comfortable spot in order to shoot themselves, you'd agree with that assessment in that particular article you cited to?
Typically, things are done ergonomically, yes.
All right. All right, let me show you some photographs, I think. You probably got some of them in through your attorney. Run through these real quick. Recognize 100?
I do.
What do you recognize that to be?
The two conditions of the firearm at discharge that we considered, so horizontal being A and vertical being B.
101?
Yeah, he
That's
found him at the
horizontal.
airport.
It's one of the other positions we considered.
102.
another position considered.
And then the last one, 103?
Yes.
Same thing?
Yes, sir.
Those are accurate photographs and images from your report?
Yes, sir.
You two that 100 to 103?
Any objection?
For demonstrative only.
You can tell them as demonstrative.
Okay, so looking at 100 here of one of your images, one of the problems I think you told us about with this not being able to be consistent with Kendy shooting herself is it the angle of the wrist? Is that accurate?
Correct. We found that in that wrist position, according to strength tables, she would be unable to press the trigger.
There's another problem with either of those two examples too, isn't there? A big problem.
What's that?
Trajectory.
And these are demonstratives. It's just showing index finger versus index finger, in the two positions. But it's important to understand that this is based on Blender model, and that is a characterization or representation, not the actual angles that were used.
The trajectory doesn't work here, does it?
Sorry?
The trajectory does not work here with these images, does it?
With these images, they could be made to work, but these were probably performed early on when we were putting the report together. But I assure you, there's lots of other examples where the trajectory is correct and considering these positions. But I've already stated that the index finger is not a condition that would work in this particular case.
Right, nor with this trajectory.
Correct.
Okay. And then looking at 101, does that get you to the necessary trajectory in our case?
It would be close. Appears to be close, yes.
But that doesn't really look like a comfortable way in which someone would shoot themselves, does it?
Agreed.
It's a little odd, isn't it?
It is, but it was a consideration.
It's not really how she was positioned in the bathtub either, right?
Not a final resting point, no.
And so that just isn't accurate at all, is it?
I disagree. I think this is a possible scenario. The tub itself is modeled accurately, placed the feet and the buttocks close to where they were found at rest, and then obviously if this was a position, she would settle into the reclining position she was found in. That was the idea.
Kind of the same thing, but you've reclined her as opposed to the previous photograph here in 102?
Correct.
All right, do you think that gets us to the necessary trajectory?
It's close.
It's still got a little bit of a problem with being comfortable, right?
Agreed.
Okay. And then I think what you ultimately thought was your best method of showing that Kendy shot herself was 103, is that accurate?
That's the scenario in which both hands are being held, and yes, that's the most likely scenario, the ones we've tested.
How long is that slide on the gun? You can put it in your report. It was like a little over 5 inches, right?
Something like that, yes.
How long is her hand? You got that in your report too, right?
I don't recall.
Let me track that down. Hold on. Turn to page 37 of your report. Let me know when you get there.
I don't have a copy of my report, so
Oh, you don't?
I have a copy.
Yeah. Thank you.
Thank you. Okay, I'm there.
All right. And do you see where you've got the hand measurement?
I do.
And you put the hand as 0.063, right?
I did.
And that's in meters.
Correct.
Can you convert that to inches for us?
That would be approximately 2.5 inches.
And that would be the length of her hand.
No, sir. That is the center of mass of a coiled hand.
You've got under hand, under body segment, you've got hand, right?
Yep,
And then under length, you've got that figure, 0.063, right?
I do.
So how long would her hand be?
We modeled it as a closed fist.
Would her hand be as long as the slide of that gun?
It could be.
Okay. Doesn't that seem like an extra long hand?
Not at all.
What about that thumb?
I was about to answer.
Oh, I'm sorry, go ahead.
It's okay. It depends where you're placing the thumb. And the thumb is helping support the pistol grip in this particular scenario. And so when the slide moves backwards, the knuckle or the thumb itself is actually very close to the slide.
Okay. That thumb appears unusually long, right?
No, it's just an effective blunder.
Why does it have that skewing to the left there at the end following the knuckle?
Just a representation of the position. I could demonstrate it for you if you'd like.
Well, I'm just curious why you had the thumb in this awkward position going like this and then downward. Can you answer that?
I think there's other ways you could hold this. This is one that would be consistent with that injury.
Were you attempting to make this work with that laceration on her thumb?
Not at all. This pistol is not ergonomically designed to commit suicide. And so there's going to be an awkward position in order to hold it.
So this article that we started off on this tangent here about suicide and people that do it being comfortable doesn't really apply to Kendy? Is that what you're saying?
All I was referring to is that humans in general will find ergonomic ways to do things. It lowers the amount of energy you have to expend, less contraction of muscle, you're working within the mid-range of the optimal ranges of your joints, et cetera, et cetera. Obviously, if you're motivated to do something that would force you to use additional range of those motions, of your strength capabilities, the joint range of motions, you're going to choose to do that. That's all I'm getting at there.
Let me publish 20Y for you. And you remember what that is?
That's the linear abrasion we're referring to. Yeah, one of the photographs of it anyways.
Okay. What about 20W? What's that?
I believe that's the same linear abrasion.
Doesn't Kendy have two of them?
She may.
You don't know, do you?
This is the one I was specifically referring to in the slide bite.
Did you know that Kendy had two cuts on her thumb?
They didn't appear to me to be in the same place. There is an explanation for it in the sense that this would be the one that would be most likely to have occurred. The other one would also be possible if both sides of the thumb interacted with the slide.
So, you do know that she had two different cuts on her thumb, or you don't know that?
It appeared to me that they were in different places, yes, but I couldn't confirm that they were or not.
So one was a slide bite and one wasn't. Is that what your assessment of that is?
No, I'm just saying that that injury is consistent with a slide bite. It's also consistent with other types of injuries.
Okay. Have you treated slide bite before?
I don't.
You don't see patients?
Excuse me, I was talking. I don't see that as an injury that needs to be treated.
All right. You've never treated slide bite before, right?
I don't think
Objection argument.
any of the slide bite references that I've seen, I don't think would require anything other than minor first aid.
Overruling the objection.
So are you saying that doctors don't treat slide bite?
Not at all. It would just be minor first aid.
Do you think a doctor would be more familiar with slide bite than you?
I think there was an example of slide bite in Dr. Smock's report, but that's a completely different position and also dealing with soft tissue rather than tissue that's overlying bones.
So are you referring to 22C when you're talking about slide bite?
Correct. That's abrasions and lacerations over soft tissue in a very different position of the hand.
And
rather than
22
over the knuckle.
and 22D.
Correct.
Okay. And so you would agree with Dr. Smock that that is slide bite?
That's slide bite when somebody's using the firearm ergonomically and doesn't place their hand appropriately, although I know experienced firearm shooters that this occurs regularly in.
How much have you made from this case
Those boxes allowed.
so far?
I believe the amount is in the 40,000s.
Okay. Was that for the report?
I think the majority of that is, yes.
Okay. And then for today?
For today was complicated. I had other commitments at the council. There was a non-refundable retainer fee for that, to change that scheduling conflict. And obviously I was paid for my time while being here.
So how much total?
It might be north of 50.
That's all this is. The prosecutors just have said it makes more money than him. This guy's definitely earned his pay, though. Holy Jesus. This guy's an awesome expert. I would use him if I needed to. Like, this guy's good. Yeah, so it's like 25 Canadian dollars, though.
No further questions.
Thank you. You wrap with the doctor?
Yes. Thank you.
What did you have to cancel, Doctor?
I was scheduled to teach at the ILETA conference, which is the International Law Enforcement Educators and Trainers Association.
Now, you mentioned in answering some of the questions about Blender. Can you explain what Blender is?
Sure. Blender is a very nice way to visualize humans in a 3D space, as we did in this particular case. It's been used to characterize anatomy. It's been used for forensic reconstructions. It's also used for animation studies as well.
From a graphical standpoint, is Blender what you conduct your modeling in?
No, sir. It was just to visually represent the thought patterns. It's the stick figures that were the mathematical models.
Okay. So it's the differences in the visualization, would that change your opinion from your modeling?
No, sir.
Okay, and why is that?
Because the modeling is physics-based, whereas Blender is a representation of that.
Now, you remember at the beginning when counsel started asking you, him asking you about Dr. Rembrandt?
About the amount of blood present or not present?
Yes.
Yes.
In your review, did it appear that Dr. Rembrandt accounted for any blood loss down the drain?
May I answer?
Yes.
I did state earlier that there was an amount of blood that would have been lost. We saw quite clearly in the video the blood collects near the bottom of the tub, and that there was at least an inch of water that had drained out over the time period between the two photographs. So how much blood was lost, I don't know, and I don't think any other expert can tell you that, or at least haven't addressed it.
Did it appear that whether or not Dr. Rembrandt accounted for the blood lost in the body bag?
I don't recall testimony to that regard, no.
Okay. Are you aware of any, in your review of the autopsy and the materials provided, are you aware of any other injuries that would cause bleeding other than from the tongue and the damage caused by the gunshot?
Major bleeding, not that I noticed, no.
Okay. Now, you stated earlier that testing is worth 1,000 opinions. Do you remember making that statement?
I was quoting a gentleman who was, one test is worth 1,000 expert opinions, in my opinion as well.
And as your opinion, can you explain that?
What I mean is that, and we can see this at work in this file, there's many well-qualified people with differences of opinions and focuses on various aspects of the evidence presented. However, with one test, I think it's very clear that you would be able to understand as a jury that blood now sinks in water, and that is a visual and an example of that phenomenon that is undisputable.
I have no further questions.
Thank you, sir. You may sit down.
Thank you. Should I leave these here or take them with me?
Sure, you can sit.
I'll clean them up.
Okay. Thank you. Council, please approach.
All right, guys, hold on here. We're waiting for the jury to bail. Here we go. Just going to address this question real quick. Yeah, he uses a free program like Blender. Well, now we can't say I'm using special software you can't screw with. Now there's no excuse for anybody to critique his work. And also, if it ain't broke, don't fix it. And then there was a comment from way earlier. A couple things here. Sean, you asked, do you have to ask for approach? Yes, you're supposed to. It's a thing of respect. But also, I mean, it's a thing of respect. I mean, the inside the well, I mean, you are not free to do as you wish. It's still the judge's courtroom. So yes, you always should ask. May I approach? Especially if you want to approach the bench, you definitely need permission to approach. Some attorneys once in a while don't. Like if it's a judge they've known for like 40 years, they might not do that. I always ask because it's easier to mess that up, but then I'd rather ask a million times than forget once. Unhung Hero for $2 says, "Oh, I'm gonna come." Well, don't come. Don't come. And D for $5 says, "Coca-Cola brand water." Excuse me. Coca-Cola brand water. Need a pick-me-up? Try out specialty water with the Coca-Cola traditional secret ingredient. Have a sip before you sit. Coca-Cola. Thank you. Thank you for the super chats, guys. Also, even the judge is the bailiff. No, generally they'll know because you've been around forever and a day. But I just don't do that. I don't do that. So. Yeah, well, that's why rich people are rich. They don't pay for things that are free. There's that too. But I think more importantly, it allows them to say, look, I don't even use, because that's how some experts are bullshit. I use proprietary software. No. This is a phenomenal expert, though, worth every dime. He's intelligent, he could be relatable, but he also could fight.
Thank you. Right, members of the jury, the defense having rested, the state is allowed the opportunity to present rebuttal. They do have rebuttal lined up at 1:30, is my understanding. We moved a little faster this morning. So I'm going to give you a 2-hour lunch today while I address some other matters with counsel. I anticipate
2-hour lunch break.
Break. Just so you have a copy of you via email probably that you haven't seen yet.
Yeah, I haven't seen it.
But I'd like counsel to be back at 1 o'clock, ready to argue that motion. That would work for everybody. Because I know that's moving quickly, but it should give you time to review the motion. Will that work for the state?
Certainly. Would the court be inclined to take up the issue of the jury instruction conference during lunch hour?
Yes. I just want to make sure Mr. Johnson has enough time. Do you want to meet at? Sure. Why don't we talk about it? Why don't we meet with council chambers real quickly and let's sort that out. Okay. All right. We'll be in recess. Thank you.
All right.
The council wants to just want to change this stuff.
All right, guys, so they're going to address some stuff off the record. Let's see what this turns into for them. We got a 2-hour lunch break, so this will be interesting. Oh, hold on, guys. Sorry. Hold on here. 100 shots. All right, hold on. We're going to skip ahead here, do some time traveling. All right, so 2 hours. Oh, yeah, look at that. Just eating up time, chat. We are Chiatsu. Oh, yeah. Oh, yeah, there we go. There we go. Here we go. Here we go.
The court placed some very specific conditions on the defendant's release from custody. Namely...
Ooh, we're going to talk about him running out of town. Let's see how this goes.
That the defendant was prohibited or excluded from leaving the state of Idaho, with the exception of he could go into Spokane County, which is where his attorney practices out of. However, the defendant was further prohibited or excluded from coming within 2 miles of the Spokane International Airport. Additionally, Mr. Howard was notified that intentionally leaving the area of restriction may be prosecuted as a crime of escape and subject the defendant to the penalties under Idaho Code pursuant to escape. The court is well aware of the procedural history of the trial. Last week, a recess was declared for Friday. Friday night, the sheriff's office and their surveillance team were watching the defendant's home. And the sheriff's office observed the defendant leave his home in his vehicle. With the defendant in a separate vehicle was Mr. McCullough, a witness who testified in the trial and was found to have been in violation of this court's witness exclusion order.
Ooh.
The state is in possession of screenshots from YouTube indicating that Mr. McCullough testified differently than what actually happened. That he was knowingly on the live portion of the trial.
Oh, no.
In the live chat.
Oh, chat. I don't like where this is going, chat. Oh, no. Oh, no. I hope they weren't on my channel. That it's like, actually, it's pretty dope if it's like conspiracy to avoid prosecution. That'd be kind of dope, but it's like, uh-oh. That guy, he really talked like this, and he just wanted to talk very nicely. I'm just a friend. I'm just a friend. Uh-oh. Uh-oh.
The defendant and Mr. McCullough left the defendant's home, traveled west through Rathdrum and into Washington.
That is impressive that they were fucking babysitting this guy.
He got on to I-90. Got on to I-90 in Idaho and then continued west into Washington. The defendant took the exit right next to Spokane International Airport and drove onto the property of the Spokane Airport, all the way up to the terminal, baggage claim, and car rental area. It was there that the defendant was detained. Ultimately, my office and the sheriff's office sought a warrant for the defendant's arrest. His bond was revoked and he was taken into custody. What's very interesting about this encounter, Your Honor, is that Mr. McCullough was permitted to sit inside of the defendant's vehicle in the driver's seat for a short period of time while Mr. Howard was being detained and dealt with. Within a few minutes of that, law enforcement second-guessed their decision to let Mr. McCullough sit in Mr. Howard's vehicle. They pulled him back out and asked if they could search him. Mr. McCullough consented to a frisk or a search, but advised officers that he had put a gun under Mr. Howard's seat. This gun was a full-size Glock, 5-inch frame, not conducive to concealed carry. While frisking and searching Mr. McCullough, no holster was observed on Mr. McCullough. Your Honor, I believe this gives the inference that Mr. McCullough wasn't possessing this gun, that this gun was under Mr. Howard's seat the whole time. Mr. McCullough was permitted to leave the scene in Mr. Howard's vehicle. What's also very interesting about this surveillance, Your Honor, is while they were following Mr. Howard on I-90, he was traveling westbound, further away from his home. He quickly took an exit. He took the Pine Street exit, and then immediately got back on the highway. The officers that were on the surveillance team are very experienced officers, and they've conducted surveillance before, and they're aware of counter-surveillance methods. It's very common for people involved in the criminal element to try to determine if they're being surveilled. And the way they do that is to make abrupt lane changes or get off and then back on the highway just to see if somebody's following them doing the exact same thing. These officers detected what Mr. Howard was doing as a counter-surveillance measure to see if he was being followed. So now we know there's a gun in his car. He's conducting counter-surveillance.
There's an even easier counter-surveillance method. Run a red light. Cops won't do that.
Maneuvers.
Just saying.
When Mr. Howard was detained at the airport, he was still wearing his ankle monitor, as court ordered. As this court knows, there is ample case law regarding evidence of flight and consciousness of guilt. The most recent case on this matter is Kimberly. And the sentence I want to focus on the most, Your Honor, is on page 4 of my brief. Page 3 of my brief. It says, for a defendant's departure to constitute a flight from prosecution, there must be other circumstances present and unexplained, which together with the departure reasonably justify an inference that it was done with consciousness of guilt and in an effort to avoid apprehension or prosecution based on that guilt. So we have to break that sentence apart. First, there has to be a departure. And that's exactly what happened, and that's why the defendant had his bond revoked. He departed Idaho and departed the area of Spokane County he was allowed to enter. He entered an area of restriction. He departed the area he was confined in. By entering the Spokane International Airport, there was a departure. And this just wasn't any departure like he went over into Liberty Lake near state line. This wasn't just a departure where he left Spokane County and then quickly re-entered. This was the airport. This is where people get on a plane and then leave the state, the country, the area, and they could never be seen again. And so it's very concerning that the defendant chose the airport as his area of departure. So there's no question again that there was a departure. Next, what the court has to consider is whether there are any other circumstances present and unexplained which reasonably justify an inference that the departure was done with consciousness of guilt. And I'd like to point out that this is just an inference, Your Honor. That's the standard here. There doesn't have to be proof beyond reasonable doubt. It doesn't have to be 100% certain what the defendant was doing. We're talking about an inference. And that's why I want to focus on these circumstances. The defendant departed with a gun in his vehicle. And the light was favorable to him. He departed with his friend who had a gun that ended up in his vehicle. That is highly concerning. Somebody who's going to flee are best able to do that with a gun. Because people who are fleeing prosecution know that it's only a matter of time before law enforcement is on their tail. And law enforcement are going to bring their guns. And it only makes sense that somebody who's fleeing is going to want to meet force with force when it comes time to take him back into custody. Your Honor, he was with a witness who was well informed as to what's happening in this trial. Mr. McCullough testified, and I believe he demonstrated to the jury that he was not an unbiased witness. This is Mr. Howard's ride or die. In addition, Your Honor, we have to look at the timing of the departure. This wasn't a departure pre-trial. This was a departure, and Mr. Howard chose the timing of the departure after the state rested its case in chief. And the timing of that is significant, because that was after Mr. Howard had a chance to assess the strength of the case against him. Some very compelling evidence is before the jury demonstrating that he is guilty of murder. He chose that time to depart. Now, there's the issue with the ankle monitor, and I think this could cut both ways, and I expect Mr. Johnson to stand up and say, well, he of course wasn't going to flee because he still had his ankle monitor on. Your Honor, I think that's also evidence that he was about to flee. Somebody who's about to flee and they're wearing a GPS ankle monitor, they're going to want to keep that ankle monitor on until the last possible moment before they cut it and run. Because as soon as they cut the ankle monitor, the alarms are going off and everybody's looking for you. So it only makes sense, after conducting counter surveillance measures and showing up at the airport with a gun, that Mr. Howard would still have his ankle monitor on. It's because law enforcement caught him before he cut it off. And again, I'm drawing some inferences here. Yes, I can't prove this beyond all reasonable doubt, but that's not the burden. The burden is there an inference when put together with the departure that shows consciousness of guilt? And I'm arguing there was, Your Honor. I think this evidence is highly relevant, and I don't think it's unfairly prejudicial to the defendant. If Your Honor allows to put evidence on in front of the jury and reopen the state's case, all the state is asking is to show proof that the defendant departed, that he was found at the airport, and that he was taken back into custody. The jury doesn't need to know about Mr. McCullough. He doesn't need to know about the gun. And the jury doesn't need to know about the counter surveillance maneuvers. I would agree also that the jury should hear that he still had an ankle monitor on. But again, that the case law I cited to really limits what the state should be able to show to the jury as proof of flight. And I'm agreeing that it should be limited. So it's with that I submit.
Thank you. Mr. Johnson?
Yes, Your Honor.
Go ahead.
A little bit of disadvantage to receive a motion in the middle of trial and argue it.
So guys, I'm curious to see, like, I mean, that's just, oof. Your buddy's like, I dropped a gun. You know, I dropped a gun in the car. What a homo. Betraying your buddy like that. I'm curious to see what the defense is going to say. I think not cutting it off, yes. Traditionally, yes. Cutting it off the last minute's the way you do it. You don't cut it off till you're ready. But where the hell is he going to go? It's in the middle of frickin' Washington. But anyway, let's hear what happens.
Let's be fair. I mean, you had to expect this motion. I certainly expected it this weekend.
I expected.
Would be ready to address this.
I actually expected a mistrial. But that aside, we've tendered as an offer of proof. Again, if I had time, I would get the actual email from herself. But it shows that the rental was supposed to be returned on the 16th by 12:30 in the morning. Mr. Howard has a curfew at 11 o'clock every night. He's never violated his curfew. The issue of being surveilled, Mr. Howard absolutely knows he's being surveilled. We had a motion in front of the court when the court denied the state from having access to his ankle monitor, set up a game camera outside of his house. We had a motion about that. The court left it as it was, but he knows he's being surveilled. Law enforcement is going up there, up and down. So he knows he's being surveilled. I think it is significant that he turned himself within 1 hour of the indictment. He didn't flee there. Also, I think Kimberly is, while on point, I think there's drastic differences. There, the court, Mr. Kimberly was released without an ankle monitor, and so the court specifically put a warrant out because that was one of the conditions. He didn't have an ankle monitor when he was released, so they issued a warrant. So a warrant was issued. Here, there was no warrant until after he made contact with law enforcement. Second, Mr. Kimberly failed to appear for the pretrial. Mr. Howard's made all of his court dates, both when he was in custody and since being out. In Kimberly, he had no contact with his attorney. I've had multiple contacts, and offer proof you can see my phone. I've had multiple contacts. In fact, as an offer proof, you can see my phone revolving errands that were going to be done in Spokane on Saturday. I knew about. He wasn't restricted from Spokane. He was restricted from the airport, 2 miles. So that's a big distinction. He's maintained constant contact with me. In Kimberly, he left Idaho and moved to Spokane. There was no movement. He was going to be back home before curfew. And again, in Kimberly, he used an alias and worked under the table. There's no allegations of that here.
This still was the dumbest fuck. Oh, I gotta return this car. I don't know. Why aren't you calling your attorney? Hey, I actually have to leave the state. Now, here's the deal. If you call me and said, oh my God, bro, listen, it's an emergency. What's wrong? I need to return rental car. I'd say you need to have 2 other people figure that the fuck out. Do not leave the state. Like, why did it have to be these 2? Your son seems to be on board with you. Hey, son, can you return the car with the creepy guy? Cool, thank you, bye. There's a million ways they could have fucking done this.
Here. the trial court took into consideration the time he was a fugitive. Here, Mr. Howard was never a fugitive. He violated his terms of release, which would normally be subject to a bail revocation hearing. But instead, obviously, the state's concerns, they filed for a warrant instead. But he was never a fugitive. And counsel's right. There must be circumstances present and unexplained which, together, the departure reasonably justified an inference that it was consciousness of guilt. Here, there are no bags. I think there was maybe less than $50 in the wallet. There's no money. There's no ticket. He did go into the thing. They were stopped or contacted by law enforcement at the return center, at the vehicle return. And again, the vehicle was to be returned by 12:30 that next morning. And in an effort to avoid apprehension, when contacted by law enforcement, he cooperated. They asked him to get out of the vehicle. He got out of the vehicle. Whether, and the state has already stipulated that the gun wouldn't come into a case in chief, but let's just assume for a second, it was Dan's gun. He didn't bring it out with him. He complied with law enforcement. So the gun is red herring. There is no inference plus facts to support flight or consciousness of guilt. He forgot about the 2-mile restriction. He's been in Spokane numerous times, both my office, shopping, errands, all sorts of stuff. And the court did not restrict his move to Spokane. He forgot, and he was in custody on that. We did talk about it, but he forgot about that. It is not a demonstration of flight to enter this at this point and allow the state to reopen the case. One, given those scenarios, it's hard to infer that he was actually fleeing rather than made a bonehead mistake about his release conditions. Or two, it's unfairly prejudicial to Mr. Howard. This case is about the science, blood, lack of blood flow, blood drainage, all that. Mr. Howard has been to every hearing. He shows up to court, as Your Honor probably has seen. He parks in the same spot every single day. He shows up at 7:15 every single day. He is absolutely involved in this case, calling me every day at night, and thoroughly involved in his defense. He believes in this case. I believe in this case. The fact that he violated a release condition is, while wrong and while subject to potential revocation of bond, is not in and of itself an indication of flight. And yes, he did have his ankle monitor on, but also he did not have a ticket. If you're going to have premeditated stuff like that, you're going to have stuff in the works. And certainly, being former law enforcement, he would know that the security would never let him into an airport if he was going to flee. It would not be to an airport, especially one so close. It would be some other modes of transportation. So I don't think there's been sufficient information, particularly when there's proof that the rental car had been returned. They were contacted at the rental car. He was returned. He was compliant. He already knew he was being surveilled. I don't think that's enough to infer that he was actually trying to flee. And so we think the motion should be done.
Thank you. Any final words, Morrison?
Your Honor, thank you.
Thank you. All right, well, I have reviewed, I appreciate the state's briefing and the cases cited. I have reviewed those, and appreciate the defense's offer of proof as to Mr. McCullough's rental car return scheduled for Friday night, midnight. I have reviewed it all. Counsel, Ms. Morrison correctly cites the case law. It's true that flight can be interpreted as evidence of guilt or create an inference of the guilty mind. As has been cited, in order to evidence a consciousness of guilt, there must be other circumstances present and unexplained, which together, with the departure, reasonably justify an inference that it was done with a consciousness of guilt and in an effort to avoid apprehension or prosecution based on that guilt. In these circumstances, I'm struggling with the initial finding, even of flight. Mr. Howard clearly violated his conditions of release. He was ordered not to go to the airport or go within 2 miles of the airport, and he violated that. It's unclear to the court that there's flight or departure. He's been allowed to go to Spokane while it could be said he went out of state. In reality, he's less than 45 minutes away from the courthouse, and he's back and forth there all the time. His attorney's office is there. He's not restricted.
Yes, is that creepy guy who watched YouTube? Yes.
From going there, and it's just unclear to the court that I actually have flight. Mr. Howard this case has been pending for years, and Mr. Howard has turned himself in, been present at court at all times. And without diving too deep into the nitty-gritty of what exactly he was doing, I don't know what exactly he was doing, but it certainly seems probable to accept that his friend had flown in here to testify for him, and he had turned in his car rental that night and was doing so. The facts, again, this is offered proof, but seem to support that that's what Mr. Howard was doing. Now, the things that go counter to that, as the state's mentioned, the counter surveillance maneuver, the evasive maneuver, so to speak, on the highway, the fact that there's a gun present in his car, though Mr. McCullough claims that it's his, those cause the court pause and some concern. But, and I do think mitigating that somewhat is the fact that he still was wearing an ankle monitor. There was no secret where he was. And again, in the court's view, this would be a vastly different situation if he'd cut the ankle monitor. This would be a vastly different situation if he had an airline ticket in hand, if he had a bag packed with cash, and the court sold his passport, so I know he doesn't have a passport, but if he had, a flight, a ticket in hand, cash, and packed and ready to go, those would be circumstances that, together with the departure to Spokane to justify inferences done with consciousness of guilt, I'm having trouble finding those initial findings. And I recognize that if the evidence is there, it's ultimately for the jury to weigh it. But before it gets to the jury, I need to be satisfied that there was a flight or a departure, and it's just not clear to me that there was. There's certainly, I think, an equally strong inference that he was taking his friend to drop off the car and coming back. Now, I do find it hard to believe that he forgot his restriction at the airport. I find it hard to believe. And I do think it's concerning enough that when I received a phone call late at night.
Now, it's not even made clear, and I agree with 2.0. It sounds like they were both in one car, but I think that's not what they were. The idea is that they both drove a car out there, but it's not even clear that way. No matter what they're doing here, none of this makes any goddamn sense. Like I said, if you had called me and said, "Oh my God, it's an emergency," what? The rental car would have been like, get a fucking grip, have your friend take it back, figure it out on the way out. Don't fucking go yourself. The idea Howard did this blows my fucking mind, because he is apparently a fairly intelligent man, but this is borderline fucking mentally retarded. Doing this, period. This whole thing was stupid. $50 wouldn't get him a half a month in Heath and Ralph's house. Yeah. Not everybody's got friends. Well, you figure it out. You figure it out. Maybe the other guy's got friends. YouTube guy's got friends. Like, that's... they're lucky this judge is understanding it, because, yeah, it doesn't make sense. Like, you can't... How do you run with $50? You can't go anywhere. Heck, you go to McDonald's and you buy, a cheeseburger, and that's half your money. And you buy a gallon of gas, and that's your other half of your money. He didn't have a flight pan. He didn't have clothes. He thought he was going to go hide in the mountains or something. So, yeah, I think it was a little ridiculous for them to do this. But cops were looking for an excuse to fuck with this guy, too, so they did it. Why would a gun help you at the airport? I don't know. Why would they have a gun, period, though? He shouldn't be having, I'm pretty sure he's not allowed to possess firearms as part of his bond. In Ohio, that's a separate felony charge. When you're accused of a violent felony, you cannot possess firearms. I'm surprised has one, period. He should fucking have a gun. Why does the other guy have a gun? Is he worried that, Dan Howard's going to choke him, put him naked in the bathtub, and kill him too? I mean, yeah, there's a Second Amendment, but there are limitations to it. Zero Fuck says most people spend half their money at McDonald's. I was making the point that McDonald's is very expensive. You buy a cheeseburger and it's $35. Okay, thank you, actually, man. And Luke, you're right. It's stupid and it doesn't go to flight, but you don't but you violated bond. That's the bigger issue. You violate bond conditions by doing stupid shit. The judge is going to say, okay, well, you're too fucking stupid to follow the rules. Have fun in jail. So, that's the problem here. That's the problem here. It was an easy fucking thing they didn't have to do.
To address this issue, if warrant or bond to be revoked. I am ordering that his release continues to be revoked and he'll be held without bond for violating the court's very clear order. But in terms of allowing the state to reopen and present this evidence to the jury, I think it's very. I don't think it's a strong. I don't think there's strong evidence here, and even with just needing to justify an inference, I'm not sure there's an inference here that what he did was done with a consciousness of guilt, and that it was an effort to avoid apprehension or prosecution. And given that, then under the weighing it under Rule 403, I find the probative value of what he did, meaning that's the legal term, the probative value, the strength of the evidence for proving something, I think is relatively low. I think the prejudice outweighs the probative value. Frankly, I don't know that the prejudice is tremendous either, though, because the defense could explain all this, apparently. But nonetheless, I think the probative value is outweighed by the prejudicial effect of this evidence. And so I'm going to deny the motion to reopen the evidence and to present this evidence to the jury. All right, with that, though, we will turn to the state's rebuttal case, and I anticipate us adjourning for some time to get your instructions ready for the jury and prepare some for closing arguments and move forward to deliberations.
Your Honor, just a clarification. Earlier this morning in chambers, you indicated that after you ruled on this motion, you'd reconsider whether or not to pull the jury.
That's right. Thank you. I did indicate that earlier. I explained I wasn't going to pull the jury. I did say in chambers one of the reasons I wasn't going to pull the jury as well is that if we presented the evidence, the jury has no point in pulling them because they would have heard the evidence. So since I'm not allowing this to be presented to the jury, the issue of pulling the jury is back before the court, as Mr. Johnson's requested. I still am not going to pull the jury. I still feel strongly that this jury has been attentive and conscientious and is following the court's orders and rules, and I don't see the need to pull it regarding this one issue of media coverage. So I'm still denied to pull the jury. Okay, stay ready to proceed.
Just as soon as we get Dr. Smock on Zoom, Judge. It should take a minute or two.
Yeah, let's just take a short recess and then just let me know when you've got it.
Thank you.
Thank you.
All rise.
Zoom, and I understand from counsel that there's no objection to that.
That's correct.
And I think,
You may proceed.
I think we have Dr. Smock on Zoom at this point.
Dr. Smock, if you're able to hear me, you're welcome to turn on your video. When he was there about 30 seconds ago.
Still on the participants.
Are we on mute? Dr. Smock, this is Judge Parise. If you're able to hear me, you're welcome to turn on your video.
Thank you, Your Honor.
Thank you, sir. You may inquire, Mr. Verheeren.
Thank you, Judge. Would you like the doctor sworn in again since it's a new day, Judge?
Yes, thank you. Dr. Smock, if you would please raise your right hand where you are, be sworn in by my clerk.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Dr. Smock, for being available today. Where are you right now?
I am at my home in New Albany, Indiana.
All right. We heard from Dr. Howard. Dr. Howard told us his conclusion as to cause of death was gunshot wound. Do you agree with that or not agree with that?
No, sir, I do not agree with
All
that.
right. And do we have some photographs that have been previously admitted that can help you describe why you don't agree with that? All right, let's start off with those. I think the first one's 17K. We are all looking at 17K. Doctor, can you see it as well?
Yes, sir, I can.
Doctor, can you describe how 17K is consistent with your opinion that she did not die of a gunshot wound?
Yes, there's several things that, and I don't know, can you see my mouse? I don't know whether my mouse is moving, probably not.
Nope.
No, can't see. Okay, I'll do my best to describe it to the jury. But when we look at the front of Ms. Howard, there's several things that tell us that she sustained other injuries other than a gunshot wound, and that she sustained injuries pre-mortem, meaning before she died. So let's look at the two. First, let's look at the lip. The left lip, you can see the bruising that goes down from her lip, down her chin, and down into her neck. So remember that in order to bruise, your heart has to be beating. So that's number one. And number two, there's an injury to the front of her neck. There's bruising to this area right here in the front, which Dr. Howard didn't even mention in his autopsy report. It's clearly visible in these photos. So in order to bruise, you have to be alive. Your heart has to be beating. And I think if we go through some of these other photos, so clearly Ms. Howard sustained a gunshot wound. But my opinion is she sustained that gunshot wound post-mortem, after she was dead. And I think if we work through these photos, I'll be able to begin to explain to the jury why that is what happened to Ms. Howard.
Okay, can we go to the next one, please? And what we're looking at is 20C. Can you tell us how this supports your theory or your belief, Doctor?
Yes, sir. Well, let's look at, she has injuries on the left and the right. And what is underneath that injury on her lip? Well, on the inside, she has a laceration, a tear, where her lip pushed into her bottom teeth. That bruising is on the outside of her lip. Meaning, if you look inside the lip, it's between the lip and on the inside of the lip. So why is that important? Well, let's look at Dr. Howard's opinion that this fracture occurred from something related to the gun. Well, I can tell you it didn't happen from the slide of the barrel for two reasons. One, the bruising is on the outside and on the inside of the lip, not on the inside of the gun. And her teeth are not broken. When I've seen injuries from a slide, meaning the top of a semi-automatic handgun, going back into the teeth are broken. And her teeth, both upper and lower, are pristine, which says this injury did not occur from the slide of the gun. Looking at the far side of her, on the right side, which is away from that fracture and the bruising on the left side, she has some damaged injury to that lower lip. That is what is consistent with some trauma pushing her lip into her teeth. And that is consistent with suffocation, pressure being applied to her nose and mouth.
And not a gunshot wound?
Not a gunshot wound, no, sir. It's on the opposite side. If you start looking, remember, I tried to explain before that I take every injury and analyze every injury to determine does it fit or not fit with any particular history or the facts of the case. And when I see injuries on two sides of the lip, that doesn't support, for several reasons, that it's associated with the gunshot wound at all. But number two, we have those two locations, and we have injury to the left side of her nose as well. So three separate locations on the nose and mouth that are unrelated to the gunshot wound.
I think our next slide is the inside of her mouth.
I think this is a better picture from the front of her mouth, showing on her nose, the left side of her nose, she's got a bruise over there, and the bruise comes from blunt force trauma, something causing the blood vessels to rupture. We've got the mark on the right lower lip, and what's interesting about that is that length of that mark is consistent with the length of one of her teeth being pushed into her teeth from the outside, not from the inside coming out, but from the outside coming in. And the extensive bruising over the area, over the line fracture of her jaw.
Show us the next one. Looking at 20G, Doctor, what can you tell us about this that refutes what Dr. Howard said?
This is, I don't know if we can zoom in on that lip itself. I don't know if the PowerPoint can zoom in or not. It's not. But looking at the inside of the mouth, the inside of the lip, look where the laceration is cut. It's on the inside. And then look at all the bruising that is on that part of the jaw, the skin that overlies that part of the jaw. That's where the bruising is, not from the inside, where something could come from the inside out. And certainly that happens, but that is not what we have in this case. And so the injury we see here is from some sort of external trauma, and I believe there was a blunt force trauma to her jaw that pushed her lip into her teeth, and then that same force fractured the jaw directly underneath that part of the lip.
Go to the next slide, please.
Oh,
that help?
That close-up that I was hoping we would see. Look at that laceration in the tear of the skin. And where is it? It's on the inside of the lip. And the characteristics, you see how it's a line going across? That's similar to what we see on the other side. So that's the type of injury you expect to see and do see when tissue is pushed into the lip or into the teeth from the outside.
One of the things that Dr. Howard said was that the blood that was visible in Kendy's mouth, tongue, and neck issues was essentially consistent with an intraoral gunshot where someone was alive when the gunshot was made. Do you think that that is correct?
No, sir, I do not.
Why not?
Well, look at the photos of the tongue. We know that the heart will continue to beat for a certain period of time after the bullet goes into C2. So where is that blood? Yes, Kendy were alive when the gunshot went in and through her tongue and then down into her stomach, where we would expect way more blood. And why is that? Well, when we asked with Dr. Nara, dissected the tongue, you saw all the arteries and the veins that were torn apart, ripped apart. Arteries bleed like stink. They will pump. And so what you would expect to see, if Ms. Howard were alive when bullet went in, you would expect to see blood coming out of her mouth, spurting from all those arteries. And is there any evidence of any sort of spurting coming from her tongue? Zero. There is nothing that says blood spurt from her mouth, from those arteries, which is what you expect to see. Remember, it can only go 3 places. Her lungs, no blood in her lungs. Stomach, no blood in her stomach. So it would go out of her mouth. And is there any physical evidence, any forensic evidence that says there's spurting from arterial bleeding coming out of her mouth? No. It's basically it's dripping out of her mouth. It's not spurt. There's zero evidence of spurt.
And looking at that slide there, would that be the normal amount of blood for a person to displace in a tub like that had she been alive when she was shot?
No. Everyone knows, men and women, that when we even get 1 or 2 drops of blood from our rectum or from our vagina, there's menstrual blood from women or hemorrhoids from men or anybody, we know that 1 or 2 just drops of blood will turn the whole toilet bowl red. And you can see through this blood. This is basically, you've got red blood cells dispersed in the blood, or in the water of the bathtub. But had the injury occurred and she was spurting blood or arterial or even venous blood flow into this while the heart is pumping, it would be there would be so much more blood, you would expect it to be, you couldn't see through it.
Okay.
The blood see in this photo, in that water bathtub, is not consistent with a living person being shot.
Okay, thank you. Next slide, please. Okay, so Dr. Howard called that skin slippage. Do you agree with that?
There is skin slippage because there were blisters on the skin, but the skin slippage is from a 2nd-degree burn. And what's very interesting about looking at this pattern, when you are exposed to a liquid and you have a burn, it's based upon, the severity of the burn is based on 2 things. One, the temperature of the medium, water, oil, whatever it happens to be, and the duration of contact. And, I'm sorry, you can't see mine, but I'll try to explain this. You can't see my cursor. But is there, look at this photo, is there a difference in the color of the burn that's closest to the wrist versus the one that's down closer to the elbow? And to me, the one further toward the wrist is lighter, and the one closer to the elbow is darker. So what explains that? What physiologically explains a difference in the characteristics of the burn? Well, think about when water or any liquid goes onto a surface of your right arm. As that water drips down, there is longer contact with that water with the skin because it's dripping down. So the longer you have the contact, the deeper the burn. And look at the difference between the color of the burn at the top and the color of the burn at the bottom. Is there a difference? Yes. The color of the burn at the bottom is darker, which indicates a deeper burn, which goes along with liquid running down the arm, staying in contact with the skin longer, creating a little deeper burn. This is not skin sloughage for being in the water too long. Now, where you start to see sloughage is on the fingers. This is not from being immersed in the water for a couple of hours. That just doesn't make sense. I would not agree with Dr. Howard.
Okay, I think we have one of her heel. That's another one of her forearm. I think the next one is her heel there at the bottom. Would that be what you would call skin slippage? And how would that differ from what Dr. Howard called her forearm skin slippage?
Well, slippage, this could also be a burn. Now, what I was a little disappointed in Dr. Howard is it would be so easy to take a microscopic section of the heel of the arm and look at it under the microscope. Under the microscope, you can tell what is burned and what is just skin from excess water. Again, this may be a burn. I don't know what caused that, but I definitely know that what we see on the arm is, in fact, a secondary burn.
How quick is it to take a slice of either that heel or the forearm in what you think was the burn and make a determination that it is a burn?
Oh, just seconds. All you do is just make a little cut and you put it into a little cassette that we have at the autopsy, and you fix it. There's a process for fixing tissue, and you look at it with a microscope, and you can say, yep, this is definitely a burn, because that will look different than a non-burn.
Okay. Dealing with her jaw, Dr. Howard attributed her broken jaw to the gunshot. Can you tell us whether you agree with that and why you don't?
Absolutely. No. And the reason is, look at where the amount of bruising, number one, and where is that bruising on her body. If it did come from the gun, what would you expect to see? Because I've seen it from guns, but the teeth are going to be broken from the slide coming back. And that's the difference between the revolvers and semi-automatics, is because that slide, the top part, is going to come back, an inch or so. And if it is deep enough into the mouth, you would see a totally different pattern. But this pattern is not from internal trauma. This is a fracture and bruising from external, meaning there was some force applied to the left side of the jaw, and most consistent with a blow or a punch. But this is not what you expect to see from a slide inside the mouth, because the injury pattern doesn't fit that. No broken teeth and no hematoma, no blood collection on the inside of the jaw. It's all on the outside.
Okay. What's our next one? Same thing, just different angle?
Yes, sir.
So in terms of trajectory, Dr. Howard, can you go to the next one? Yeah, there we go. So Dr. Howard was reluctant to call that a downward trajectory, as was one of our other witnesses today. What do you think about that?
No, clearly this is downward. And where I put, this is from my report, where I actually put the tip of the arrow was actually a little higher than where the bullet hits. If you were able to zoom in and you look at that second cervical vertebra, look at all those other fragments. Actually, where it actually hit is even a little lower, maybe a half a centimeter lower than where I have the arrow. So it's clearly a downward trajectory, or bullet path, clearly down. It's not straight back. It has to be downward based upon where we see the damage on the x-rays. It's down.
Okay. And then we, Dr. Howard and I discussed head injuries. I think we have a slide addressing that coming up. Yeah, those things right there. So Dr. Howard attributed to the bleeding there to the incision he made in the scalp. Is that something that you would find correct?
No, I would disagree with Dr. Howard again. Those two areas of hemorrhage are 2 inches away from where the incision was made to reflect the scalp. And as someone who has made incisions at autopsies and reflected scalps, that this is evidence of trauma to Ms. Howard's scalp. That is 2 areas of hemorrhage leading into the tissue from blunt force trauma. That has nothing to do with the incision that was made at autopsy.
Okay. Then I think we talked about the thumb. Dr. Howard thought that was an abrasion. What do you think of that?
Now, I listened to Dr. Howard's testimony, and abrasion, he said, didn't break the skin. And so I asked the jury to look at this. This clearly breaks the skin, number 1. So it's not an abrasion. And 2, look at the edges, top and bottom of this wound. They are nice and sharp. That says there was some sharp implement that came across that portion of the tongue, something with an edge. There's no abrasion, there's no skin scraped across. There's no laceration, meaning where the skin is ripped and torn from the blunt force trauma. This, Dr. Howard, I followed his work for years. I think in his time, he was a great pathologist. But this is not an abrasion. This is clearly an incision, something caused by something that had a sharp edge.
Not a gunslide? Not a gunslide, doctor?
No, this is not a slide. I think I shared that with the jury. Having been a doctor for the SWAT team, treated thousands of gunshot wounds in my career, both living and dead. I mean, this is not a slide. I've had slide. This is not what it looks like.
Okay, I think we're done with our PowerPoint here for a moment, but I have a few more questions for you. Dr. Howard talked about how it was common to save tongues in an autopsy. I know that you've told us that you've participated in thousands of them. Has that been consistent with your work?
No, sir. I think the only reason we would save a tongue, and I've only seen it maybe once or twice, is if there's some sort of tongue lesion or cancer that we want to look at under a microscope. But no one routinely saves tongues. I was a little taken aback by that statement. We have refrigerators full of tissue in little plastic jars, and I don't know any medical examiner in the country that routinely saves it. In this case, I'm glad Dr. Howard saved it because we were able, Dr. Bernard was able to dissect it and get some more information. So clearly, we thought there was something important about the tongue, and there clearly was. But we don't routinely save tongues.
Okay. Dr. Howard also talked about the fact that he didn't need to see scene photos, much less go to the scene in order to make an assessment of manner of death. What do you think about that?
I couldn't disagree more. And I think I shared with the jury, when I was trained in Scotland and by the forensic pathologists in Scotland, we were mandated to go to every scene. And I even heard, I think that Dr. Howard said he hadn't even looked at the scene photos when he did the autopsy. That puts the pathologist or any forensic physician at a huge disadvantage. I want as much information as I can possibly gather or be given in any scene. Which is why I go to scenes, I send my medical students to scene, I train detectives, crime people, the importance of scene documentation and evaluation and collection of evidence. So not going to scene, not looking at photos of the scene before you do an autopsy, I think put Dr. Howard at a disadvantage by not having all the information that I think would have helped him in his evaluation of of Ms. Howard's death.
Dr. Howard also admitted several times to not taking photographs of various injuries. Is that the best practice method of someone doing an autopsy or not?
No, it's not. The way biologists and crime synthetics and the way I train my forensic nurses in synthetics, it is ideally you want a minimum of 4 photos of every injury on the body. And overall, a good range and a close one with and without a forensic ruler. And always take it 90 degrees so that that forensic ruler gives you an accurate assessment of the size of any particular wound. I think what was disturbing about Dr. Howard's autopsy, one, there were several injuries that weren't photographed, and 2, he lumped the injuries on the arms. Like he said, there are 10 bruises on the upper extremities. Now, each one of those bruises should be described individually because you don't want to lump all blunt trauma into one sentence. You need to put each injury and give it its due, and that did not happen in this time.
Is that because it's important to sometimes note pattern injuries?
Yes, it is. Again, I think it's important, and the way I approach it, in the living or deceased individual, is I look at each injury and try and figure out where did that particular injury come from. Is there a pattern to it? If there is, what object or implement created that particular injury? If there's no pattern, all I can say is one close one.
One of the other things that Dr. Howard said was that it was uncommon to have peculiar hemorrhages in strangulations. Excuse me, it was...
No. Go ahead, I'm sorry.
He said that you would typically find peculiar hemorrhages in strangulations. Do you agree with that?
No. There's some reason why you may or may not have petechial hemorrhages. When you take all asphyxia-related deaths, only 80% have petechial hemorrhages. But there are multiple, we call them pale hangings or pale strangulations, where you are strangled to death or hung to death, and you have no petechial hemorrhage. Remember those 3 criteria that are required to create petechial hemorrhage anywhere in the body. 1, you have to have venous obstruction. So on the back, you have a blockage of the jugular vein. 2, you have to have arterial inflow. And the analogy of looking at water, in order to pop a balloon, we've got to have water going into that balloon. And in order to pop a capillary, we've got to have blood being pumped in from somewhere. However, it's not uncommon, particularly when you do what's called a urinating choke, where you put in pressure here, block the jugular vein, and then you're putting pressure on the back and sides of the neck to be able to block 100% of the blood that flows to the brain. And so that second criteria of arterial inflow is met, and you are dead, strangled to death, and you have no petechial hemorrhage. So, is it common to see petechial? Yes, but you have to analyze and understand why sometimes you do and why sometimes you don't. And you have to have those 3 criteria that have to be met in order to have a petechial hemorrhage from a fatal or even your fatal strangulation.
Have you encountered Jeffrey Desmoulins before?
Yes, sir, I have.
Have you had the opportunity to peer review his work?
Yes, sir, I did.
Have you found problems in his work that he has had to address on prior occasions?
Yes, sir. I encountered one of his reports in a case, Guy versus the U.S. There was an officer involved in shooting. And once I peer reviewed his report, we found several inaccuracies and mistakes. I've made the U.S. Attorney's Office aware of those mistakes, and Jeffrey Desmoulins had to correct that on the next report.
Mr. Desmoulins talked about how much he expected to make from this case. About how many hours do you think you have into this matter?
35, 40 hours.
And
I've never sent you a bill in these cases at all. I've never sent you a bill at all. So.
what do you expect to bill us?
I expect it to be somewhere between 15 and 20,000 at the end of the day.
Thank you, Doctor. I don't have any other questions for you, but Mr. Johnson might.
Thank you, Mr. Turner.
Motion to postpone, Council.
Right.
Hi, good afternoon, Doctor.
Good afternoon, sir.
Now, Dr. Nara testified that the damage to the lip would be consistent with the damage to a gunshot wound. Would you agree with that?
You're talking about the left side of the lip or right side of the lip or both? Because neither, in this case, are consistent with an intraoral gunshot wounds.
Okay, so
Very
you
good
disagree with
question.
Dr.
I'll
Nara
bring that up. I have an issue
if
with
she
that, but it's
said
too
that the
late.
damage would be consistent with the gunshot wound?
Again, are you talking about right, left, or face, or?
The right lip.
I'm sorry, I think you broke up. You're saying
The right lip.
side?
Yes. The left side. The left side lip.
Okay, the left side, no, I would disagree with that, for the reasons that the injury, the bruising is on the outside and going down this way. And if she's dead, when the gunshot wound was sustained, one wouldn't get the bruising. So the bruising occurred before the gunshot wound occurred. And when I've seen intraoral gunshot wounds that do cause damage, 100% that the teeth are damaged. And you have to also ask yourself, how would that injury occur if there were some force from inside the mouth that caused the fracture to move outward? And that's not how it happened, because if that were the case, you would have to have the damage to the teeth, the inside, and you expect to see bruising on the inside of the mouth, inside of the gum. And where do you see it in this case? You see it on the outside.
Dr. Nara also.
I would not agree with that.
I apologize, Doctor. The Zoom sometimes. Dr. Nara also testified that the bleeding would be contained in the mouth. Do you agree with that? I'm not asking for why, but do you agree with that?
Which bleeding? Bleeding from the gunshot wound?
Yes, bleeding from the gunshot wound.
Yes, there will be bleeding. Well, it depends. If her heart is beating, no, I expect the blood to be outside of her mouth. Because with each pump of the heart, you're going to see arterial venous blood spewing out of the mouth. So you expect to see some blood from the injury itself pooling inside the mouth? She said yes. That can certainly happen. And in this case, it did happen. But because the gunshot wound occurred after she was already dead, we don't see the amount of blood you expect to see if she were alive.
Might be a delay, but can you see my screen?
Yes, sir.
Okay, this is, I believe it's 18F. And this is a photo taken after autopsy, correct?
Yes, I believe, I don't know if this is the funeral home or the autopsy, but clearly she is on a table.
Good. And you're aware that Dr. Howard took 129 photos, correct?
Dr. Nara took 129 or?
Dr. Howard took 129 photos?
That's correct, sir.
Okay. And you traveled here recently, so you're aware that we have 2 states that are in close proximity, correct?
I'm sorry, you broke up. 2 what are in close proximity?
2 states that are in close proximity?
Yes, Idaho and Washington, yes, sir.
Is it your understanding that as a Spokane medical examiner that Dr. Howard would be allowed to go to the scene of an Idaho case?
In my experience, if a investigator wants, anybody can go anywhere if they want to see a scene. I would think any detective would relish having a forensic physician go to the crime scene.
Are you aware? Sorry.
I don't know any, personally, I don't know any state law that would prohibit Dr. Howard from going to a crime scene in Idaho. I don't know any state law that would prohibit anybody from crossing the state lines.
Doctor, do you know what software that the Idaho coroner uses to communicate information to the Spokane medical examiner?
No, sir.
Do you know what information was transcribed from the coroner who was on scene to Dr. Howard prior to the autopsy?
No, sir.
Okay.
I did hear Dr. Howard say he didn't see any photos of the scene prior to his autopsy.
That was his testimony, his live testimony, you talking last week?
I believe so, sir.
3 years after his autopsy?
I'm sorry, the connection is not good. Can you repeat the question?
I'll withdraw. Now, would you agree that skin slippage can be sped up by submersion in water?
Certainly.
Would you agree the skin slippage can be also...
Depending on, I'm sorry, sir, depending on how long someone is submerged.
Would you agree that pressure can also increase skin slippage?
Certainly.
Looking at 16G, can you see which direction her body is leaning?
I think you said which direction her body was leaning?
Yes.
Well, what I see is, let's just kind of dissect that. I see her left leg, left knee leaning up one way. I see her right knee leaning another way. I see her left arm leaning against the wall. And I see her right arm against the wall. And I'd like to bring this up because look at...
And Doctor, I'm going to direct you. I just asked...
The witness should be allowed to finish his answer before he's interrupted by counsel.
It's counsel's witness, he can direct him, if that was, I'm allowed Mr. Counsel to interrupt him.
Then, moving on to the bathtub. How much blood went down that drain? Can you tell us that?
Don't know how much blood went down, but we know that from the different photos, there's a little less than an inch of water that drained out. The blood seems to be pooled right along the center of the bathtub.
On the arm, the bruising did not cause the death, correct?
No, sir. The bruising was part of the assault. It was not caused.
And there's a difference between bruising and lividity, correct?
Absolutely.
Your theory of strangulation comes down to lack of blood, correct?
No, sir. The presence, the reason was, well, let's go back to her lips. There's evidence that her lips were pushed into her teeth. There's evidence of pressure on the left side of her nose. And then the very first photo that was shown in the PowerPoint showed bruising to the front of her neck. So I believe she died of asphyxia. It was all strangulation, all suffocation, or combination of both. And that's how she died.
Her head was slumped forward in the tub for a long period of time, correct?
I'm sorry, I didn't repeat your question.
Her head was slumped forward in the tub for a long period of time, correct?
For some period of time, I don't know how long. It was clearly slumped forward from the time the photo starts until she was removed. But I don't know, I can't define a long period of time.
The photos you reviewed, do you know the gaps in time in which they were taken?
Yeah, it was over a period of hours, so unless when I go back to the photos, I couldn't, you did tell me exactly when the first was taken and the last was taken, but I haven't done it.
Now, I'm showing you, and I apologize, I don't want to dwell to the jury, I don't want to dwell this too much, but showing you what's been marked as 20M. This is photo as part of the autopsy, correct?
Yes, sir.
The autopsy is a traumatic experience to the body, correct?
No, sir, it's not a traumatic experience because the heart is beating. Now, we're not beating the body of autopsy. I'm a pathologist prior to making decisions with a sharp scalpel to reflect and remove tissue. It's not traumatic, no.
But counsel showed you a picture earlier with the face swollen, correct? From one of the corners. That would.
Bruising to her mouth and her jaw, and he also showed you this photo of the blunt force trauma to the top of her skull.
The photos taken by the coroner were taken 2 days after autopsy, correct?
There were some photos that were taken by the coroner, yes, 2 days after autopsy. The photo, I think, you just showed was taken at autopsy, as well as some of the other photos.
You talked about the tongue being saved. Remember counsel talked to you about that?
Yes, sir.
The point of injury with the tongue was unique in this case, correct?
I'm sorry, you said something about the tongue? You can eat with the tongue, is that what you said?
I don't know if standing closer or backwards will make it better, but can you hear me better?
Let's try to answer. If you could repeat the question, please.
The tongue, in this case, had unique injury, correct?
It had a bullet going from top to bottom through it.
From,
That was
sorry, I'm not meaning to cut you off, because when you start a new sentence, I think you're done, so I apologize. So doctor, you said it top to bottom, tip to back?
So the tongue, the bullet went through the top of the tongue, out the bottom of the tongue, and into the spinal cord.
So he made a correct decision to save something of potential evidentiary value, correct?
Yes, sir, it did.
Okay. The tongue is a muscle?
The tongue is a muscle with sensory organs built into it as well. These buds, yes.
Now,
It's correct.
I apologize. You testified a couple weeks ago that you reviewed the materials in 2021, correct?
That's correct, sir.
You were provided the autopsy photos in 2021?
Yes, sir.
You were provided the scene photos in 2021?
Yes, sir.
You were provided the autopsy report in 2021?
That's correct, sir.
You provided coroner photos in 2021?
That's correct, sir.
You stated later that you were asked to review it maybe on one other occasion? Is that
I
right?
was asked her initially to review it in 2021.
Okay. And then you reviewed it, at that time you needed more information?
That is correct, sir.
And you were asked to review it one more time?
After doctors had reviewed it, after Dr. Nara had entered a section, that's correct. And there's additional information.
Okay. And you did testify, I'll withdraw. No further questions. Permission to retrieve exhibits.
Yes. May? Thank you, Mr. Johnson. Redirect, Mr. Remain.
He's not going to go see that.
Hey, Doctor, we are looking at, it was 16G, it's a photograph of Kendy in the tub, and I think you were describing that to Mr. Johnson when you were cut off. Do you remember that?
Yeah, if you can pull it up, I can't see it. Because I think there's some important information that I would love to explain to you.
All right, let's see if we can get that PowerPoint back up. So that burns on the inside of the right corner, right?
Yes, sir.
And counsel was asking me some questions about how pressure can lead to skin slippage, right?
Yes, sir.
Now, when we're looking at that photograph, you were starting to describe how her right arm was placed to include her forearm. Can you continue with that?
Yes, sir. What I wanted the jury to understand is that I think the defense counsel requested which way was the body leaning. Well, it's kind of leaning both ways. Look at where there is actual pressure on the body. If you look at her left arm, left elbow is up against the wall, and there's no skin slippage on that part of the arm. And let's go to her right arm. What part of her right arm is actually in contact with the bottom of the tub? It's the elbow. There's no skin slippage at the elbow. And then look at the inner surface of her right arm. Her wrist is up at the top of the water. So her elbow's in contact. There is no pressure against the inside of her arm. And it's not there. That part of the arm is floating in the water. So to say, to make the assumption that this part is because of pressure against the bathtub, this photo, there is no pressure against the inside of her right arm against the bathtub, period. So it's not skin slippage from pressure, because there's no pressure on that part of the arm. What we're seeing on the inside of her right arm are thermal injuries. Those are second-degree burns. And look at what part of her knees are in contact. It's the outside of the knees. You see any skin slippage there? No. But even more important, so think about if you spread your legs in a frog leg position, which way are your feet now in contact with the bathtub? What happens is your feet are going to lift up. So, but I think getting back to the original question about what caused this skin slippage on the inside of the right arm, they're thermal injuries. There is no pressure from the bathtub, bottom of the tub, on the inside of the right arm that would cause it. It's free floating in water. I think that was what I wanted to talk to you when I got that.
Okay, if I take that off if you like. So, counsel asked you a couple questions about being involved in this case in 2021 and then coming back and taking a second look at it later after you got more information. Have you done that before?
Yes, sir.
Can that be common in cases like this, in cases involving staged crime scenes?
Yes, sir.
Why is that?
The reason it's common, the reason it's common, the reason that's my personal standards, before I render any opinion in a criminal case, I have to be 100% convinced.
Now, this is something people brought up, and I think this is an issue. This thing, strangulation prevention, I think that's a little prejudicial. It's not the end of the world, but I would have asked that got changed, but there's nothing to do about that. So.
Call that reasonable medical and scientific certainty that I'm going to render an opinion that can have criminal implications for a potential defendant. In my opinion, before I'm going to put my name on the line, is I have to be 100% certain that my opinion is based on all the evidence that I have. And when you first presented that to me back in 2021, I said, I need more information, or I can put pen to paper and tell you, did I think she was a homicide? Yes. But was I ready to put that in writing? Not until I got additional information.
Are you 100% convinced that this was asphyxia?
Yes, Your Honor.
And are you 100% convinced that this is a homicide?
Yes, Your Honor.
All right. Well, thank you. No further questions.
Thank you, Dr. Slot, for your appearance. We'll let you sign off.
Thank you, Doctor. Have a great day.
You too.
You good on the rebuttal? That was the extent of a rebuttal case, Judge.
Thank you, Mr. Heron. All right, members of the jury, you've now heard the entirety of the evidence, and so we're going to take a recess. I'll just be honest with you, this is a longer recess. And just so you know what's happening, I don't think you have to just go on for it. I'll be preparing the final jury instructions. I'll be providing them for you. While I'm doing that, counsel's going to be organizing their thoughts for closing arguments and things like that. And so this just honestly takes a little while. But I anticipate coming back. I'll be reading you the final jury instructions. The attorneys will be giving you their closing arguments. I suspect that will take us close to the end of the day. And just so you know as well, when it comes to deliberations, I'm not supposed to keep you here after 5 o'clock unless you all unanimously decide you want to stay and deliberate longer. And if you do that, you can. But if we're going on a regular schedule, I would anticipate you might get into deliberations and we'd probably let you go at 5. Again, I'll let the jury make a decision when we get to that point. If you are unanimous that you want to stay longer and keep talking. But everyone would have to agree because I can't keep anybody past 5 if they can't. So, but anyway, I just wanted to give you a sense of where we're headed with this. So we'll be in recess at this time again. I'll admonish you not to discuss the case yet among yourselves. I'll have a chance to do that soon. Do not discuss the case among yourselves or with anyone else. And I kind of apologize in advance that this is a longer break, but I want you to kind of understand why it is. Okay, we'll be in recess at this time. Counsel, I don't know if you got a chance to see it yet. I did ask my law firm to send you the verdict form as well. It's pretty good. Obviously, as the first count, it's just guilty, not guilty. The second count hasn't included offense, so it starts with a question and then goes to the second one. Just take it when you get a chance to look that over. And then I know Mr. Johnson, you have a little bit of time, so will the parties be ready to be back at 3 o'clock, or is that sufficient?
Yes, sir.
Is that what for the state?
Yes.
Okay. Have you seen the verdict form yet or not?
I took a look at it during testimony.
Judge, my only feedback is whether or not it's confusing calling what is actually the second question that the jury is being asked to answer question number 1.
We were back and forth on that. If the parties want, I can label the first one question 1, question 2, question 3. Okay.
Thank you.
On the fence on that. Mr. Johnson, is it the right to you?
Yes, Your Honor, I would agree.
Okay. We'll just call the first one question 1 about that. Okay, thank you, counsel. We'll be back at 3 o'clock.
All rise.
So guys, well, that was interesting. I saw a couple people, looks like there were some new names, like, who's this guy in the corner? Well, I'm potentially criminal. I'm an attorney in Cleveland, Ohio, and we've been covering this from day one. I don't know. I think that Desmoulin, the defense expert, I think did a good enough job. I think there's enough doubt there that was created with that to explain why this happened the way it did. Do I think the jury's going to buy it? No, I think they're going to convict him. But I think there's reasonable doubt here. I don't think it's clear it happened the way it did. The issues about how the blood came out of the tub and all this nonsense. Yeah, I think all that is in. I think all of that is in his favor. But yeah, I'm definitely. If I'm ever in a kinesia, like a situation like that, and I have a client who can afford it, holy cow, yes, I would use that guy in a heartbeat. He is phenomenal. He is well educated. He's very calm. he doesn't get rattled when the prosecutor starts screwing with him. He battles back in a very professional and quiet tone. I mean, what's not to love from that guy? That dude was hitting it up. Yeah, the state's case ultimately, yes, and Dr. Smock coming in at the end. Yeah, that's a good way to end it. But I just, their argument is he's a cop, therefore he could have done all this. It's like, yeah, but a lot of people could have done this. So I don't know. I think that's the problem with the state's case. Well, therefore he knew about this stuff, so therefore he did it. It's like a lot of people know this stuff. So, but let's skip ahead here. We're chugging along, guys. We only got a little bit left. And for some reason, it feels like it's not playing at speed. So we're just going to try to keep it going. It's at 1.4. And we'll keep the time going here. Let's catch up.
Members of the jury have heard now the entirety of the evidence. I'm going to provide you what are called the closing jury instructions. As I indicated to you earlier, I'm going to be reading these instructions to you. I don't do that to be impersonal because you're going to each get your own copy of the instructions that I provided. And I want to make sure I don't, speaking off the top of my head, forget something or mistakes. So I'll now provide these instructions to you. Instruction number 14. You have now heard all of the evidence in the case. My duty is to instruct you as to the law. You must follow the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree or don't understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any I tell you, it is my instruction that you must follow. Instruction number 15. As members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of 1. Sworn testimony of the witnesses, 2. Exhibits which have been admitted into evidence, and 3. Any facts to which the parties have stipulated. Certain things you have heard or seen are not evidence, including 1. Arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. 2 of things which are not evidence. Testimony that has been excluded or stricken, for which you have been instructed to disregard. And 3, anything you may have heard or seen when the court was not in session. Instruction number 16. In order for the defendant to be guilty of count 1, domestic battery, the state must prove each of the following. 1, on or about July 10, 2020. 2, in the state of Idaho. 3, the defendant, Daniel Charles Howard, committed a battery upon Kendy Howard by causing injuries to him. 4, while they were household members. And 5, in doing so, the defendant inflicted a traumatic injury or injuries upon Kendy Howard. If any of the above has not been proven beyond a reasonable doubt, you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, then you must find the defendant guilty. Persons are household members if they are married to each other, were ever married to each other, or have a child in common, regardless of whether they have been married or are cohabiting. Traumatic injury means a condition of the body, such as a wound or external or internal injury, whether of a minor or serious nature, caused by physical force. Instruction number 17. A battery is committed when a person, 1, willfully and unlawfully uses force or violence upon the person of another, or 2, actually, intentionally, and unlawfully touches or strikes another person against the will of the other, or 3, unlawfully and intentionally causes bodily harm to an individual. Instruction number 18. In order for the defendant to be guilty of count 2, first-degree murder, with malice aforethought, the state must prove each of the following. On or about February 2, 2021, in the state of Idaho, the defendant, Daniel Charles Howard, engaged in conduct which caused the death of Kendy Howard, to wit, by asphyxiating her. 4, the defendant acted without justification or excuse. 5, with malice aforethought. And 6, the murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time during which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not premeditation. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond reasonable doubt, then you must find the defendant guilty of first-degree murder. Instruction number 19. Murder is the killing of a human being without legal justification or excuse and with malice aforethought. Instruction number 20. Malice may be express or implied. Malice is express when there is manifested a deliberate intention unlawfully to kill a human being. Malice is implied when 1. The killing resulted from an intentional act, 2. The natural consequences of the act are dangerous to human life, and 3. The act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of time. It only means that the malice must precede rather than follow the act. Instruction number 21. If your unanimous verdict is that the defendant is not guilty of first-degree murder, you must acquit him of that charge. In that event, you must next consider the included offense of second-degree murder. Instruction number 22. In order for the defendant to be guilty of second-degree murder, the state must prove each of the following. 1. On or about the second day of February 2021. 2. In the state of Idaho. 3. The defendant, Daniel Charles Howard, engaged in conduct which caused the death of Kendy Howard, to wit by asphyxiating her. 4. The defendant acted without justification or excuse. 5. With malice aforethought. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of second-degree murder. If you find that all of the above have been proven beyond reasonable doubt, then you must find the defendant guilty of second-degree murder. Instruction number 23. Videos, text messages, and various exhibits have been admitted into evidence that were redacted by order of the court. You are instructed that you are not to concern yourself with any redactions that have been done to any of the evidence that has been admitted in the case. Instruction number 24. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, you were admonished that it could not be considered by you for any purpose other than the limited purpose for which it was admitted. Do not consider such evidence for any purpose except the limited purpose for which it was admitted. Instruction number 25. It is alleged that the crime charged was committed on or about a certain date. If you find the crime was committed, the proof need not show that it was committed on that precise date. Instruction number 26. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 27. You have been instructed as to all the rules of law that may be necessary for you to reach a verdict. Whether some of the instructions will apply will depend upon your determination of the facts. You will disregard any instruction which applies to a state of facts which you determine does not exist. You must not conclude from the fact that an instruction has been given that the court is expressing any opinion as to the facts. Instruction number 28. The original instructions and the exhibits will be with you in the jury room. They are part of the official court record. For this reason, please do not alter them or mark on them in any way. The instructions are numbered for convenience in referring to specific instructions. There may or may not be a gap in the numbering of the instructions. If there is, you should not concern yourselves about such gap. Instruction number 29. I have outlined for you the rules of law applicable to this case and have told you of some of the matters which you may consider in weighing the evidence to determine the facts. In a few minutes, counsel will present their closing remarks to you, and then you will retire to the jury room for your deliberations. The arguments and statements of the attorneys are not evidence. If you remember the facts differently from the way the attorneys have stated them, you should base your decision on what you remember. The attitude and conduct of jurors at the beginning of your deliberations is important. It is rarely productive at the outset for you to make an emphatic expression of your opinion on the case or to state how you intend to vote. When you do that at the beginning, your sense of pride may be aroused and you may hesitate to change your position, even if shown that it is wrong. Remember that you are not partisans or advocates, but are judges. For you, as for me, there can be no triumph except in the ascertainment and declaration of the truth. As jurors, you have a duty to consult with one another and to deliberate before making your individual decisions. You may fully and fairly discuss among yourselves all of the evidence you have seen and heard in this courtroom about this case, together with the law that relates to this case as contained in these instructions. During your deliberations, you each have a right to re-examine your own views and change your opinion. You should only do so if you are convinced by fair and honest discussion that your original opinion was incorrect, based upon the evidence the jury saw and heard during the trial, and the law is giving you in these instructions. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. However, none of you should surrender your honest opinion as to the weight or effect of the evidence, or as to the innocence or guilt of the defendant, because the majority of the jury feels otherwise, or for the purpose of returning a unanimous verdict. Instruction number 30. Upon retiring to the jury room, select one of you as a presiding officer who will preside over your deliberations. It is that person's duty to see that discussion is orderly, that the issues submitted for your decision are fully and fairly discussed, and that every juror has a chance to express himself or herself upon each question. In this case, your verdict must be unanimous. When you all arrive at a verdict, the presiding officer will sign it and you will return it into open court. Your verdict in this case cannot be arrived at by chance, by lot, or by compromise. If, after considering all of the instructions in their entirety, and after having fully discussed the evidence before you, the jury determines that it is necessary to communicate with me, you may send a note by the bailiff. You are not to reveal to me or anyone else how the jury stands until you have reached a verdict, or unless you are instructed by me to do so. A verdict form suitable to any conclusion you may reach will be submitted to you with these instructions. And you'll receive, these are the original instructions that will go back with you. You'll each have your own set. And then you'll also see an original verdict form, and I'll just read it to you now. The verdict form will say State of Idaho versus Daniel C. Howard is case number verdict. And it reads, we the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Count 1. Question 1. Is the defendant, Daniel C. Howard, guilty or not guilty of domestic battery? And then you check the box either not guilty or guilty. Count 2. Question 2. Is the defendant, Daniel C. Howard, guilty or not guilty of murder in the first degree? Again, you check not guilty or guilty. The form then reads, if you unanimously answered question 2 guilty, then you must sign and date the verdict form. So you would just flip over and sign the last page. If you unanimously answer question 2 not guilty, then proceed to question 3. Question 3 asks, is the defendant, Daniel Howard, guilty or not guilty of second-degree murder? And you would check not guilty or guilty. When you flip to the back page, it says, once you have selected a verdict for each count, date and sign the verdict form and tell the bailiff that you are done. And then the presiding officer would date and sign it. All right. This time, we'll now hear closing arguments. State will go first. You may proceed.
Thank you, Your Honor. I'm just going to slightly move the D10.
That's fine.
Who was Kendy Howard? Kendy Howard was fun. She was communicative and engaged in her life, as her family, as her friends. She loved her parents, her brother, she loved her children, and especially her granddaughter. She had hobbies, passions, things in her life that brought her joy. And in the months before Kendy Howard's death, Kendy was moving towards something. She was moving towards a new future, a new house, a new relationship, a new life that was away from the financial, emotional, and psychological control of the defendant. When you have eliminated the impossible, whatever remains, however improbable, must be the truth. Throughout this case,
You gotta stop, guys. When you're trying to do this, don't use quotes from fictional characters. Sherlock Holmes wasn't the best detective. He was a drug addict and a womanizer. Like, you gotta be careful about this. This is not... Also, those pictures of Kendy, she didn't look like she was, like, getting liposuction and all that. Like, she didn't look like she needed any of that shit. Like, so I think people like, oh, she said she was fat. Like, she's not like she's, like, huge or anything, so... Whatever, but... Yeah, don't use... This is like using fucking Harry Potter. This is like using fucking Harry Potter. Do not be this person. It's like, the bad guy's Voldemort. You can't even say his name. He's so bad. Don't do this cringe shit. Don't.
The state has shown you that Kendy Howard did not kill herself. Kendy Howard did not kill herself because Kendy Howard was full of life, moving towards that future. And Kendy Howard did not kill herself because Kendy Howard was dead when she was shot through the mouth. The defendant killed Kendy Howard.
Allegedly.
Now, back in July of 2020, Kendy was very much still under the financial control of the defendant. And on this particular day, they were, once again, arguing about money. As Michelle Lampert told you, Dan's money was Dan's money, and Kendy's money was Dan's money. And messages between Kendy and the defendant on that day tell us that they were, in fact, fighting about money. Now I'm pissed, he says. She would later confirm with Dan Prado that the fight was about money, and that it got to a blowout point. Later that evening, she would call 911 frantic and terrified. She would tell that 911 operator that she heard something, a shot, that she doesn't know guns. Later, when law enforcement did arrive, she would not report anything. And who was standing next to her? Her son Wyatt. She didn't report in front of her son. But she does tell the next day. She's texting, communicative as always, with her friend Michelle Lampert. And you can read these entire conversations. They're available to you. She sends her these bruise photos as well. She shares it with Dan Prado as well, talking about how this happened and implying who did it. Talks to Dan Prado about being made to erase her phone. Because as Ms. Markhoffer, the prosecutor investigator, told you, Kendy likes to take selfies. There were a lot of selfies on her phone, and we have some from this time period. That one of her ear was taken at 8:25 p.m. on July 10th. And then there were the photos that were on her phone that she didn't send. She took lots of bruise photos. Photos to her chest, to the front of her arm, to the back of her arm, to her other arm on the other side, underneath her arm, and to her neck. And Kendy didn't share these photos. She took them. And these are dated July 12th. Now, in order for the defendant to be found guilty of count one domestic battery, the state must prove several things. On or about the 10th day of July, that's when Kendy says it happened, that evening. In the state of Idaho, their home in Athol, the defendant committed a battery upon Kendy Howard, causing injuries to her. And certainly in those conversations, they were household members, they were still living together and married at the time, and in doing so inflicted a traumatic injury. All of those bruises on every part of Kendy's chest, under the arm, on the side, those weren't made from slipping on a trolling motor. It is convenient that the defendant's best friends, Brett Gunderson and Carrie Maitland, remember that 4 years ago, exactly on July 10th, they saw Kendy slip on the trolling motor. But again, those photos from inside the Kendy's phone, they don't match that timeline. Because Kendy and Dan pulled both out and went to Dvorak on July 15th, 5 days after this event. The bruise, seen in pictures at Dvorak, it's fading. This happened on July 10th, and it didn't happen with slipping. Maybe slipping might explain that one on the chest that was visible to other people, but it doesn't explain all those other bruises. Now, Dr. Bostack testified, and she talked to you about all of the reasons that victims of domestic violence do not report. Why they don't report to law enforcement, and why they don't share details with their family, with their friends. Why they stay in relationships where they are ridiculed, where they have mean comments said to them, where they are controlled, isolated, and abused. Brooke took the stand. She told you things that she's heard her stepfather say to her mother. Things like fat, bitch, dumb. But what did change in July is that Kendy got serious about leaving. She started talking with her coworkers. And Kendy didn't share with her coworkers because Kendy was communicative. Like how she told her coworker Matt Kulak. She didn't get that bruise at work. But she starts talking to him about how she's going to be leaving that job. She's going to be leaving her job of many years, and she's moving to Cambiai. And she's asking her bosses for references and to look at job postings. And she's talking to her friends about maybe she's not going to stay with the hospital. Maybe she's going to follow her passions, open up a little antique store. And Kendy is working with her boyfriend, who was a realtor, to look at houses down in Cambiai. And on January 22nd, her offer on that house in Camden was accepted. She signed paperwork, entered into a contract, and even back on January 22nd, she was getting advice from Dan Prado that she would have to get a quitclaim deed. She was communicating about this, she was asking questions, she was getting that information that she needed. She was also talking with her friends about this idea that she's going to leave Dan Howard. She's telling them about her feelings. She's sharing. She's engaged with her friends and her family. And what's more, she's supported. Her friends are telling her, you know that we'll support you. You know that you've got somewhere to go if shit gets bad. And Kendy, she's excited. January 24th, she is out shopping. She's getting to choose decor for the house that's going to be all hers. She's getting the hot tub that she's always wanted. She's getting to make those purchases for her future. And yes, we know again from Kendy's phone, Kendy was having thoughts. She was wondering about things. There's a screenshot, never sent, in her phone, saying, why not agree to just keep each other's own pension? Only one person she would have sent that to. But Kendy wasn't a person to keep her thoughts just in her mind. Kendy sought out information. Like on January 26th, Kendy reaches out to her friend Zach Jones. Says, hey, how much is my house worth? How much are those lots in Spirit Lake worth? And even talking with him about how she knows she's going to have to get something written up for the new house in Camden. And maybe also talking to him about some of her fears. But that isn't where Kendy stopped. January 27th, Kendy met with Matt Grace, the attorney. And in that period of time, Kendy found out that she was entitled to the $2 million in community property that they had. She would be entitled to half. Half of the house in Athol, half of the lots in Spirit Lake, all of the toys that they had accumulated over the course of their 26-year marriage, half of the retirement accounts, including Dan's retirement account, and cash. Because Kendy was seeking out that information. She was getting informed, and she was sharing that information that she was learning from mom, from friends. January 28th, Kendy does something for her. On that day, she goes and she makes an appointment for a mommy makeover. January 28th, she makes that appointment. That appointment is set for later in February. Because as we know, Kendy had some body image issues, likely fueled by the abuse that she had sustained in her marriage from her husband. She had been on diet pills that she got from Dr. Ford, her family doctor, as well as from Kristen Miller at the Real Weight Loss Clinic. But Kendy was moving forward, looking forward, making those future plans. And during this time, Dan's up in Alaska, and he's getting bits and pieces of this, and they're starting to text and talk about it, and he said, we can talk about this when I get home. On January 28th, Kendy goes and picks him up from the airport, drives to Spokane, picks him up. And Kendy, ever communicative, is talking with her childhood friend Tana. She's telling Tana on the 28th, I asked for a divorce. Tana says, what's his reaction? And he says, not good. But despite that, Kendy tells Tana, when Tana asks, how do you feel? She says, never felt so good. That feeling did not last for Kendy, because Kendy went to bed. And then the next morning, early in the morning hours of the 29th, she woke up. She woke up to the defendant standing over her in black or dark colored clothes, wearing black latex gloves, holding something in his hand that was probably like a pillow. His other hand she couldn't see. And Kendy saw a look in his eyes that terrified her. She opened up a line to Dan Prado. She managed to get to the bathroom, and what Dan Prado heard through that open line, well, it terrified him. He could hear the fear in Kendy's voice. He could hear the defendant's voice. So he called Jamie and Wendell, people that he had his own relationship with, his own friendship with, and told them, I'm scared for Kendy. And so they called 911, and Wendell got a hold of Kendy on the phone. And Wendell, as he is talking to Kendy in that bathroom, what does he hear? He hears Dan Howard's voice saying, I would never hurt your daughter. Wendell stays on the phone until law enforcement gets there. And when they get there, and you all got to watch the video, what they find is a Kendy who is barely speaking above a whisper. All she wants to do is pack a bag and get out of there. And finally, away from the defendant, as the defendant's downstairs with Deputy Broughton, Deputy Traw is able to ask Kendy, what is going on here? What do you think was going to happen? She tells him, he was going to kill me. She doesn't say it just once, she says it several times. Downstairs, the defendant relaxed on the couch, doesn't understand why everybody's there. And so Kendy is walked out by the deputy. She gets in her car and she calls Dan Prado. They talk for almost an hour. And she tells him all of those same details. She calls Michelle Lambert. They talk for almost half an hour. Tells Michelle all those details. Her story is consistent. She gets down to Camden. She talks with her parents. Wendell, he goes and gets his own .380 magazine clip, tosses it on the floor. And Kendy says, yes, that's what I saw on the floor, but when I went back to look for it, it was gone. The defendant, meanwhile, he is blowing Kendy's phone up, texting her saying this was all a big misunderstanding, telling her that she's safe here. He doesn't stop there, though. Over the next course of that day, he calls Kendy 23 times. 16 times between 6 a.m. and 10:30. And then 7 more times later that day. But that isn't the only way he's trying to get a hold of her. He is sending her message after message, telling Kendy, love with a changed man. What's not to love? Sending her photos of them from happier times, all to lure her back home. Come home. This is a big misunderstanding. You're safe here. And despite her family and Dan Prado's pleas to the contrary, she does. She goes back. She tells them, look, I've got an eye appointment I've got to keep. I've got to give my notice at work. I've got to finalize this divorce. She tells them, he got caught. He's not going to do anything now. And she does. She goes back. January 30th, she goes and she keeps her eye appointment and she puts in an order for 2 pairs of prescription glasses. Glasses that she will have to pick up in the future. Meanwhile, she is again still ever communicative, talking with people, and she's talking to the defendant. And around 7:33 p.m., during their conversation, she sends the defendant the listing for the house in Kendy. A listing that has Dan Prado's name on it, Dan Prado's face. That night, when she gets home, it's a different Dan, new attitude. Now he's willing to sit down, he's willing to do the paperwork with her, he seems okay. And they do, they sit down and they fill out asset division, they fill out the divorce papers. And Kendy, ever communicative, she's sending these to Dan Prado. This is what we're talking about, this is what we're doing. And in that conversation with Dan Prado asks her, what are you leveraging for the quitclaim deed for the Kendy house? That was in there too, it's part of the trade. He's hard to read Kendy's text, but he's hooded with that. House part of trade, no guns, mounts, and safe for deed. That conversation indicates Kendy and the defendant talked about the Kendy house on January 30th. So February 1st, after having this conversation with the defendant the night before, Kendy moves forward. She's moving forward with this plan to divorce the defendant. She reaches out to Courtney Lambert, they talk, they set a plan. Courtney's gonna come by the house on Thursday, walk through it, get the listing ready. Courtney even indicates she's got a buyer lined up for $800,000. Kendy is moving forward with this plan. Meanwhile, Dan heads down to Lucille. He stops in Lewiston, he picks up Brian, and as they are driving down, Brian testified. Brian told you that Dan pulled out his phone and showed Brian the listing of the Kendy house. That same listing that Kendy had sent to him. That same listing that had Dan Prado's face, Dan Prado's name. They talked about whether or not Kendy was having an affair. They talked about their suspicions and whether or not Dan Prado was that guy. By the time that Dan Howard talks to Detective Sergeant Lawton, he's downplaying that. Told him I didn't care much at that point. That's not what Brian said. Brian said that Dan was up pacing all night. That Dan was pacing all night, that Dan was driving erratically, and Dan was upset. February 2nd was Kendy's last day. Started out totally normal. Kendy went to work, as she did, based on her schedule. She clocked out around 4 o'clock, on schedule. Her coworkers who worked with her that day testified she didn't have any injuries to her that day that we saw. She didn't have any burns to her arm that we saw. We didn't know anything about Kendy being injured at work. And it was a good day, because while Kendy was at work, down at Kendy, a home inspection was going on. And Kendy, of course, ever communicative, she's talking with Dan Prado about this. Everything is good. Home inspection went great, closing can move forward. She's also telling Dan Prado, he's still trying to hang on. Him being the defendant, not fully accepting this is happening. He's still bleeding. But Kendy, she is resolved. She is moving forward. She is ready to keep going. She wants the house in Kenyon. She wants the divorce. After work, she goes and she gets her nails done in Liberty Lake. Nina Pham testified, and he was in a good mood. No injuries to her hands, her arms. Her mom's nervous. Erase everything off the phone. Kendy stops and gets McDonald's on the way. That McDonald's is about $7 food for her. She then talks to Dan Prado on the way home. For a few minutes, he testified that she seemed good. She was in a good mood. Kendy would go home. She would talk with her mom that evening. And what were they talking about? Mundane stuff. About the house in Camden, decor, dressers. Things looking forward to Kendy's new future. And Dan came home from Lucille that day. Dan came home on February 2nd. And so that evening, 10:48 p.m., the 911 call comes in. And in that 911 call, Dan Howard tells the 911 operator, she's dead. She's dead, she's dead, she's gray, she has no pulse. She's cold. Dan Howard, a long-time law enforcement officer who had been to many fatal car accidents or other crime scenes, tells the 911 operator, she's dead. I checked her pulse. Yet, when the deputies get there, all of a sudden, he's asking them, what's going on? What are you doing? What's happening? Acting as if he doesn't know what's going on with his wife. He's also repeatedly making vomiting noises, but they notice that there's no actual vomit. He's wailing and making crying noises, but they notice that there are no tears. They also notice that he's got fresh deodorant stains on his shirt. He would later tell Sergeant Lawton that he took a shower around 4, and now it's well after 11. The defendant gives a version of these events. He tells Sergeant Lawton that he got back that afternoon. We know it's true. That she picked up something from the deli. Well, she got McDonald's on the way home. And then we went down there and finalized everything, but she flipped out when she realized that the house had to be liquidated, and she went upstairs. Well, they've been talking about this house. Kendy knew what she needed to do to get the house from the divorce, and it wasn't a house that she even owned yet. And so, according to the defendant, instead of going upstairs and reaching out to her realtor boyfriend, her realtor friend, her family, or anyone else, he says that he can hear the bathwater running. Anyway, he says, I heard something hit the floor. Didn't sound like a shot. The same defendant, his father testified that he's completely deaf in one ear. So he is a deaf in one ear, prior law enforcement officer who was on SWAT and was a firearms instructor. Cannot recognize the sound of a gunshot going off in a small room with an open door in his house. But he can hear the bathwater running? He also goes on in his interview to tell Sergeant Lawton that, was the water still running when you went up there? No, trickling. There's a trickle. Yeah, I shut that off. Must have been going in the overflow. Did he shut off the water, or was it going in the overflow? Either way, Deputy Wheeler got on scene. That water is not going to be overflow. And again, I hear the water running, and it sounded like something hit the floor. Detectives asked him, how long was it after you heard that sound of something hit the floor? She went upstairs. An hour and a half. He says, that long? Sergeant Lawton asks. Yeah, he says. Yet, Deputy Wheeler, again, that first officer on scene, told you that when he went in that bathroom, there were bubbles in that bath. And then he held his hand by the water, it felt warm. There were other odd things that stood out to Deputy Wheeler in the beginning. One was the scene in the bathroom. There's a purse sitting on the counter. There was a gun magazine in that purse. Her phone and glasses are very neatly placed by that magazine and by that purse. Not within arm's reach of the tub, however. Downstairs, the dryer was running, and Detective Northrup would later tell you that based on this timestamp from Deputy Wheeler's body camera and the 6 minutes left on the dryer, that would have meant that that dryer was started within minutes of that 911 call being placed. In order for the defendant to be guilty of count 2 first-degree murder, malice aforethought, state must prove these elements. On or about the second day of February, you know that's the date that this all happened, in the state of Idaho, at her house in Athol, the defendant engaged in conduct which caused the death of Kendy Howard. No one else in that house who caused Kendy's death, either the defendant or Kendy herself, as alleged by the defense. The defendant acted without justification or excuse. There's no self-defense claim here in this case. With malice aforethought, basically did he act disregard for life, and whether that murder was willful, deliberate, and premeditated. Throughout interactions with law enforcement, both outside the house and inside the house, Dan Howard kept his face covered. No tears, no true signs of emotion that deputies could see. They looked for those tears, but they could not find them. There were lots of other things that they started to notice that just seemed strange. Like in the floor of the bedroom, there was broken glass. Deputy Coroner Lynn Acevedo, who has been to thousands of deaths, would also note that glass on the ground. Detective Euler would note when he went downstairs that the wood-burning stove was absolutely cooking. He comments on the video that it's uncomfortably hot down there. And then there's a humidifier kettle sitting on top of that stove. Divorce paperwork still sitting there on the bar counter, and now it's changed. It's changed in that Kendy's house split is now on the paperwork. Still in Dan's handwriting, different color pen. And again, Kendy at this point has been well informed by attorneys, by her boyfriend, by her friend, that this house isn't an asset. This house is a debt. This is something that would have to be dealt with in the divorce through a quitclaim deed. And she didn't even own the house yet. Closing had not occurred. The body itself seems strange. The body is unnaturally positioned in the tub. Her feet are scrunched up at the bottom. There's no splatter on the hands from holding the gun. And as Randy Beasley told you, what little blood is there on the body? Well, it's moving against gravity. It's moving in the wrong direction. It's curling up and around her nose, up her cheek, and on her breast. It's moving down with gravity, but then over. And Beasley told you that was indicative of a body that had moved. And as law enforcement goes through this scene, they are finding more and more things that indicate to them that this scene is staged. Small details like the fact that the shampoo and conditioner bottles are facing out of the tub. Details like the fact that the purse, the cell phone are not in reach of the tub. The fact that there's no towels within reach of the tub other than those decorative towels. There's no clothes in the bathroom for Kendy to change into. Bubbles, the temperature of the bath is warm, the body itself looks strange. Later, they would find out that Dan's DNA was not on those bullets in that magazine in the tub, but it was on the bullets in the magazine in the purse. Overall, there are lots of things about that scene that cause investigators to say to themselves, this doesn't look right. Well, very quickly after Kendy's body was removed from the tub, she was taken to Spokane for her autopsy. There's a lot of evidence about how long Kendy sat in that tub, but then her autopsy was 11 o'clock that next morning. About 11:30 is when it got started. And John Howard, at the end of his career, got a body, and he looked at that body, and he saw an obvious cause of death, a gunshot wound to the mouth. And he told you that it's important to document injuries. Yet, he did not document injuries. He didn't even document the injuries that he noted in his report. He didn't bother to take pictures of them. Just did a very superficial examination. He also told you that he did not review crime scene pictures, then or now. He didn't review any of the investigation, then or now. He didn't review any of the additional work that had been done by investigators in this case. And Lynn Acevedo, a few days at the funeral home, she sees Kendy's body laying out and she thinks, whoa. Looking at that body does not look like a body just committed suicide. And ultimately, through the autopsy photos, through Lynn Acevedo's photos, through the review by other medical doctors, this is what Kendy Howard's body looks like. Each of those dots is an injury to Kendy's body. Sure, maybe 1-2 bruises could be from tripping over a box at work, but not this. Part of what you have to consider in your deliberations is malice. Malice is expressed when there is a manifested deliberate intention unlawfully to kill a human being. Malice is implied when the killing results from an intentional act. The natural consequences of that act are dangerous to human life, and the act is deliberately performed with knowledge of that danger and conscious disregard of human life. Ladies and gentlemen, the state would argue to you that both are present in this case. The actions of the defendant demonstrate a deliberate intention to kill Kendy Howard, express malice, and the actions taken by the defendant to asphyxiate Kendy Howard, knowing how dangerous that conduct was, is implied malice. Ladies and gentlemen, you have both. Malice of forethought simply means it does not imply there has to be a deliberation or lapse of time. It simply means that the malice must precede. Did Kendy Howard die of a gunshot wound? Even at the scene, this is Kendy Howard at the scene in a body bag. That is bruising to her neck. Seen still later at the funeral home. And Dr. Smock told you that bruising on that part of the neck is consistent with a rear naked choke, consistent with a carotid restraint, consistent with a type of move that could result in complete occlusion of blood flow to the brain, which would result in a lap petechia. Dr. Smock also talked about her jaw. Her jaw, it was broken, fractured on the left side into multiple pieces, here and here. And that there was bruising, time of autopsy, you can see in other photos as well, from that. Dr. Smock told you, bruising occurs in life. It can show up after death, but bruising occurs in life. That fracture is the result of blunt force trauma that occurred before her death. Gary Tolson talks to you about carotid restraint as a police technique, what it is, when it's been taught, how it's utilized. It is lethal force. And it's lethal force because officers have to know that it can kill somebody. And Leslie Lehman told you that when she was a trooper with Dan Howard showed her how to do that move, taught her. They did it together and they talked about carotid restraint. Because again, ladies and gentlemen, this move is the carotid restraint. This is a chokehold that crushes the windpipe. This blocks blood flow. But Dr. Smock pointed out that there are other signs of asphyxiation to Kendy Howard. The fact that she has damage to her lip, the fact that she has damage to this side of the lip caused by her teeth being pushed in, the fact that she's got bruising to her nose, and again, the bruising to the neck. These are the results of pressure. And Kendy Howard's body, bruised in pattern form, bruised in protected areas. And again, ladies and gentlemen, many of these bruises, and these are bruises, not lividity, are captured because Lynn Acevedo had the forethought to take these photographs at the funeral home, not because Dr. Howard took photos during his autopsy. Dr. Howard didn't even take a photo of the backside of the body. It wasn't covered in blood. And then, of course, there are the lacerations. There are lacerations to the feet, consistent with walking on broken glass, lacerations to the hand, and as has been excessively discussed in this case, not slide bite. And then there is the burn to her arm, the burn seen at autopsy and then later at the funeral home. Dr. Howard would have you believe that that is skin slippage. Well, Dr. Stewart, whose specialty is burns, who is at a level 1 trauma center in Seattle, who routinely examines potential burns through telemedicine, told you, no, that is a thermal burn caused by a hot liquid. Where is there a source of hot liquid? Hot enough to burn this into a 2nd-degree burn? Down by the stove, sitting on top. But what else Dr. Stewart told you is that 2nd-degree burns are actually the most painful kind of burn. 3rd-degree burns, you burn right through those nerve endings. But 2nd-degree, like this, you're just exposing all those nerve endings. And a person with a 2nd-degree burn like this is not going to go stick her arm in a bubble bath. Now again, Dr. Howard pointed out some skin slippage on that foot, but not on the other foot. And he told you that slippage occurs when there's pressure. Well, ladies and gentlemen, as Dr. Smock pointed out today, this arm, and again, it's that underside of the arm, there's no pressure there. That arm on the side is up against the tub, but where that burn is floating in the water, not skin slippage. And trajectory. Yes, many interoral gunshot wounds are suicide. But most of those interoral gunshot wounds go up to the brain to kill the person. They have an upward trajectory. And as Dr. Desmoulian talked about, an upward trajectory is a more ergonomical trajectory for someone attempting to shoot themselves. Downward trajectory is associated with homicide. It's associated with someone else holding the firearm and shooting into the person's mouth. And although Dr. Howard and Dr. Desmoulian quibbled and tried to avoid the question, they both ultimately agreed that is a downward trajectory. Dr. Van Baron talks to you about the tongue. And it's right. Dr. Howard did a good thing when he saved that tongue. He saved something of evidentiary value. And despite his proclamations that he saved lots of tongues, he saved this one, and it allowed Dr. Narr to examine it. And when she examined it, what did she find? Well, she found soot, because it was a contact wound. She found that there was some hemorrhage in the tongue, but not nearly as much as she would have expected to see. And there were all these vessels. That wound path, that bullet path, transected. And Dr. Van told you, had her heart still been beating at the time that all of those blood vessels were transected, it would have been profound and pulsated blood loss. John Howard told you that blood can go in 3 places. It can go into the stomach, if there was no blood in the stomach. It can go into the lungs, if there's no blood in the lungs. Or it can go into the environment. Kendy Howard's heart at a C2 transection would have interrupted parasympathetic nervous system and the sympathetic nervous system. And as Dr. Van Baron explained to you, as well as other doctors, even Dr. Desmoulian this morning, the heart can continue to beat. Now, Dr. Desmoulian tried to point you to a case study where there was some sort of shutdown of the heart. Yet, when you pushed on that case study, well, that gun, that shot, went up through the soft palate and landed in a different part. Dr. Howard told you that when he looked at Kendy's body, without any additional information, it looked like other bodies that he'd seen. I determined that this gun, in the absence of evidence of any other cause of death, was the cause of death. If Kendy Howard had been alive when that shot went through her mouth, it would have killed her. 100%. Without someone immediately intubating her and getting her to a hospital, she would have died from that shot. Dr. Howard did not consider the other evidence. Dr. Howard did not consider everything else that indicated that at the time that that shot went through Kendy Howard's mouth, she was already dead. Dr. Desmoulian, as well, he told you that, well, if she was already dead, then she couldn't commit suicide. But he had run through all of these different scenarios that looked at whether or not it was possible that she could have shot herself as soon as she was alive. And so many of them he had to eliminate because it was impossible for the trigger to be pulled due to the strangeness of the wrist, because it was not ergonomic to hold the gun in that fashion. Because the trajectory was wrong. And Dr. Desmoulian, coming to his conclusion that it was biomechanically possible that she could have hypothetically shot herself, did not review the injuries in this case. He did not consider she was already dead. Ladies and gentlemen, you have more information than John Howard had. You have more information than Dr. Desmoulian considered. You have the benefit of all of the information from the scene, from the autopsy, from the 2-year investigation that followed. And all of that leads to the conclusion the defendant staged this to look like suicide. And part of how you know that are all of the inconsistencies that he told law enforcement. That Kendy killed herself over a house she didn't own, that she went upstairs and killed herself without even reaching out to anyone to say, hey, Is he right? Can he really force me to split this house? No, according to the defendant, she just went upstairs and did it. He claimed that he gave Kendy a loaded gun, but didn't know one was in the chamber. Well, it's true that he gave Kendy, according to the records, the evidence, that he did give Kendy a gun about 10 years prior. And Wyatt testified that he observed her shoot it once, maybe twice, and that was back when the defendant was still at ISP. So at least 5 years before this. And so Kendy would have had to have possessed a gun that was kept in a safe that she didn't have access to, and she would have chosen that as her method to kill herself. Ben told you that Kendy didn't have any life insurance. April Tarpley told you that she did. Defendant didn't say anything about blood on his hands, didn't say anything about water on the clothes, even though the bath mat was soaked. Claimed that he did not care if Kendy was having an affair. Brian's different. But he even went farther than that, ladies and gentlemen. He knew that law enforcement was looking closely at this, and so he created this document here. He gave it to law enforcement along with all her pill bottles. It's in his handwriting. He wrote, Kendy's Prozac prescriptions found for major depression. Well, just looking at the bottles, the Prozac bottles, shows you that they were prescribed for compulsive overeating. Mr. Miller told you that it was the lowest dose, that it was strictly to make phentermine work better, and that she would never prescribe Kendy that. Moreover, the only person who thought Kendy needed meds, or at least repeatedly told Kendy that she needed meds, was the defendant. And he didn't think she did. And then there was how Detective Sergeant Wallaton asked Dan several times about whether or not he had gunshot residue on his hand. Not because Detective Wallaton thought that he would be able to test the defendant's hands, because he knew that was not a valid test to see the defendant's reaction. And so the defendant had this story about popping off some rounds and changing out some sights, yet that gun didn't show signs of being recently shot, and the sights were standard factory. Ladies and gentlemen, you were asked, in order to find the defendant guilty of first-degree murder, whether or not there was premeditation. Premeditation does not require that you find that the defendant was already thinking about this back on January 29th. Although, the state would argue he probably was. You don't have to find that he was thinking about it when he was down in Lucille, but the state would argue that he probably was. Premeditation only requires that it was reflected upon before the decision was made. You could have made that decision that night, during whatever conversation they had. Now, if you find there was not premeditation, then you should and can still consider whether or not it would be murder in the second degree without that premeditation. But in this case, ladies and gentlemen, the state would argue there is significant evidence of premeditation in part of the defendant. The state has argued to you that a big part of why the defendant murdered Kendy was money. We know from their messages that money was something that the defendant cared about. And after Kendy's death, well, the defendant acted in accordance with that same motivation. That hot tub that she purchased, well, within days of her death, he was contacting the seller, getting a deposit back, getting that refund. He contacted Bank of America and called fraud on her legitimate charges that she made in life. That was also not ultimately found to be true fraud charges. Courtney Lampert offered the defendant $2,000 for Kendy's special glass chicken collection. But no, on her birthday, the defendant sold Kendy's possessions in the yard to strangers. And when Brooke showed up to try and get some of her mother's possessions, she was battered by her brother and trespassed by her father. She walked away with nothing. Question, ladies and gentlemen, is whether or not Dan could have staged the scene. Could he have shot Kendy through the mouth to throw off investigators, to throw off Dr. Howard? Could he have made this murder look like a suicide? He told Dean Lampert he could. He bragged about it at a barbecue. Dan Howard, as an ex-Marine, was trained in that carotid restraint. He knew the dangers of that hold, the lethality of it. He had worked in law enforcement for a very long time, not just as a trooper, although troopers go to many fatal scenes, but beyond that, in SWAT, firearms instructor, offensive tactics instructor, and with knowledge, DNA, fingerprints, ballistics. Dan Howard was capable of making this murder look like suicide at first glance. The more you look at this evidence, the more it leads you to the truth. Beginning of this case, my co-counsel, Mr. Mortensen, told you that there are 5 manners of death: natural, accident, suicide, homicide, and undetermined. Kendy Howard did not die of natural causes. Kendy Howard's death was not an accident. Ladies and gentlemen, the state has shown you, both in terms of who Kendy Howard was, and her passion for life, her plans for the future, and her engagement with her friends and her family, this was not suicide. And the state showed you this was not suicide because a dead person cannot shoot themselves in the mouth. And because Kendy Howard did not commit suicide, this case is not undetermined. Thank you.
Thank you, Mr. Athol. Members of the jury, we're going to take 5 minutes, quick recess, just for humanitarian reasons. I would prefer to finish all of the closings. Defense has closed still to go. State gets a rebuttal close at the end. If any of you cannot stay after 5 o'clock today to at least get us all the way through closings, please tell my bailiff. I can't keep you after 5 by rule, but if you can all stay, I prefer to finish closings today and bring you back and start deliberations tomorrow. If you can't do that, let my bailiff know. Otherwise, I'll assume that we can get this part at least wrapped up today.
Hey, why wouldn't you ask this before you even started it? Read the instructions and then start the arguments in the morning. Why would you not do it that way, Judge? Holy fuck, why would you be that... I thought he asked this already. Why would you not ask this now? Like, ask it now partway through. That just screws everything up for everybody. Yeah, the captions have been a mindfuck. I'm sorry, guys, but some of you guys wouldn't need captions, so I put them there. That was not very... I mean, she felt like she was screaming at us the whole time. I'm assuming the prosecutor himself is going to do the rebuttal and bring it home, but I think this is Daniel Howard's. This is going to be his attorney. His attorney can bring this around. I think he can right the ship. Let's see. It'll be interesting. It'll be interesting. It will be interesting.
All right, we'll take 5 minutes.
Well, we're going to take a lot more than 5 minutes if you watch. Here, hold on. This could be a lot more than 5 minutes. We're at 23 minutes now. Whoop, 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 whoop. Whoop, whoop, whoop. Whoop, 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 whoop. Yeah. That was a lot more than 5 minutes. It was like a 15-minute break.
All the jury please back or whatever. So we know a little bit longer. Let's bring the jury. Please back or whatever.
Oh, this is some that's a PowerPoint right there, chat.
Good afternoon, ladies and gentlemen. We talked in jury selection about how it's taken us twice, and so before I get into my pre-prepared statement, I just want to address a couple things. First is the possible hazard. I know they use that for both their openings and their closings, but it is not impossible for a person to commit suicide. Our common life experience will probably show us that suicide can be surprising, or to make a rational decision. Additionally, testing and science is the way to eliminate possibilities. And so the impossible hasn't been eliminated, but also the bruising has been misleading in this case. And so when you take the exhibits, you'll get all the exhibits back. And I'm purposely not going to go through photos in closing. We'll talk about some aspects and some things that you should look for. But you've got to look at one of the timestamps of when those pictures were taken. There's a drastic difference. For instance, in the Deputy Wheeler's photographs that were taken before midnight, involved in the tub, and pictures where there's drastic water depth and the line is here, you see the water's clear as they're drained. They're taking photos when they're draining. So they're grouped together. You have 16A through whatever. They're all grouped together. But pay attention to the photos and where that blood line is. As the tub drains, in Northrup's photos in particular, you'll see the blood line. But the bruising is misleading for many ways. And the main thing is, for instance, Ms. Acevedo, her photos are post autopsy. And again, I don't want to even demonstrate it, but you've seen the pictures. You're basically removing the scalp, you're flipping over the body, you're doing a neck dissection. That's a long period of time. Both Dr. Spock, the first time he testified, and Dr. Howard talked about lividity and where's that blood going when there's no circulation. It's going to raise into some discoloration that looks like bruising and is lividity. So it's careful that you need to do it. But the issue comes down to blood. And the reason why is because there's no petechiae, there's no damage to the hyoid bone. And Dr. Smock's explanation is that if you do this restraint a particular way, you can cut off 100% of circulation, and that's why you use petechiae. Obviously, if we stop petechiae, that changes the whole case. So the case does come down to the volume of blood on this. So first, obviously, in all of our experiences, we have tragedy. We respond to tragedy in different ways. There's different people that will respond very emotionally, other people are more stoic. But we have all experienced tragedy. And I want to be clear that just because we're defense here, this is a tragedy, no matter how this pans out. Whether she committed suicide or not, that's for you to decide. But it's tragic either way when we're dealing with a case like this. But the point of talking about that is when you were selected as jurors, you're making a commitment to set aside the emotions. These are very emotional. We hear stories from family. We hear stories of situations. It's very, very understandable to feel the loss of Kendy. But you as jurors have the toughest job to be able to separate those emotions. Talking about emotions is people respond differently. We've heard Dan described as stoic and reserved. We've heard him, we saw his son, Wyatt, on the stand, who comes across maybe stoic and reserved, not painting testimony, but basically being open when asked by counsel, would you change your opinion if you saw X, Y, and Z? And says yes. Compare that to his sister, who very clearly early on, first phone call or when she calls back, very emotional. People respond differently. And so it's important that you take the emotions into consideration, but focus on this case objectively based upon the facts that you have in front of you. There very clearly was a family dispute, and that's evident, and in some ways that may have shaped this case. But we talked about the different personalities. So I want to walk through some of this. So the 7/10 incident in 2020.
Please don't. Please.
You have video that shows officers responding and there's no abuse. You also have the 911 call. It's up to you to determine the credibility of the witnesses and what your observations are. But her state of mind when she makes that call. But she very clearly tells the officer there was no physical abuse. The only comments are to Michelle and to Mr. Prado. Now, what's significant about that is throughout this, we have to examine her credibility in the sense of contextually what was going on. She told Mr. Prado that Dan made her delete all the photos. Well, clearly that didn't happen because the photos were there almost a year later when his phone was seized at the scene, or when her phone was seized at the scene. Photos were there, you have all the photos and evidence. So she's clearly not being honest with her conversation with Mr. Prado. There are witnesses, Carrie and Brett, and you can examine their credibility. You know, the state wants to say, well, they could have gone to law enforcement at any time. But why would they? We're talking about someone falling against a boat. You wouldn't expect to go to law enforcement with that. You only go to law enforcement if you expected something illegal happened. So why would they go? It wasn't made aware to them until 2023, as was testimony of Detective Lowell. And 27, 28 years. Not a single person has said, even that Dan raised his voice in anger. We have reference from Brooke that there's some name calling as far as weight and stuff, but no witnesses to any abuse in almost 30 years. No witness to any physical abuse of that sort. So it makes you wonder, why do we have the surge? A bruise on your chest that was not investigated. The date of that is 10 months prior. There's no witnesses, and there's really no admission from Kendy that Dan affirmatively did. So why did it charge? I mean, that's maybe relevant, maybe not, but maybe it's to bolster the case. So your instructions, you do how you want, but I would advise you to read the instructions, particularly the ones that we went over 2 weeks ago. You each get them. This is kind of like a Bible. So when we walk in here, there's not going to be a lot of dispute. We're not, July 20th, the state of Idaho. But the issue is whether he actually made a delay or something. Okay, there it is. The one thing I'd say about the date is the date is not about the bruising, lividity, contusions, discoloration from her death, autopsy, etc. The bruising is as it relates to the incident in July 10th. Now, you'll have the photos, you have photos of the trailer, you have the testimony, and you'll be able to look at the bruises. And you can see there's a big bruise that kind of trails off to the center, consistent with controlling one. And you can examine it. But I don't want to spend much time on the 710 because I want to get into the main issue. It's key to keep in mind that Kendy was living a secret life. And there's no judge, it's not illegal, there's nothing illegal about that, but she was living a secret life. So she wasn't being honest with Michelle, with her parents, with her husband. She wasn't, and even in some cases, with Mr. Prado. But you have an incident where Dan had come home, you have the messages, you could read through them. There was a delay by 2 days, or suspicion, or you had an affair. You see more of that conversation on the first, where Kendy is accusing Dan of having an affair. Who did you go see? What help? I called the hotel. Where you at? But Dan comes home. There's no black clothes in evidence. When you watch the video, it's a little bit smudged, but when you watch the video, you can see that it's the same clothes that were in the washer. Mr. Prado had a 15-second phone call with her, and they didn't call back. They called her parents and didn't call back. Didn't do anything about it. So, there's no dark clothes found anywhere in the house. There's no gloves in evidence. There's no anything. So she comes home the next day. And here's again, some of what we need to take the emotion off and focus on the science is there's a balance in a 28-year relationship of, yeah, I want you back. Hey, I love you more than anything. Please come home. To being controlled. But she does come home, and they spend the weekend together. And here's where I think it's interesting to read some of the messages to Michelle, Tana, and Mom. She's talking about how calm they're going through their divorce, that they're splitting the assets evenly. Here's that, and they even text photos. She even texts photos to her friends. Now, so that 129 event, we don't know what was going on. It doesn't, if you were to believe that someone is standing in black clothing that didn't have gloves with a firearm, then yeah, it's concerning. But that's not what the officers found, and that's not what you have before you. That's a statement that she made to her family after she left. She packed a bag, she left, she came back on 31st. So can she be suicidal? Well, I would posit that the family is probably not the people you should talk to. Either side, either the son or the daughter, because it is too close to home. We don't want to think that a loved one has committed suicide. But let's look at Dr. Hanger. Dr. Hanger conducted an evaluation and elicited factors, and he talked about the home's life stress inventory, and he found that she had a moderate to high degree of experiencing difficulty coping. Now, he made adjustments to that, but the adjustments were made based upon early statements from the family given to law enforcement close in time to her passing. There was no direct examination of Kendy, obviously, which can increase the confidence level.
Don't say, oh my God, don't say that.
Report, but he finally admitted that he's not possible to provide an absolute predictive determination of suicidality from a records review. The point of this is, let's look at the science, let's look at the scene, let's look at the evidence. It's not letting the emotions and the could she have done it, or would she, we probably all know people that we never would have expected that make rash decisions. We got to think about the science. So, here's some of the factors that are in favor of that. And she describes herself as being in a midlife crisis more than once in the evidence that you have with text messages. To Roy Fitting, part of that is it normal to feel sick to your stomach? This is just on the 31st. Sick to your stomach about the choices you're making. She's, on the first, she's accusing Dan of having an affair, and that's why she's late. She also, that's the same day her affair comes out, and when you read the messages between Dan and Kendy, and also Mr. Prado and Kendy, you'll see, and Kendy and her brother, you'll see this was just not a small argument. she was irate. She rapid text to her brother, she rapid text Dan. This was very, very stressful for her. That her secret life, who she thought she had kept secret, maybe her plan was to get a divorce and then slowly integrate Mr. Prado into the equation. Her plan was not to have the affair come out to her family and friends and have that be the reason why she's getting a divorce. In fact, there's messages that you have where she's told by her friends that you should not be having an affair. If you are, you should be doing that. She was blocked by her brother on that day. No one can stand here and tell you what she was thinking or what was going on in her head. What we do know is the last message she sent was to Tanner.
Objection, facts and not in evidence.
It is exhibit defense. Her last message sent was to Tanner. And that message talked about her brother blocking her. So let's look at it. Let's separate the emotions. Let's separate hypothetically what was going. We can't know what was going on in her mind. We can feel sorry for the tragedy and miss her. But let's look at the facts and the evidence in this case of a murder or a staged suicide. So first, regarding asphyxiation. The only evidence is a lack of blood. Again, remember that Dr. Schmock compared the carotid restraint, which is taught by law enforcement, to a rear naked choke. That was what you see in MMA. In fact, one of the exhibits you have from Polison is 3 pictures that show different holds. One of those is a rear naked choke, and Dr. Schmock talked about the rear naked choke. The reason that's necessary is because you have to have 100% circulation cut off. If blood escapes to the head, you're going to get the petechia. All the doctors agree that there's no petechia. So they're going by, there's not enough blood for it to be suicide. No petechia, no damage to the eyeballing. So Dr. Howard was the only one to examine the body fresh. It was within 12 hours of the passing that he examined the body. And he ruled death by gunshot. He testified that there's been hundreds of intraoral gunshot wounds that he's examined, and the blood that he saw was consistent with the amount of blood that he would find. Dr. Rambaran talked about how, who's a trauma surgeon, not a medical examiner or forensic pathologist, talked about in the volume of blood that you would expect. And he used around 800 milliliters to a liter of blood. And he tried to do a demonstration. I don't think it really worked because it kind of just stuck in the spot. But he tried to show a demonstration of what the blood would look like. Well, what they did not consider, what no one has talked about, is the amount of blood in the body bag. And why is that significant? They're saying, look at the water. It should be dark from a photo as they're draining it 8 hours later. The reason you have to consider the blood in the body bag is because there's only 2 sources of bleeding. The tongue, which we'll talk about in a bit. The tongue and the damage caused internally to the C2 and its jaw and surrounding areas. So if you consider the blood in the body bag over there, is that enough blood consistent with suicide? If you consider the amount of blood in the body bag, plus the amount in the photos at the beginning when Wheeler first showed up, plus any amount that drained, we do have photos and evidence that showed up drainage. When they did drain, there's a line of blood that had been going down the center to the drain. This asphyxiation, there's like too much blood. They haven't given an explanation where that blood went. And so you have to consider what's in the bag and what's going down the bag. Now, location. There is no theory as to where asphyxiation occurred. Did it happen before the tub was filled up? And was it in the tub? There's no blood anywhere found in the house. You heard testimony that they checked things with luminol. There's no blood found anywhere else in the house. And you'll see it, it's in evidence, a little envelope, about this big. I think there's one rock associated with it too. I don't know if it's tooth or rock, it's not glass, but there's earring backing, something, whatever it is, and then a few shards of glass that are about this big that they found 2 weeks later. There's no defensive wounds on Dan. So the one thing to keep in mind is the carotid restraint or rear naked choke is a violent maneuver. She didn't have any alcohol in her system. She didn't have any drugs except for caffeine in her system. She was not overly intoxicated. It's a violent maneuver. She just had her fingernails done. There's no damage to the fingernails. There's no defensive wounds to Dan. So if you look back at the interview. Euler, Detective Euler, it's body camera. He's the one that we had large chunks when we were watching at home after detectives arrived, and they're talking to Dan. And there's a point where Dan, close to 6, it's close to when he made the phone calls, but there's a point in time where Detective Loudon goes up and gets the charger. So you see his body camera, see him go
That said, holy shit.
you see him turn, and you see him go.
Guys, we're almost caught up live, but damn, I didn't even think about that. Nobody brought up her nails weren't fucked up. Or got her nails done and nothing happened to them. It's not a woman who got into a fight.
Between the bed and the dresser. That's where that glass was. You don't see it in the video, but 2 weeks later, that's where the glass was, in that area. There's no blood or DNA on the glass. There's no sign of struggle anywhere else in the house. Nothing is found in the vacuum bag. So if that glass had come from a struggle, number one, if he's smart enough to stage a scene, wouldn't Dan pick up pieces of glass 2 weeks later? But two, there's nothing in the vacuum bag of evidentiary value, which by itself has evidentiary value. It shows that there was not an active cleanup that was exacted. Talk about the corner photos. Again, we have this chart. I think it's 19B, this white background with the skeleton, not skeleton, with the outline of the person with diagrams of bruises, right? A lot of those were taken on the 5th in the morgue after autopsy, after embalming. A couple of days later, what that does not mean, or they have not proven what's validity versus what's bruising and what's trauma from the process of the autopsy. So, the coroner photos were taken on the 5th, after the traumatic experience. You see the swollen face? That's not from injury, from abuse. That's from the autopsy, basically almost removing the face. And you have, when I showed you one earlier today, you have those photos. But the face, obviously, is swollen by putting everything back together. Then you talk about they remove the internal organs. They do a wide incision, remove the internal organs, look at them, test them, put them back. Right? It's traumatic. So looking at the photos from the 5th is a little bit, it could be disingenuous. Both Dr. Howard, we talked about this, both Dr. Howard and Dr. Swank talked about what livid is. And Dr. Howard examined the body, no sign of injury to the neck. What I keep in mind also is in the photos, particularly Wheeler's photos, but you see her resting place in the tub. Her head is slumped down, on her chest. And again, where does blood flow? It doesn't flow. Where does it go? It settles. So what is lividity versus what is bruising? I think the photos there, you can draw your conclusions based upon the evidence. Let's look at the scene. The scene is consistent with suicide. The gun position is consistent with suicide. Now, there's testimony that Dan was a patrol officer. There's no evidence that he worked as a detective. There's no evidence that he had any sort of homicide training. No evidence of the knowledge of staging a scene that would fit the biomechanical information. When you look at all the possibilities, we'll come back to this, but when you look at all the possibilities, his purpose was to rule out suicide. And out of many scenarios Dr. Desmond came up with, 2 are potentially consistent, depending on whether this is a slide by. That takes a lot of knowledge. He has a PhD in biomechanical engineering and is able to examine scenes. For a person not even trained to be a detective, to know exactly where to put the gun, which way to face it, that would fit the biomechanical recreation is a lot of specialty knowledge that has not been shown that Dan has. Dan's DNA is not on the gun. And it's not that he wiped it, because Kendy's DNA is on the gun, and some other male's DNA is on the gun. So that's not just wiping. That would be wiping and placing someone else's other DNA. And that's again, there's no training experience that Dan has had that. Again, scene continued. It's consistent with the slide bite on the thumb, but as you heard Dr. Desmond, even if you think that's not a slide bite, the possibilities go up. There's more scenarios that are consistent with suicide. Dan's DNA wasn't even on the bullets of the magazine. Now, let's talk about that for a second. When examining the credibility, Kendy told Ms. Prado that she was excited. She was getting her guns. She was getting her guns. So, from her own words to Mr. Prado, she was excited about having her guns. The splatter, and many people testified about the splatter to the left hand, to the right hand, to the nipple. And so Again, how do you stage that, especially without training? When you look at the photos, particularly in the earlier ones, you will see on either side of the neck dark pools of blood that are going down. And when you compare that to what you observed from testing the blood and how it interacts with the water, the state has not accounted for the blood that has been expended in the scene. The blood, this is, I think, 18A, but the hair, the first picture of the body, when you look at that, you'll see the hair is absolutely matted with blood, caked on the body and all that. Now let's talk about the tongue. Dr. Howard fainted. Point of injury, rare to have it hit the tip. Tongue is muscle. Muscles go to rock state upon death. Now, you heard me ask that a couple of weeks. Here's the point. The injury was to the tip. If you were alive, or if you were not alive, what is the natural resting position of the tongue? Behind the front teeth. Behind the front teeth. So if she was not alive, how did the top of the tongue get injured without damage to the bottom teeth? That injury of the tongue is consistent with someone who was alive at the time of gunshot. Talk about gunshot residue, and none of the witnesses put a lot of emphasis on gunshot residue, but I think it's important to ask a couple things. During the video of the encounter between the detective and Dan, he was asked on, I think, more than one occasion if he wanted to do GSR. He immediately says, yeah, you can do it now. Detective Northrup, I went through all the details. He's talking about how, what the weather is, what kind of house it is, the amount of detail that he put in his report, so much detail. Yet, in his report, and he admitted on stand, he did not put that Dan did this. That's never in any of the reports. They didn't take his clothing. If they thought that he did that, why wouldn't they take his clothing? But is it something that was added later over 2 years later, now when it goes to grand jury? They didn't send Dan's kit to the lab. You have a picture of the kit that Chet talked about today. The kit that went to the lab was from the autopsy, and you have that. Let's talk about the arm. Burn, not a burn. So let's look. If it's a burn, again, it's not a cause of death. It's not related to the gunshot, and it's not a defensive. You put your hands up, right? It's onto the back of your arms. Where's the injury? It's on the inside portion of your arm. That's not offensive. But it's also, there's no other evidence or moisture as far as wherever it would have occurred that some liquid was thrown. There's no evidence of that anywhere. But could it be from making tea on a blazing hot, as was described, scorching hot basement thermos or kettle that's on the stove? Yes. But it's not related to the death. So is it a burn? That's not what the case hangs with. And even if it is a burn, there's no cause. There's no theory that Dan created that burn. There's no offer of proof that Dan created that burn. There's just, here's a burn. He must have done it. Let's use this against him in our trial. But Dr. Howard, who again was the only one who examined the body while it was fresh, described that as skin slippage. So he talked about how when you're submerged and you're under pressure, the skin slippage or the decompensation basically is rapid. Look at how she is in the tub, particularly, again, in Detective Weaver's photo. Her head, her arm on the left side is up. Her body is a little bit leaning to the right, and her arm right here is up against the tub. Is that consistent with skin slippage? But either way, it doesn't, the case is not hinged on that injury, but I think it's important to point out why Dr. Howard, who's never testified for the defense in his career as the main witness, believes that it was skin slippage. Bruising versus liberty. We talked about this, so I'll just, the only other thing I would tell you, Dr. Howard's opinion was death by gunshot. You have a piece of evidence in you, I believe it's Defense Exhibit C or D, I think it's C, that Acevedo, she took the photos on the 5th, February 5th. She agreed that she wouldn't sign something that she didn't agree with. She issued a death certificate, you have an evidence, her signature on it, from June, saying that the cause of death was transection of C2 with penetrating gunshot wound to the head and neck. That was her opinion. Obviously, now it might be changed, but what you have in there is the photos and the video. Let's talk about Dr. Smock. First, he was asked in 2001, and he said he needed more information. Right? He saw the bruises or the marks, the avidity, whatever we want, contusion, whatever, blunt force trauma, whatever word we want to use, whether it's blunt force trauma like this or whatever. He saw the photos from the coroner. He saw everything back in 2021. And he issued his opinion. You heard the first time he testified. It was after Dr. Dozen issued his opinion in October of last year. Everyone else is wrong. Dr. Narr is wrong that the blood can be contained in the mouth. Dr. Narr is wrong that the lips and the broken jaw are consistent with a gunshot trauma, interoral gunshot wound. Dr. Lambert is wrong that the lips and the damage is consistent with a gunshot wound. Dr. Howard's wrong that the lips and the jaw were caused by a gunshot wound. Everyone else is wrong except for Dr. Smock. The blast and the trauma of the blast, whether that's bruising or whatever that is on the scalp, that caused from hitting the head. There's force involved with the explosion of a firearm. Someone sitting in the tub, head's going to hit back. Additionally, when it does, there's going to be some damage to the head and the mouth. Dr. Smock said, or asked or said, he was 100% convinced. I'm not much in science. I love science. I'm just not very good at it. But 100% doesn't seem very scientific. That seems to me. Compare that to Dr. Desmond. He set out to rule out suicide. Rule out suicide. This position, not suicide. This position, not suicide. He said, and what is his opinion? His opinion isn't sitting here before you, bolstering himself, saying, yeah, I have an opinion that she committed suicide. The opinion was, the evidence is consistent with suicide. It's up for you guys to decide. Dr. Smock, 100%. 100%, this is my opinion. Everyone else is wrong. You gotta go with that. We already talked about how that one exhibit includes the post-autopsy photos. And Dr. Smock did not do any testing or modeling or putting together a theory of what actually could have or would have happened. We heard Dr. Desmond say testing is worth 1,000 experts, and we kind of see that in this case. We'll come back to that. So examining Kendy's own statements, there was secret affair. She was upset about the house. She was actually excited about her gun, back and forth on what she wanted to do. Didn't have a job lined up. Here's the thing, grass is always greener. But she didn't have an exciting future lined up. The pieces weren't together. She didn't have a job. She didn't, there were issues with the house, and she didn't even know if she wanted to leave Dan or not. And we talked about it last. Her last message was not to Dan Prado. Her last message was to Tanner regarding her brother. Looking at Dan's statements, the house was added to the paperwork. You can check that for yourself. February, the heater's running. We had testimony that it was blazing hot in there. Testimony is going. How do you hear water from upstairs? If you're in the basement, how do you hear water from upstairs? You hear it through the walls, through the pipes. You hear the pipes, the water run. How do you know someone flushed the toilet upstairs? You hear it through the walls. Right? So, yeah, he hears the water. But the fan's going, washer's going, or not the washer, the dryer's going, and he hears something like a thud. Yeah. Little things matter. If Dan has set a scene, why would he say that he heard a thud? Why would he say, I heard a gunshot, went upstairs to call 911? Right? He's a former law enforcement officer, former firearms instructor. If he was setting a scene, why would he say it was a thug? He was cooperative with law enforcement for hours. And we heard, I think during opening, we heard that you would hear testimony that was asking people for coffee or whatever. You watched, 4 or 5 hours of video. Not once did he do that. Most of the time, he sat in the same position, And again, people respond to emotional trauma differently. How he responds might be different from how another person responds, which would be different to how another person responds. But what did he do? He cooperated with law enforcement. He made mention of a prior incident where Kendy had expressed suicide ideation. Put a gun to her head, in the bedroom, in the closet, pulled it down, and when she pulled it down, she discharged. The officers went to confirm. They found a hole right where they said it was. Why? Well, again, it was objective, not emotional. Said, yeah, when I was in middle school, the bullet came down. We didn't get into hearsay. That's what he observed. A bullet coming down through that closet floor. We'll talk about the Ford gun. There's photos and evidence. You go through there. You'll see Fallon. You'll see the breach. Also, what you'll see if you examine, you also have a physical 40 itself. You'll notice that the sight is all the way to the right. It's not in the middle. And so Dan is talking about how he changed the sight. He moved that sight all the way to the right. And you'll be able to examine that. So examining the totality of the scene. Blood sinks to the bottom when agitated. Dr. Desmond didn't force the scenarios. There's no way to quantify how much blood was drained. And suicide is consistent with the evidence. We see the blood line around the body. Again, when you examine, you might find that there appears to be more than 800 milliliters that Dr. Ambrose said he would expect to find in an injury. The scene, the blood, the body bag, drain, the tub, supports that there was a lot of blood. And again, the state doesn't have any evidence of how the scene was staged. And I apologize. I see what you're saying. There is a delay in this. No theory. Was she placed in the tub, then water filled up, then shot? Why isn't there more water around? The only part of water is there's a damp, the bathhouse. It's not on the floors, nothing. If the water's in there, then Dan certainly would have had blood on him. And again, it doesn't explain there were no gloves found, so he would have had to use his hand and scrub it and put someone else's DNA in it. So the state hasn't offered one theory on what happened. Where the asphyxiation took place, when she was shot, why there's no blood anywhere else in the house, and no evidence on Dan, no scratch marks, a person who's not intoxicated, not drugged, is not going to let someone just is not going to sit there and not attack, especially with fresh evidence. So we looked at, I just have a couple more slides of this. We looked at the Dr. Desmond's chart. And the point of this chart is they considered more than 10, but they ruled something quickly. If it was a left-handed fire, would have been to the left side. So rule out those. And you go through here. There's 2 that are consistent. If we remove the slide light, there's 2 that are consistent all the way across the board. What's a slide bite? If that is a slide bite, then there's one scenario that's significant. The point of me telling you that, or pointing that out, is how technical, the technical expertise it would take to stage this scene. It's not just choking her out, shooting her, dropping the gun in the tub, washing her hands, being done. You actually have to place the
This
gun a
guy's
certain
on
way.
fire. He's
You
doing
actually
awesome.
have to get everything just right. You have, you have
Good.
a lot. I'll continue to talk about that. So we saw on here the blood accumulation in the water, and you remember the test that. Okay, we have it. Remember the test that we had. That the blood accumulated in the water. The blood testing in the water. When we saw that, the water or the blood sank to the bottom. Sank to the bottom. It didn't just make it. It's not a toilet where you have a bunch of movement and agitated water as you're draining it. The water shows that it was draining. The blood pulled to the bottom and went from there. So when we get to this, I'm just going to fast forward this portion. When we get to this portion, you all remember the testing. That's only testing that was done, and it's so significant because this case is about the blood. The testing of the blood and the line that it goes, and what the hair does. As the water drains, the hair is not going to be as noticeable or visible in later photos, and how the blood was traveling. You see that. When it's all said and done, there is no theory where it doesn't fit the science, it doesn't fit the scene, it does not fit the facts. When you separate out the emotions and look at the evidence, the state has not been burdened. And that burden is a high burden. Many of us have friends and family or ourselves that have served in the military, protecting our Constitution, being presumed innocent on every count until that presumption is overcome beyond a reasonable doubt is one of the fundamental principles of what we fight for the Constitution that we have. And that burden, when applied to this case, is significant. You don't have to put your stamp of approval on Dan. You don't have to like him as a father. You don't have to like him as a husband. People, he's not on trial for that. He's on trial for domestic battery from a bruise and for first-degree murder for a staged suicide. That doesn't fit the evidence. Even if you believe it's more likely than not, then you have an obligation to find him not guilty because that's not the standard. The standard is without. Ladies and gentlemen, when you apply that to this case, you ask that you're finding Mr. Howard not guilty.
Thank you, Mr. Johnson. Final word, Ms. Shostak?
Thank you, Your Honor. gentlemen, at the start of the instructions, the judge told you that the arguments of attorneys are not evidence. It says Mr. Johnson can argue that this is a defensive posture. The state can argue that this is a defensive posture. Someone's throwing hot water in your direction. Ladies and gentlemen, Mr. Johnson told you a lot of facts, and you get to go back and get to review the facts, you have your own notes and your own memories, and you get to decide what the facts are. What you remember, what you heard, and you get to apply those to the law. Mr. Johnson, he was right about one thing. He was right that the state cannot give you a blow-by-blow of what happened that night. There are two people that know what happened that night. Kendy Howard and Dan Howard. Did she get that burn first? Or did she step on the glass first? Was she grabbed on the upper shoulder first? Or did she get that bruise across the back of the thigh? The state cannot answer those questions for you. But what you have to do in this case is decide whether or not Dan Howard murdered Kendy Howard by asphyxiating her with malice and premeditation. You have to make that determination beyond reasonable doubt. The state being unable to tell you the exact sequence of events is not reasonable doubt. And there's an instruction on reasonable doubt, Judge. Read it to you and you'll have it back there. And it is not the shadow of all doubt. It is not a witness saying, I ran many scenarios and it is possible that this happened. The state does not have to eliminate every possibility. Is it reasonable to think that Kendy Howard committed suicide? No, it is not. The state has shown you beyond a reasonable doubt that the cause of Kendy Howard's death was the defendant. We ask you to find him guilty. Thank you.
Thank you, Ms. Shopstall. Members of the jury, I'm going to excuse you for the day. It's 5:30, and my intention is to excuse you, have you back here at 9 in the morning. We will select at random the alternate. We'll provide you with all the exhibits, and swear in the bailiff, and have you begin your deliberations. Okay, so I think it probably makes sense to proceed in that fashion. So I'll release you with the thanks of the court. I'll remind you not to discuss the case among yourselves or with anyone else. And I'll look forward to seeing you back in the morning at 9. Thank you. Please rise. You can be seated. Counsel, I'm thinking perhaps can you all be back at 8:30 tomorrow? We'll just do a quick confirmation with the clerk regarding the exhibits. I trust the state has some ability to provide for watching of the videos for the jurors, is that right?
Yes, Your Honor.
Okay, so let's just make sure, why don't we meet at 8:30 tomorrow, make sure we have that all set to go. And then just as a final word, I want to commend counsel for the state, counsel for Mr. Howard for the professionalism and good job you have for your clients in this case. All right, we'll be in recess. Look forward to seeing all of you. Thank you.
All right.
Easier for them to come out
Sorry. Yeah, holy cow, that was beautiful. Beautiful work by the defense and closing. I think it's actually very well done. Do I think that's enough? I don't know. I'd like to think so. Coupled with their expert? Yeah. So, yeah, good stuff. I actually was kind of impressed by that at the end. And real quick, That's a Shame says, I am actually going to talk about Harry Potter in my upcoming jury trial, and you can't stop me. Good luck. I wish you nothing but the best. And Bella points out, like, both of them seem to have been too dumb to pull off a grand plot. Yes. And then a bunch of, I don't know how to read the characters, but says, is this a difficult trial? It's actually, yes. This is not an easy, clear-cut one. It's not clear that he's guilty. So, I think this is actually going to be a tough one. And Young is saying, no innocence chart. No. Yeah, I think that's always helpful, especially if you have a PowerPoint. It's easy to throw that up on the screen. The guilty, the not guilties, all the way up to guilty. Yeah, I think so. I think it's a good one. And then I Am Dave says, why is a rebuttal only for the state? Because there's this idea the state has the burden of persuasion, so they get to go last. I don't think that's fair. I don't think that's how it should be. The fact is, if the state wants to, the man fighting for his life should go last because he's got the most to lose. But I'm not in charge of that. But yes, if I could change it, there would be no rebuttal for the state. They'd have one chance to get it all out there and make it stick. Getting to come back afterwards, I don't like. So, while I agree with that, they will never do it. So, yeah. So, there's that. That's the, that's the end of that chapter. So, I'm curious to know what you guys think right now. You want a poll? All right. Set you guys a poll. Guys, we will start the live show. I'm going to wrap this up real quick. We'll be starting the live show probably about 9 o'clock tonight. I need some time to take care of some stuff. And be back on. Okay, so we've got some options here, guys. Got a poll up for you guys to take real quick. Tell me what you think. I mean, I don't know. Do I think the jury's ultimately going to convict him? Yeah, but I don't think it's going to be easy. I bet it comes back like an Allen. They're going to be out for a while. I wonder if they get an Allen charge out of this. Like, I could see that happening. Like, the announcer deadlocked, but I think they'll flip the one or two people that hold out. I don't think ultimately he wins. I think he's gonna get convicted, which I think is horse shit. But yeah. Sweet Tooth's going to say based on evidence, yeah, but I think they're just going to look at it and say, yeah, he probably did it. So, kind of where I am with it. So, yeah, I just, I don't, like I said, I'd like to think he gets acquitted, but don't think it's happening. Yeah. So. The murder, he's going to get convicted of murder. It's going to be it. I mean, he's done at that point. I don't know which murder, I don't know what theory they're going to convict him under, but yeah, he's going to get convicted. I kind of got the feeling if he doesn't, I'm happy for him, but I just don't see that happening. I don't see the jury buying into it. So, was the last bit live? Yeah, no, the last bit was live. They are done for the day. And they are going to start deliberations tomorrow morning. We caught up. It was my mistake. They hadn't started day 10 yet, so day 10 started today. Dealing with the whole him fucking running off, fucking around at the airport, which still, guys, that is the dumbest fucking thing in the world. I don't care what your reason is, you don't go. Oh, there's a rental car. Motherfucker, you might sit in jail for a couple of months. Like, no, you know, thank God the state couldn't use that in their closing or use that anywhere. He probably would be convicted. You know, that was so stupid. And then his buddy, his ride or die, is like, oh, there might be a gun in the car. That creepy guy. Maybe he fucking killed Kendy. It's creepy enough he could have done it. I'm just saying. Play dumber to make it look less premeditated. That'll work. Well, just like, ugh. Cry more? Why are you telling me to cry more? But yes, juries are brainwashed, but there's also just people tend to believe that, they tend to believe that the state, they tend to believe authority. People are inherently trustworthy of authority for some weird reason. Could the boyfriend have done it? I don't know. I think Kendy fucking killed herself. I think Kendy did it. I think Kendy did it. Totally. I think Kendy was, offed herself. Because it sounds like, and that is a good point he brought up, that I kind of forgot about that whole thing, like, although it didn't come out clearly when he was having everybody take the stand, yeah, Kendy was mortified. She thought Dan was having an affair while she's out stripping around. And it turns out, I think that's part of the reason why she went and had an affair and got a boyfriend is because she thought he was, and then it turns out he wasn't. Well, now she just looks like a hoe. So I would want to look nice if I was going to self-eat. Well, that's a separate thing. Yeah, maybe she did that. But yeah, she was... Yeah, I think there's something there, that she did this because she got outed. I think about it. Cheaters often think their significant other's cheating. Yep, that happens too. And yeah, there she goes with that. And just gave away the glass chickens, yeah, which were like... The glass chickens. I would clean my house all nice up all nice, yeah. Take care of your, extended stuff you have to take care of. Return your videotapes. I have dick bias. Well, I do have a dick, so... Kind of works that way. Tilly, cold feet and my feet are cold. Well, that's that's right. Symptom of AIDS. I know. Tilly, you better be careful, man. You don't want the high five. I mean, there's only one high five I want. High five, but not the other high five. So, hey, you might have you might have not HIV, but full-blown AIDS. I'm not going to eat myself in the tub naked if I was going to eat weight or naked body. Yeah, but I mean, look at her. Did she really look that, like, she's obsessed with her weight and she had problems and image issues? Did she look like she had any image problems in those pictures? Like, I don't think so. Like, she didn't look like, Pretend to be like Sean today and pretend to be a working lawyer. Well, he's always working. What movie or song would be playing if I offed myself? Oh, I don't know. It's like, hey now. Oh, yeah. Hold on. How's that go? There's a war within. Who sings that song? Don't Dream It's Over. Crowded House. By Crowded House, yeah. Yeah, that's how I'd probably do it to that. Just have it on replay, or like I do something really awkward like fucking Miley Cyrus. Just play Party in the USA over and over again. I don't know. Something. Or just, I don't know. Something, I don't know. So. Yeah, I know he called her fat, but she wasn't, so. And, she was so insecure, but she found a man right away, so it's like, I don't know. Like I said, there's just stuff that doesn't add up in all these claims that she was doing. When she says that, Dan said all it's about her, so we'll see. Yeah, more human than human, yeah. Oh. So upset she scarfed down McDonald's. Well, yeah. I know I'm fat and I still eat that shit once in a while. Well, once in a while. Yeah. Leaving on a jet plane. Stabby, it's a vacation song. Well, you're leaving. I bet Dan's house is on prime western hunting ground. No, it looks like he's out like in the middle of like the plains. Why would it matter what song you would play? It's one more song to play. So, all right, guys. Well, there's more we could talk about later. I'm gonna take a break for now. We'll start up right around 9 o'clock over on Locals. You guys haven't been there before. It's over at potentiallycriminal.locals.com. You can use the promo code Criminals2024, and you can get access for free to the live show tonight. The live shows are for subscribers only, and I will see you guys there. Yes, Last Resort wouldn't be a bad one, too. So, all right, guys, I will see you then. Yeah, so we're all done. It's all in the jury's hands now, and I'm in court tomorrow, so hopefully they don't do anything for a while. See you guys. And, yeah, I mean, as of right now, just because even if he did it, Daniel Howard is not guilty. For now. Take care, everybody. Bye.